today in Spanish.
Yeah, okay, now I can.
Good morning. My name is Christopher Ronneberg. I'm a journalist with the Norwegian newspaper Aftenposten, and I'll be guiding you throughout this day 2 of a very interesting conference. The theme of today is facilitating secrecy, and we have 8 very, very interesting talks from 8 highly qualified individuals. Our first speaker is a representative of the government of Norway, and it will be very interesting to hear what Mr. Roger Skjerva, the State Secretary at the Ministry of Finance, has to tell us about this. From what I can tell from my paper, the talk is titled Norway's Positions, Interests and Values. So, Mr. Skjerva, please take the floor.
Thank you for a nice presentation, Ronneberg. Ladies and gentlemen, good morning. Nice to see you. What Ronneberg didn't tell you is that my job is to disappoint people. My job in the government is to say no till the other ministries, until the finance minister says yes. And my job is to step in and give his speeches when the prime minister or the parliament calls for him, and give his speeches. And you know, Finance Minister Johnson is the most popular finance minister in Norway ever. So, and I'm just me. So I am walking disappointment. But I can assure you that I'm just not stepping in. This is an issue that I'm very personally engaged in, and it is also a subject that is one of my main responsibilities in the ministry. So we are here because we want change. We want to stop tax revenues from being hidden from governments in developing countries, and we want to stop corruption, corrupting society. We want to stop international tax crimes for a more just and fair world. And we all here, I think, share this vision. And I would like to congratulate the organizers of this conference for delivering an impressive arrangement. And I very much appreciate the excellent initiative of the Publish What You Pay and the Norwegian School of Economics to organize this conference. The fight against international tax crimes is high on the agenda of this my government. And the extent of information sharing and transparency is now at a level that was unimaginable just a few years ago. The Nordic countries have taken the lead in this development, and we have this position because we have, through 1972 Nordic Convention, had 40 years of experience of close cooperation, working together against tax crime. We know how important this is, and we are bringing with us this knowledge when we work with the rest of the world. The change we have seen is partly caused by technological development. Monitoring cash flows got considerably more challenging the day money could be transferred by the click of a key instead of money in a bag. Against this, we see a change of culture. The Nordic countries have pushed a culture where secrecy is not okay, and it's a long way to go. But there are good reasons to be optimistic. So where are we now, and where are we heading? Today I will look deeper into some different fields. First, I'll start with the status of country-by-country reporting, a major breakthrough when it comes to financial reporting. I will then make a few remarks of the Financial Action Task Force, where we now have a leader from Norway. And I will also speak about the work of the OECD against harmful tax practices and the Global Forum on Transparency and Exchange of Information in Tax Matters. And at the end, some remarks of the professional secrecy of lawyers. So, I would like to start by stating some basic information about country-by-country reporting, CBCR. CBCR is a different concept from regular financial reporting, as it presents information for every country that a company or their controlled subsidiaries operates in, rather than in a single set of information at a global level. As of today, there are no regulations in Norway or in the EU which impose companies to report operational information on a country level. Nor are there any other requirements to enhance transparency of payments made to governments in countries where the companies conduct their business. As a consequence, it is today virtually impossible to deduce from the companies consolidated financial statements on how much of the company's total revenue and expenses that relate to their business in each country they operate. Reporting requirements showing what a company pays to host governments, like taxes, royalties, and bonuses, is likely to show a company's financial impact in host countries. And it is my opinion that such a transparent approach will encourage more sustainable businesses, as it highlights payments flow from developing countries. The challenges related to payment flows from developing countries have, among other aspects, been further described in the so-called Tax Havens report from 2009. The report was taken by the initiative of the Ministry of Development and headed by the Professor Schjelderup, which I think was one of the first speakers yesterday, sitting here. And this report points out CBCR as an important instrument to promote greater transparency in payment flows related to operations in developing countries rich in natural resources. The government followed up the report, first through a working group and then in the government's action plan against economic crime. The action plan calls for further work with implementing national CBCR requirements, either as a part of the work which is being done in the EU or independently. The Norwegian government is of the opinion that a set of international CBCR regulations would be the best solutions, but is at the same time of the opinion that absence of such international regulations should not prevent the Norwegian authorities from implementing CBCR requirements nationally. Last October, the European Commission presented a proposal for a new directive on the annual financial statements, which included CBCR requirements. The Commission's proposal is still under consideration by the Council and European Parliament, and the provisions on CBCR requirements are challenging to agree on. I have been informed that a plenary decision on the proposal is planned for January 2013. The Commission's proposal for CBCR regulation is imposed for large companies and all listed companies in extractive industries and the logging industry. Companies subject to CBCR regulation must on an annual basis report on payments made to governments in countries where such operations are conducted, including information on payments related to specific projects. The purpose of the CBCR regulation is to enhance transparency of payments to governments, which will be helpful in the combat against corruption and also in promoting good governance. The European Commission considers the proposal for CBCR regulation to be comparable with the CBCR regulation in the Cardin-Lugar Amendment contained in US Dodd-Frank Act. And the Cardin-Lugar Amendment has been hailed as one of the main anti-corruption measures in the US law in recent times. The Norwegian government welcomes and generally supports the European and American initiatives on introducing reporting requirements on a country-by-country basis. The proposal is in line with the Norwegian government's work related to increased transparency in international payment flows. And I also find the proposal to be in line with the government's efforts to enter into tax information agreements with so-called tax havens with the purpose to combat tax evasion. In the view of the Norwegian government, CBCR regulation will have the greatest impact, of course, if there is an international consensus on implementing such regulations. EU legislation will have a direct impact on the Norwegian legislation through the EEA agreement, and is therefore important for the Norwegian government that EU rules are as good and robust as possible. So the government sent the Commission's proposals, therefore, on a public consultation in December 2011, with a deadline for submitting comments within the end of January this year. In a sense, the bodies entitled to comment were positive to the introduction of CBCR, but divided in the views on the specific content of such provisions, and of course also when such provisions should, when such CBCR should come into place. In July this year, the government decided how Norway should continue with its effort to introduce CBCR and what positions Norway should pass over to the EU in the development of the CBCR regulations there. The government concluded, among other things, that it is important to have a good and robust EU legislation as possible, but at the same time one should not impose disproportional additional administrative burdens on companies. CBCR requirements should help visualize the extraction of natural resources, and it should be clarified that one purpose of the CBCR regulation should be to prevent tax evasion and to help identify tax revenues resulting from the extraction of natural resources. And we also concluded that an evaluation of the CBCR regulation should be held after 3 years and include an assessment on if the CBCR requirements should be extended to other sectors. And finally, it was decided that the Norwegian government would work to enact requirements for CBCR in the EEA areas as quickly as possible, and that Norway aims to enact rules from 1st January 2014, even if the entry into force should occur at a later point of time in the EU. The Norwegian position were passed to the Commission, Council, and various members of the European Parliament in July this year, and we are now awaiting the final CBCR regulations in the EU. We also have a process in the Norwegian Ministry of Finance, where the aim is to put into force Norwegian CBCR requirements by 1st January 2014, regardless of what happens in the EU. So, country-by-country reporting is an important step towards sustainable businesses. What I mean with sustainable businesses, I mean a business that is able to and open in how they pay rents to the owners, salaries to the workers, and tax to the society. Norway is prepared to take a lead position, and if we manage to get this into international regulations, it will be a leap in the fight against tax crimes. Now I would like to change the subject and direct your attention to the work of the Financial Action Task Force. I love the sound of that name. It sounds like something from Hollywood. But Financial Action Task Force, FATF, is utterly real and important. They are both pushing new standards, where Norway have been actively involved in the revision of the new and improved standards, and executing investigations and reporting to local authorities. So who are they? FATF is an intergovernmental body which was established by the G7 summit in 1989. And the objectives of FATF are to set standards and to promote the implementation of measures for combating money laundering and the financing of terrorism and proliferation of weapons of mass destruction. In April this year, the mandate of FATF was renewed by ministers and other representatives of member jurisdictions for another 8 years. The FATF currently comprises 34 jurisdictions and 2 regional organizations. This is the European Commission and the Gulf Cooperation Council. Approximately 150 additional jurisdictions have committed themselves to implement the FATF standards through memberships in various associated organizations, the so-called FCRSCB, Financial Action Task Force regional style bodies. Members of the FATF and the FSRBs also commit to undergo mutual evaluations. In July this year, Bjørn Skogstad Åmo, which is a special advisor in the Norwegian Ministry of Finance, undertook the presidency of the FATF for a 1-year period. He was vice president last year. And he's a man that has my greatest respect, because he's the only one that has served for a longer term as a state secretary in the Ministry of Finance in Norway than me. In February this year, FATF adopted 40 new and revised recommendations. And in my opinion, the new recommendations represent enhanced measures to fight secrecy, economic crimes in general, and tax crimes in particular. And let me mention the 2 new recommendations which we, from the Ministry of Finance, look upon as probably the most important ones. First and foremost, tax crimes are now included in the recommendations list of designated predicate offenses for money laundering. This means that member jurisdictions commit to criminalize money laundering from tax crimes. And furthermore, banks, financial institutions, and other subjects to the recommendations are obliged to report to their national FIU, Financial Investigation Unit, and when they suspect that their clients are laundering the proceeds of tax crimes. This enables the FIU to share important information with national enforcement authorities and with other FIUs in other countries. In Norway, there are also good mechanisms in place for the dissemination of information and analysis from the FIU to the tax authorities. The new recommendation do not provide for a definition of tax crimes, nor do they provide for any further clarifications as to exactly what types of tax offenses member jurisdictions are obliged to define as a predicate offense for money laundering. And this absence of stricter guidelines leaves room for a relative flexible approach as regards the implementation of the new standards in international law. And this flexibility is a challenge from a Norwegian point of view, but there's no doubt that the inclusion of tax crimes in itself constitutes an important step in the right direction. Norway, as a member of FATF, has initiated a mapping exercise for all FATF countries regarding tax crimes as a predicate offense. And hopefully the experiences from jurisdictions where the laundering of proceeds of tax crimes are already criminalized, like in Norway, can be of benefit to other jurisdictions. Secondly, when it comes to who is the real owners of business. Secrecy and lack of information about the ownership of legal persons and arrangements make such instruments vulnerable to the misuse of criminals. and the revised recommendation comprise enhanced requirements and measures to improve transparency of beneficial ownership and control of companies, trusts, and other legal persons and arrangements. Certain basic information is required to be registered in a public company registry, and information on shareholders and members must be maintained within the country of registration. The new recommendations also specify what steps financial institutions and other reporting entities are required to take in order to detect the ultimate beneficial owner of a client account. Furthermore, trustees and others operating on behalf of legal arrangements similar to trust shall be required to disclose their status to financial institutions and other reporting entities. Trustees and others with similar functions are to be required to obtain and hold adequate, accurate, and current beneficial information. Let me then turn to the OECD's work on harmful tax practices and on the Global Forum on Transparency and Exchange of Information for Tax Purposes. Working together in international arenas like the OECD is vital if we are to succeed. In the paper describing the purpose of this conference, you mention milestone achievements in transparency reform in the US and the EU, and the need for collaboration across borders in these matters. And transparency and access to information are indeed keywords when we discuss how to deal with financial secrecy, and in particular to combat tax evasion. These achievements are, however, not limited to the US and EU, but are now global. And this is a result of wide international collaboration, and Norway has played an active role. Let me address these developments with a few words. Norway chaired the OECD group that drafted the report Fiscal Degradation, that declared action against secrecy and harmful tax competition. The OECD 1998 Harmful Tax Competition Project to counteract these developments between member states also put the focus on the tax havens. Tax havens were told to accept transparency and effective exchange of information for tax purposes, including the lifting of bank secrecy, or to face defensive measures from other countries. After a rather reluctant start around 2000, a number of tax havens made commitments to accept tax information agreements which would lift bank secrecy in OECD countries, but developments to conclude tax information agreements were slow. In the beginning of 2009, the G20 declared the end of bank secrecy on a global scale. And the declaration didn't change the world overnight, but it was important. It led to the lifting of bank secrecy in OECD countries like Switzerland and Luxembourg towards their tax treaty partners, and general action against jurisdictions that offered hiding places for tax evaders. But on an initiative from the finance ministers in the Nordic countries, already in 2006, we started up the Nordic Tax Havens Project. And the project is to jointly negotiate tax information exchange agreements. And after the G20 initiative, we experienced a boost in the willingness to conclude tax information agreements. Today, such agreements, we have such agreements with 39 jurisdictions that have been signed, and negotiation to conclude with the remaining 5 on the OECD list of closed financial centers are now at a final stage. If we succeed, the Nordic countries will be the first to achieve a full network of tax information exchange agreements, and there will no longer be places where Norwegian tax evaders can safely hide money. The Global Forum on Transparency and Exchange of Information for Tax Purposes was established later in 2009, much as a consequence of the G20 statement. And the GF, the Global Forum on Transparency and Exchange of Information for Tax Purposes, or GF. And the GF standard is to provide information on request, including from banks and financial institutions, and on ownership of letterbox companies, trust, etc., and to oblige members to conclude tax information agreements. All GF members are subject to a thorough peer review process to ensure that the standard is observed. The GF consists of all OECD members and all financial centers, but has now 116 members and is steadily growing, in particular with developing countries joining in. Let me also mention the OECD and the Council of Europe multilateral agreement on administrative assistance in tax matters, which is now open to all countries. All the OECD members, all the G20 countries, and a number of financial centers have signed or declared to sign, and a number of developing countries have declared an interest to join. This multilateral agreement also includes possibility for automatic exchange and assistance in the recovery of taxes, and this may be the tool developing countries need to counteract illicit capital flows instead of having to seek resource-demanding tax information agreements. Illicit capital flows from developing countries can also take the form of disloyal or even fraudulent transfer pricing practices. So access to relevant market price information from G20 and OECD countries can be crucial to be able to counteract such practices, and can be achieved through the multilateral OECD and Council of Europe agreement. Tax information agreements are a strong and important tool, new tool. We see that these arrangements work and bring in considerable sums in evaded tax in the Nordic countries. But it has weaknesses. Information on request is resource demanding, but it's a start. And to many countries, it represents a fundamental change in policy. Automatic exchange of information should be the goal, and we strongly support it. And there are now some good news, because we are watching developments in the EU on the savings directive, and in the US on the FATCA arrangements that may promote automatic exchange as a common practice, as the Nordic countries have had in place actually since 1972. And as mentioned, the multilateral agreement may be the necessary tool. Just a few years ago, nobody believed bank secrecy would be lifted at all in some countries. So the transparency and access to bank information we have achieved is a result of hard work, patience, and effective collaboration across borders, and this we will continue. I have spoken of access to information, which is what transparency is all about. Another important subject related to the theme of this conference is lawyers' duty of confidentiality. Merete Smith, Secretary General of the Norwegian Bar Association, will go further into this topic later today, but I will use this opportunity to emphasize a few aspects of this subject. And of course, you must bear in mind that I will see it mainly from the Norwegian tax authorities' point of view. The Norwegian tax system is based on the obligation for the taxpayer to each year give all necessary information needed to determine correct tax. The tax authorities also obtain a lot of information from different third parties, such as, for example, banks. In addition to the taxpayers and third parties' duty to, on their own, give information to the tax authorities, the tax authorities may use their control provisions, which impose on taxpayers and third parties a duty to give further information on request. Lawyers' duty of confidentiality is very often referred to as a strong duty of confidentiality, and thereby has a stronger protection than other duties of confidentiality. In Norway, as in most countries, it is set down in the penal code that breaches of lawyers' duty of confidentiality is punishable. And in addition to the prohibition in the penal code, there are rules in both the criminal procedural code and the civil procedural code that prohibit the court to take evidence about something that falls under a lawyer's duty of confidentiality. However, in Norway, there is no legal provision that expresses directly the content of lawyers' duty of confidentiality. Also, Article 8 of the European Convention of Human Rights provides a general protection for correspondence with a lawyer, among others. However, this does not mean that no exception from the duty of confidentiality can be made. Intervention in the protection given in Article 8 is possible if it, for example, is valued as necessary in a democratic society in order to prevent crime. Such an intervention then must be established by law, and there must be proportionality between the burden of the intervention and the purpose of the intervention. An exception in lawyers' duty of confidentiality has, for example, been adopted in the Norwegian money laundering legislation, and when certain conditions are fulfilled, lawyers have a duty to report to the financial intelligence unit at the police. To be able to determine correct taxes, it is essential for the tax authorities to receive accurate information about transactions and money transfers, including information about to and from whom the transaction has gone. The need for information is the same if a lawyer has been involved in the transactions. Earlier, the tax authorities had few problems receiving this kind of information in Norway. Also, if the relevant information was to be found in correspondence with a lawyer. But this has now changed. The tax authorities' legal right to ask a taxpayer for information that is in his correspondence with a lawyer has in general been challenged. Because in December 2010, the Norwegian High Court came with a decision where it was determined that money transfers that take place as an integrated part of lawyers' natural practice is protected by the duty of confidentiality, including the name of the client. The decision has influenced the understanding of the tax authorities' right to ask for information existing in correspondence to or from the taxpayer's lawyer. Therefore, the legal situation now is that the tax authorities cannot require information from correspondence with a lawyer if the information falls under the duty of confidentiality. And this means, among other things, that the tax authorities do not have legal right to ask for information about money transfers that take place through a lawyer's client account. And this again implies that it is possible for a disloyal taxpayer to keep information on capital and income away from the tax authorities. If the tax authorities turn to the banks to get information from them about from who and to whom a money transfer has gone, this will not be in the bank's position. This because the money transfer has been done in the name of the lawyer. So the tax authorities are in a situation where they have no access to this kind of information. And this is not an acceptable legal situation. And I will not accept that all our effort to combat secrecy for the wealthy in tax havens will be undermined by lawyer offices in Oslo or in Bergen. Because it's difficult to see the reasoning why lawyers' duty of confidentiality should be used to protect access for the tax authorities to this kind of information. Lawyers' duty of confidentiality protecting access for authorities to relevant information is not only a problem in Norway. From the agenda you will be discussing this very important problem from, I see that you will be discussing this very important problem from different angles today, and I look forward to hear about the results of these discussions. But what does the government do about this problem in Norway? In the tax area, we need quick action. So the Ministry of Finance is now working with a proposal for changing the Tax Assessment Act. Our aim is to send out before Christmas a proposal that imposes on lawyers a duty to give information about money transfers through their client accounts this year. But as I mentioned, not only the tax authorities are experiencing problems connected to information not being available for them because of lawyers' duty of confidentiality. The decision from the High Court that I just referred to was related to the police and prosecuting authorities' right to receive information about transactions through a lawyer's client account in an ongoing criminal investigation. So the Ministry of Justice is working to appoint a legal committee that will work out a proposal for a new legal framework for lawyers and others offering legal assistance. This committee will, among other things, examine and give an account on the legal situation regarding lawyers' duty of confidentiality. The committee will also be given the task to propose new legislation related to lawyers' duty of confidentiality. In this regard, one important task will be to define which parts of a lawyer's task that should fall under the lawyer's legal practice, and then again be found by professional duty of confidentiality. Before I wrap up, I would also like to give a short mention of another important work being carried out by the OECD to achieve our goal to fight financial crime and its harmful effects on society. We of course have to work on different areas at the same time. And the task force on tax crimes and other crimes under the OECD Fiscal Committee are working with topics related to tax authorities' possibilities to discover other financial crime than tax crime, for example, money laundering and corruption. They cooperate with the FATF and the OECD Working Group on Corruption. For 2 years now, they have been working with a special project to promote a whole-of-government approach to tackling financial crimes and illicit flows. In 2011, Norway hosted the launching conference of this project called the Oslo Dialogue. It's a long time since Israel and Palestinian negotiations. This year at the Rome conference, a document describing effective interagency cooperation in fighting tax crime and other financial crimes, we launched the so-called Rome Report. And the report describes organizational models for agencies fighting tax crimes and other financial crime. Models for sharing information, models for enhanced cooperation, and also recommendations. One of these recommendations is that countries review their models for enhanced cooperation described in the report. Joining forces in the fight against financial crime and illicit capital flows is essential, and I look forward to follow the work set out in this project. And I hope this report will we inspire countries to analyze and develop new methods and systems of cooperation in the future. I'm getting to the end of my time here at the podium. As I said at the beginning, we share a vision of a more just world where tax crimes are effectively prevented and stopped. One of the major tasks ahead is country-by-country reporting. Norway is prepared to take the lead. CBCR can prevent tax evasion and identify tax revenues to prevent exploitation, or in other words, robbery of a country's wealth in natural resources. If we manage to get this into international regulations, it will be a leap in the fight against tax crimes. Our men and women in the field is the Financial Action Task Force, and in OECD and the Global Forum. It's hard work dealing with countries and interests, often with another point of departure than us, but the work has to be done. It's a dirty job, but someone has to do it. When it comes to lawyers and secrecy, we are now setting up a new legal framework because the current situation is not acceptable. Joining forces in the fight against financial crime is essential. International standards are necessary. It's a long and winding road, but we will get there. I would also mention that Publish What You Pay and other non-governmental organizations are playing a very important role, and they inspire, share knowledge, and is making the ground for new political actions. And so you are all needed in this fight. And together, we can make a change for the better. Thank you for your attention.
Our next presenter today is Jason Sharman, the director at the Centre of Governance and Public Policy at Griffith University in Brisbane, Australia. He has written extensively on tax havens, money laundering, and grand corruption. In his lecture today, he will address, among other things, I'm sure, the following questions. How effective are transparency rules governing shell companies? And if you want an untraceable shell company, as I'm sure many of you do, where's the best place to buy it? And how sensitive are those who sell shell companies to corruption risks? Interesting topics, interesting questions. Mr. Sharman, please take the stage.
Morning, everyone. I'd like to start off by thanking the organisers of the conference, the Norwegian School of Economics and Publish What You Pay Norway, for giving me the opportunity to speak here this morning. I'd like to begin with an anecdote. In June of 2011, two journalists from Reuters news agency, Kelly Carr and Brian Grow, reported on a modest suburban house in the town of Cheyenne in Wyoming in the United States. This house was, had floor-to-ceiling, wall-to-wall mailboxes, 2,000 in all. Each mailbox was the only physical instantiation of shell companies, 2,000, which were legally registered at this address. According to court documents, one of the shell companies registered in this town in Wyoming was Capital Investment Group belonging to the former Ukrainian Prime Minister, Pavlo Lazarenko, which Lazarenko used to conceal ownership of tens of millions of dollars of assets corruptly acquired during his prime ministership of the Ukraine. Lazarenko is now in jail in California serving an 8-year term, but it seems that he's still using shell companies incorporated in Wyoming to control millions of dollars of assets, which he will then probably enjoy once he leaves. Today I'm presenting the results of a co-authored study. It's myself, Dan Nielsen, and Mike Finley. And it's a field experiment we've conducted over the last 2.5 years in which we impersonated a rogues gallery of 21 fictitious characters and involved and made 7,400 solicitations for anonymous shell companies from firms in 182 countries. And this is for exactly the sort of untraceable or anonymous shell companies that I'll demonstrate are so useful for criminals and are explicitly banned by international standards. Now, just the sort of key terms for my talk today from this Lazarenko example, if you've got this company in Wyoming with the 2,000 letterboxes there, Wyoming Corporate Services, still in business today, I hasten to add, is a corporate service provider. That is a company whose business it is to set up and sell shell companies. You've got the shell company itself, Capital Investment Group, which, as I say, Lazarenko used to hold his assets. And then you've got Lazarenko, who's the beneficial owner, the real person in control. I'd like to start off with a few words about what are shell companies and why they are important. This is a shell company I set up in 2009 in the Seychelles. It has a bank account in Cyprus. I set it up from Australia using a corporate service provider in Singapore. I made a euro transfer into their Hong Kong account, set up the Seychelles bearer share company, which has a Cypriot bank account. It's cost 1,752 euros. Shell company is called a shell company because it doesn't engage in any substantive business, doesn't produce any good or service, it's just a legal person. But a legal person can be very valuable in terms of holding bank accounts or owning assets. Such shell companies can be set up online in dozens of jurisdictions in the matter of a few days or perhaps even a few hours for just a few $100s or at most a few thousand. The key issue with shell companies is if they can be traced back to the real person or the real people in control, the beneficial owner. If not, the shell company becomes a sort of corporate veil that screens, separates and conceals the financial affairs of that person, the beneficial owner, and this is why they can be so useful for criminals. A World Bank report on this issue, referred to, called the Puppet Masters, begins with an example. It says, imagine that you were engaged in corruption. You needed to make a large illicit transfer. What would you do? Well, conceivably, you could use cash, the original sort of untraceable medium. But cash is quite heavy. $1 million in US $100 bills weighs between 8 or 9 kilos. So really, you can only get about $3 million even in a pretty big suitcase. Okay? Cash is bulky, and you have to be, obviously, in the same room. You have to be able to hand it over. So it's not terribly convenient. You could make an interbank wire transfer, but then there's a risk that the bank will lodge a suspicious transaction report and that you'll be traced back pretty easily. So really the third option is, instead of having a bank account in your own name, either as the bribe giver or the bribe recipient, you could have the bank account being held by a shell company. And as long as the shell company can't be traced back to you, the beneficial owner, then you can probably make this illicit transfer with very little chance of ever being found out. To quote an excellent report on the issue done by Global Witness called Grave Secrecy, published earlier this year, shell companies are key to the outflow of corrupt money that keep poor countries poor. Those who loot state funds through corruption or deprive their states of revenue through tax evasion need more than a bank. They need to hide their identity behind a corporate front. Many other reports have come to the same conclusion about the centrality of shell companies, not just for tax evasion and corruption, but really for just about any form of profit-driven crime. So in short, if you're interested in the sorts of crimes and evils that we're talking about in this conference, you really must be interested in the issue of shell companies and the degree to which they're transparent or opaque, the degree to which they can be linked back to the beneficial owner. Now, precisely because shell companies are so useful for criminals if they can't be traced back, there are international standards mandating that you should be able to link a shell company with a beneficial owner. So we've mentioned the Financial Action Task Force already. Like the previous speaker, it does have a sort of Hollywood ring to it. You've got these very clear standards that says countries should take precautions to make sure that shell companies, that's legal persons, means companies, can't be used for money laundering. That authorities should be able to access and find out who the beneficial owner is, who the real living, breathing individual is behind this. But of course, the real question is not so much the existence of the rule, but its effectiveness. Does it work? It would be ridiculous to think that just because you pass a law against corruption, corruption is stopped by that law. But this presumption of effectiveness, of just saying, well, there's a law there, so I'm sure it's, in this case, a standard there, I'm sure it's effective, is pretty much what the international community has done with this rule, Recommendation 24, formerly 33. Despite how important the issue of shell companies are, their transparency, despite the importance of this question of whether this rule before you is effective, it really hasn't been investigated until now. The anecdotal evidence suggests that we have reason to worry. So going back to Wyoming Corporate Services, This is an excerpt from their website telling you all the great things you can do with a shell company, which really gets to the heart of the problem. You can see here, you know, a person who cannot be accountable for its actions. Imagine the possibilities, okay? And indeed, many criminals, not just Lazarenko, have done more than imagine the possibilities. They've actually exploited them in these varieties of crime. The study I've co-authored with Nielsen and Finley seeks to answer this question of effectiveness. We have a rule out there saying that shell companies should be able to be linked back to the person in control, the beneficial owner. Does it work? As noted, the basis of our project was to create 21 fictitious characters and approach 3,700 corporate service providers, like Wyoming Corporate Services, in 182 countries. Over a period of 2 years, we approached each of these corporate service providers twice, so we have 7,400 solicitations in general. The results provide by far the most detailed and scientifically rigorous evidence we have on the availability of untraceable shell companies, but also the sensitivity of corporate service providers to different kinds of customer risk profile. The aim of the study is to find out whether in practice anonymous shell companies are available, or whether corporate service providers are doing what they should do, namely, whether corporate service providers are insisting that clients provide notarized or certified copies of government-issued photo identification documents, such that if regulators or law enforcement subsequently have a question about that company, they can go to the corporate service provider that formed it and say, who owns this? Who's responsible? Apart from the overall level of compliance, we also tested how sensitive providers were by changing the content of our solicitation emails in ways I'll describe in a bit, so that we varied the level of the risk profile of the customer, not just the severity of the risk, but the different kinds of risk as well. And we also varied the amount of information that was contained in our approach emails to find out whether this made corporate service providers more or less willing to provide anonymous or untraceable shell companies. That is to say, whether it made corporate service providers more or less compliant with the FATF rule. Okay, well, I mentioned that it's an experiment, and I've got experiment in the title. Normally we associate experiments with maybe test tubes or microscopes or people wearing white coats, and of course this does not describe what we did. But we did replicate the essence of an experiment, okay? Experiments are particularly valuable because they are the single best way of finding out what causes what. They can isolate causal effects independent of all the other various factors that may mess up our ability to find out genuine causal relationships. So by way of analogy, let's look at the process of approving a new drug through a randomized controlled trial. Okay? If you're looking to have a new drug approved, there is one way and one way only you can do so. You have a pool of volunteers which you divide into two groups. You randomly assign them into one of two groups. One group, the treatment group, gets the drug in question. The second group, the control group, gets a placebo pill. Okay? The idea is, as long as the group is big enough and as long as the randomization has been done properly, any difference that you observe between the treatment group that got the drug and the control group that got the placebo afterwards can be wholly and solely ascribed to the effect of that drug, because the process of randomization washes out or neutralizes all the other factors that might affect people's health there. So at the end, you can find out if the drug has positive effects in fighting whatever disease you're interested in, or negative effects in terms of unwanted side effects. Now, of course, we're not working with drugs or placebo pills, but we are looking to replicate this logic. Instead of randomly assigning a placebo pill or a drug, we randomly assign different email groups. We start off with a placebo or low-risk email. I'll put that here and explain it in just a bit. Then we vary this basic email template to see what difference it makes in terms of corporate service providers' willingness to provide anonymous or untraceable shell companies. And because we're using random assignment in a very large group, any difference between the rate at which corporate service providers are willing to provide anonymous or untraceable shell companies can be wholly and solely ascribed to variations in the wordings of the emails that we put forward. Okay? So if you like, this placebo or control email forms a bench line against which we can measure the changes in the wording of the other emails, the treatment emails, that I'll go on to explain. Okay, let's have a look at the structure of this email. First off, we say we're a consultant. Okay? There's a lot of legitimate consultants out there, but also consultancy is commonly used as a sort of alibi for a sort of for many of the sort of illicit transfers that we're interested in too. So in 2004, a bribery scandal involving the Norwegian state oil company to Iran, the bribes were excused as being consultancy payments. So too in my own country, the Reserve Bank of Australia, our central bank, recently enmeshed in a foreign bribery scandal, again used consultancy payments as the excuse or the alibi by which bribes were passed to foreign recipients. Okay? So the consultancy is important. Okay? How about this country of Norway? Okay? This is in fact a compound country of 8 countries. We wanted to use 8 relatively minor, low corruption and low terrorism risk OECD countries. So this is Australia, New Zealand, Austria, Norway, Sweden, Denmark, and Finland. Okay? So for each email we use one of these 8 countries. For the name, we use the most common male name for each of these countries. We're writing this to these corporate service providers that we found, these 3,700 that we found through Google searches. We're asking them for a shell company. We say that we want a shell company for reasons to minimize tax liabilities, to provide limited legal liability, and for confidentiality. And from doing a lot of interviews with corporate service providers, these are sort of the most common reasons why people are interested in getting shell companies. These are all sent through Google Gmail accounts, just registered in the name of the person. They're registered to mobile phone numbers in Uganda. They were sent out through proxy servers in such a way that the emails appeared to be coming from the actual country of origin, i.e. Denmark, Finland, Norway, Australia, New Zealand, the Netherlands, Austria, whatever it is. Okay? The key question here is what documents? The key question posed to the corporate service provider is what identity documents, if any, do the corporate service providers require before they're going to supply a shell company to us? If they're following the rules set down by the Financial Action Task Force, they should ask for notarized or certified copies of government-issued photo identification documents. If, however, they're willing to provide us with a shell company without any documents, then that shell company becomes exactly the sort of anonymous or untraceable entity that is so useful for financial criminals, whether it's laundering money, engaging in fraud, giving or receiving bribes, evading taxes, or whatever it is. Okay? We also say communicating via email. It's pretty hard to impersonate people from 8 different countries via the phone or Skype. And of course, this gives us a written record as well of all the correspondence that passes between us and the corporate service providers. Okay, so this is the baseline. And as I say, the key question is, what identifying documents do you need from us? Okay? We also got some price information in there. For the non-English speaking ones, we put a couple of spelling mistakes in there to make it look a little more authentic too. Okay. Okay, so this is the baseline. This is sort of the control or placebo email that's analogous to the sugar pill or the control group in the drug. Now present a series of treatments. These are the sort of variations we introduced into subsequent emails. See what difference, if any, it made in terms of corporate service providers' willingness to give us an anonymous or untraceable shell company. Okay, and the changes, the email frames are basically the same in all of them except for the bolded text. I hasten to add it's bolded for the purposes of the presentation. It obviously wasn't bolded in the emails we sent out. Okay, this is pretty much the same structure. We've got another Norwegian, that's the same. They want a shell company, that's the same. They want it for tax liability and confidentiality reasons, that's also the same. The key question again is what identity documents do they require? The only thing that's different is we say, does it make any difference to firms' willingness or proclivity to follow international standards if you actually tell them what international standards are? If non-compliance is a product of ignorance, for example, perhaps if you tell people what the right thing is to do, they might actually do it more. Okay? We don't know. We thought this is maybe a hypothesis to be tested. Okay? So we mentioned the FATF, and we mentioned this idea of they have these standards of disclosure of identifying information. Then we go on and say, but we hope you don't ask us for them. Okay, so that's treatment number 1. Of our 3,400 corporate service providers, 3,700 corporate service providers, 1,700 were from the United States. And for the 1,700 ones in the United States, we decided to beef it up a little bit more. We not only said that there are rules set by the Financial Action Task Force out there, but we also said that the Internal Revenue Service, the US tax authority, actually enforces these. Now that's not actually true, but we were interested to see what difference, if any, this made to the proclivity of US service providers to ask for identity documents. And again, the rest of the email is the same. The Australians, the please communicate via email, the key question of what documents do you need, and so on. And again, we were trying to say, relative to our control email, relative to the placebo one I showed you at the front, what difference, if any, does this make? And because we're randomly assigning across a big group, we can be very confident that any difference between this treatment and the placebo email is caused by the variation in the wording that's bolded. Okay? Next one. Again, the same, except this time we said, well, let's create an incentive. We said we are willing to pay more if you don't ask for the documents that you should ask for. Okay? If you pay people to break the rules, does it make it more likely that people will actually break the rules? Or perhaps, is this sort of so suspicious and unsubtle that it may frighten off corporate service providers? Okay? If you get somebody who says, there's a rule out there, but I'm going to pay you to break it, perhaps corporate service providers are really risk averse. Okay? We're not sure what the net effect will be. This one's a bit different. Okay? Here we pose a corruption risk. And instead of our composite country, Australia, we've got our composite country, Guinea-stan. Okay. Now I mentioned that the Australian countries are perceived to have very low levels of corruption. Instead of 8 low corruption countries, Guinea-stan is 8 high corruption countries, or perceived to be high corruption. So we've got Guinea, Guinea-Bissau, Equatorial Guinea, Papua New Guinea, and then we've got Tajikistan, Turkmenistan, Kyrgyzstan, and Uzbekistan. Okay. For each email, we randomly draw one person, one identity from one of these 8 countries. Okay. And we're doing this to signal a high corruption risk. But we thought that may have been too subtle. So we did a second variation, you can see there again. We said that we are consultants, again, but this time we're in government procurement, which the OECD says is one of, if not the most corruption-prone area. Okay? So we're sending a really, really strong signal of corruption risk. Okay? Here you have someone who is in the bottom 1/5 of the Transparency International Corruption Perceptions Index from their country of origin, in a spectacularly corruption-prone area, government procurement, who's asking for an anonymous, untraceable shell company. Any corporate service provider with half a brain in their head and any sense of moral responsibility of scruples would recognise this as an outrageously obvious corruption risk. The question is, does it make any difference to corporate service providers' willingness to supply anonymous or untraceable shell companies? Could make them more willing, for all we know. Last one. Terrorism. Okay. Terrorism financing. Okay. Again, we varied this again. We changed the country of origin. Okay. This one, we have the people coming from either Lebanon, Pakistan, Palestine, or Yemen. They're again a consultant, but this time for a Muslim aid organisation and working in Saudi Arabia. Okay. Again, the rest of the structure of the email is the same in terms of tax, limited liability, confidentiality. The key question, what documents do you require, prefer to communicate via email. Each of these factors is listed by the Financial Action Task Force as posing a risk for terrorism. So again, just like the previous treatment poses an outrageously obvious corruption risk, so too this email poses an outrageously obvious terrorism financing risk. And again, the question is, what difference does it make, if any, in terms of corporate service providers' willingness to ask for documents in the way that international standards say they should? Okay, we sent out these emails, 7,400 of them. As I say, each corporate service provider got at least 2 emails, or 2 emails over a period of 2 years, and we mixed them up to make sure the corporate service providers didn't get the same email twice. We then have a vast, and we indeed still do have a vast database of all the emails responded, back and forth. And we had to code these responses. And really, we could get 1 of 5 results from these. First off, corporate service providers just might not reply at all. We might get no response. Okay. Those ones were a little bit actually hard to work out what was going on. On the one hand, maybe they were just disorganized, or we didn't think we were worth it in terms of the money. Or perhaps they were engaged in a form of soft screening. That is, they thought, these guys seem very sketchy, very dodgy, very suspicious, maybe we're just not going to reply to them. So the first of the 5 outcomes could have been no response. The second one could have been refusal, where they wrote back, we did get an email back, and they said, some of these things. Some of them were pretty short and sweet. Thank you, no thank you. Okay. Some of them were a bit arch. No problem, RS. You should concentrate on making an honest living. You seem like a bright guy. Okay. This is our fictitious Tajik here. This is our fictitious Australian here, Mark Brown. Okay. Some people were very offended. Some corporate service providers were very offended by our approach. They thought it was highly immoral, and they had responses like this from the refreshing directness that's characteristic of Australians. You can see this person says, "You will remain a complete impoverished idiot for the rest of your life and die poor and sad. I will be leaving you nothing in my will." Okay. So these ones are pretty easy to code, okay? They're refusals. There's nothing going there. There's three other kinds of responses we could get. Obviously, the happy one, or the one we would hope for, is corporate service providers would write back and say, yes, we will sell you a shell company on the condition that you provide notarized or certified identity documents to prove that you are really who you say you are, Mark Brown or Ruckman Solov, or whoever it might be. And these were coded as compliant. And again, I'll show you an example of this in a bit. Sort of next best one was partially compliant, where they'd ask for some ID documents. The corporate service provider would say, yes, we'll sell you a shell company, but only if you send us some ID documents. But they didn't really, it wasn't a requirement to have them notarized or certified. The worst outcome is when they wrote back and said, we'll sell you a shell company and no documents are required. Okay? And in that case, the shell company becomes anonymous or untraceable because you can trace the shell company only back to the corporate service provider, and the corporate service provider says, I don't know who I sold this to. Sometimes we got sort of an ambiguous response that said a no, but seemed to suggest a no could be changed to a yes. And some bad language, unfortunately, on this next one. This is our terrorism financing email from the fictitious Pakistani to a law firm in Florida. And the guy responding accurately picks up that we're a terrorism financing risk. Okay, no particular prize there because we made it pretty obvious, but anyway. And he initially says, in no uncertain terms, you could be a front for terrorism financing, but if you pay me $5,000 a month, I can do business with you. Okay, not only set up a shell company, but set up a bank account to go with it as well. So this is very, very worrying. Not only do corporate service providers realise we're posing a terrorism financing risk, but for not that amount of money, they say, well, we can help you out with this. Okay. This finishes off your previous message and this one, a meaningless crap. Get a clue. Just how stupid do you think we are? Okay. Well, I'll answer that actually in a couple of slides' time. Okay. Okay. Compliant. This is what should happen. These are the sorts of emails we should have got. This is from St Kitts and Nevis, a small country in the Caribbean, 2 islands. And again, this is our corruption treatment. This is our fictitious Tajik. And they say, yeah, we'll sell you a shell company, but we need certified or notarized copies of the following identity documents. The picture pages of your passport or driver's license, utility bills, and references. Okay? This is compliant. This is what the FATF says should happen. Okay. Unfortunately, we've got a lot more like these, non-compliant. Here's a 2 from the US. You can see it should only take you 10 minutes. We just need the name of your company. Or this one, all you need to do is provide the name of the company, that's it. We've got another sort of longer, slightly more sinister one as well that I haven't got on a slide, but I'll read out an excerpt from. This corporate service provider replies and says, the anonymous structure we offer is totally secure since we manage the bank account on behalf of the owner. The owner's name appears nowhere. Using this structure, no investigator could determine the true ownership of the structure. We offer additional security by the fact that we could change the nature of this structure and relocate it to other jurisdictions literally within minutes if required. Having said that, we should make it clear that we will not engage in any illegal practices on behalf of clients. However, what is illegal in one country may not be illegal in another. Okay. So we did get some pretty scary responses like this. Okay. One more sort of non-compliant one. This guy's worried about terrorism financing, particularly worried about it going to Nevada when it could be going to Delaware, okay, where this person works. So again, here we have our outrageously obvious terrorism financing risk, and the person says, no problem, $235, please, for a corporate, and just MasterCard, Visa, or American Express. We don't need any identifying documents at all, okay? So again, this is from a helpful person in Delaware, more than willing to supply an anonymous shell company to an obvious terrorism financing risk. Okay, in terms of general patterns, what do we find? First off, pretty poor overall compliance. Of all the replies we received, 48% failed to ask for the proper identity documents. That is, 48% failed to ask for certified or notarized identity documents. 22% of the replies we received overall failed to ask for any identity documents at all. That is to say, 22% of the replies we received were more than willing to provide anonymous or untraceable shell companies that are explicitly banned by international standards and incredibly useful if you're engaged in financial crime. Okay? Conventional wisdom is that developing countries are often unable to apply international standards, that offshore centres or tax havens are unwilling to apply international standards, and that rich OECD countries are both willing and able to apply international standards. At least when it comes to the regulation of shell companies, this is dead wrong on each count. Okay? This graph here measures the level of compliance in terms of what we call a dodgy shopping count. Okay? The dodgy shopping count simply says, if you want an anonymous shell company, how many corporate service providers do you have to approach before, on average, you'll find one who'll sell an anonymous shell company to you? So if you've got a 5% non-compliance rate, that means you've got a dodgy shopping count of 20. The higher the dodgy shopping count, the more difficult it is to get an anonymous shell company. And of course, conversely, the lower the dodgy shopping count, the smaller the number of corporate service providers you're going to have to approach before you can get an anonymous shell company, and the less well international standards are working. This is the international sample over here, and I'm not sure to what extent it's clear, but these are tax havens, OECD, developing nations. Tax havens have by far the best performance, okay, in terms of actually asking for identity documents there. So the dodgy shopping count, you have to approach about 25 corporate service providers in tax haven jurisdictions before you find one who says, sure, we'll sell you a shell company, we don't need any identity documents at all. That's a surprise. Okay? That runs directly contrary to the conventional wisdom on the subject and most of the communiques of the G20, the OECD, the FATF, and so on. You can see that developing countries do okay, not as well as tax havens, but better than the OECD. Okay? Worst of all, you can see that the OECD countries, okay, have a dodgy shopping count of about 8. Okay? So if you're approaching corporate service providers in the OECD countries, you've got about a 1 in 8 chance, or on average it's going to take you 8 approaches before you find one. This is the United States on the other side, and you can see this really sort of stubby line here, which is pretty bad news, is US incorporation services. Okay? The other one is law firms, who mainly just didn't reply to our solicitations. You can see of all of the US corporate service providers we approached, that is excluding the law firms, 41% were willing to provide an anonymous shell company to us. Okay? So the United States is one of the worst countries in the world in actually upholding international standards when it comes to shell companies. Okay? So really, you're only going to need to approach 2 and a bit corporate service providers in the United States before you find one who's similar to the quotes I reproduced earlier, is willing to sell you an anonymous or untraceable shell company. Okay, well, how about the difference that the treatments made? I showed you the various things in terms of the FATF treatment, the IRS treatment for the US portion of the sample, the premium where we offered to pay more, corruption treatment from Guinea-Stan, and the terrorism treatment of the jurisdictions or the countries that are perceived to have a high risk in terms of terrorism financing. Okay, again, the longer the bar, the better the news. The longer the bar, the higher the dodgy shopping count, the harder it is to get an anonymous shell company, and obviously the converse as well. And again, we've got the international sample here and the US here. Okay? Corporate service providers do pay attention to the content of our emails, at least for some of them. Okay? The little asterisks here under terrorism at the top, there are 3 for the US, 2 over here, indicate that to a statistically significant degree, it's much harder to get an anonymous shell company if you do pose an obvious terrorism financing risk. Okay? You've got about a 5% chance or a dodgy shopping count of 20 if you're not only a terrorism financing person, but stupid enough to put it in an email with obvious risk factors. It's going to take you about 20 approaches before you get someone who's, like our friend from Delaware, who will be willing to sell you an anonymous shell company. So there is some risk sensitivity or risk responsiveness among corporate service providers. And again, because of the large group and because of the randomization, we can be pretty confident this is a real effect that's driven by the changes in the wording and the risk factors that we signaled, namely the country of origin and the industry. For the US sample, you can see perhaps that there's a couple of asterisks next to the IRS as well. Okay. For US corporate service providers, one way of making them sit up and take notice is saying IRS. Okay? That seems to, if not strike fear into their hearts, make them a little bit more compliant, or in fact statistically significantly more compliant. Even though this is not actually true, the IRS doesn't enforce these standards. Okay, so again, you can see this makes some difference. For the rest of the treatments, though, the 3 under the US pool and the premium premium corruption and the FATF treatment for the international sample, it's mainly a story about dogs that didn't bark. That is, things that didn't happen. One of the most concerning findings of our study is that even when we signal an outrageously obvious corruption risk, this makes absolutely no difference in terms of corporate service providers' willingness to enforce the rules regarding corporate transparency. Okay? So there's absolutely no sensitivity to corruption risk amongst corporate service providers. Given that anonymous shell companies are probably the single most useful mechanism by which bribes are given and received, large bribes, then this is a really worrying finding. Okay? In fact, you know, not statistically significant, but it's actually slightly easier to get a company if you're a high corruption risk rather than if you're a low corruption risk. Okay? Telling people about the rules makes them no more likely to follow the rules. Okay? So when we said, by the way, the FATF has the standard that you should be asking me for ID, people didn't really care about that. Didn't make any difference. Okay? So you can sort of see here it's not a very reassuring picture. There is some sensitivity in the system towards terrorism risk. The IRS makes US providers sit up and take notice, but otherwise not a very encouraging picture. I want to finish up with a few points. Okay? First off, that unless we fix the problem of shell companies, we're very unlikely to make progress in fighting large-scale corruption, kleptocracy, but also a wide range of other financial crimes that are at the heart of this conference. The rules we have are actually quite good. Okay? This is not a problem of we don't have the right rules in place. What we do have is a major problem of enforcement or implementation or effectiveness. The rules are in place, they're just not being enforced. In practice, as we've demonstrated, it's very easy for even obvious corruption risk to obtain precisely the sort of untraceable shell company that are explicitly banned by international standards and are very useful for financial crime. The largest vulnerabilities are not amongst developing countries and even less amongst tax havens. The large rich states of the OECD, especially the United States, pose the largest risk when it comes to the provision of anonymous shell companies. The solution is neither very technically difficult, nor is it very expensive. It's a relatively easy matter of licensing corporate service providers in a way that's currently not done in many OECD countries, and auditing them to make sure that they do in fact employ know your customer regulations. What is lacking is not so much technical knowledge or financial resources, but political will amongst the countries of the OECD. We hope that in a small way our study will do something to change this. Thanks very much.
That was entertaining and very scary at the same time. And now we all know how to get rich quickly. Our next speaker today is Alison Christians. She is the H. Ewart Steichman Chair, is that correct? in tax law at McGill University of Law, where she teaches and writes on topics of national and international tax law and policy. So that means we'll have another aspect of this big topic of the day, and more about the legal issues. The presentation is called Legal Circumventions, When Does the Form Have to Give Way to the Substance in Tax Matter? So, Ms. Christians, please.
Well, first of all, thank you. I'm very pleased to be here and to be addressing this crowd. And you're a tough act to follow, because I think you just to really show just really how compelling the evasion picture is. And so actually I'm very happy that I come after you, because we can start from this premise that we've already seen tax evasion as a major compliance issue and tax havens as impediments to effective taxation, right? With a combination of low tax and secrecy, and the US being an obvious leader, unfortunately, in this field. And what I want to do is switch the focus just a little bit and think about how legal structures currently in place contribute to the problem, even when we take compliance off the table. In other words, I want to say, how do we use legal forms to achieve the same ends, that is money just disappearing, without violating the rules in play? To put it one more way, how do we disappear money perfectly legally? And one of the reasons I'm animated by this question is that the more stories we have about multinational corporations dodging tax all over the world, the answer is always the same. We are fully compliant. We are fully compliant. And so I think when you have a world of full compliance, what are we after with Publish What You Pay? What are we after with country-by-country reporting? And I think if we start to look at the legal structures that get us to full compliance and no taxation, we'll get even a bigger picture that includes this tax evasion issue, but also includes non-evasion as a major problem that we also have to solve. Okay. So as I go through this, I'll give you a series of slides with an example. And what I'm going to suggest is that, I was given the topic of form versus substance, and what I'm going to suggest is perhaps provocative, is that the form is the substance, and the substance is in the form, because it's all a question of legal structure. It's all a question of legal forms that we respect. And out of history, or path dependence, or our ideas about what can the state do, or what does the state do, or what can people do, what is a corporation, that we get to a place we didn't necessarily expect. Okay. And one of the things I think that it's worth reminding ourselves is that when we practice the same thing every day, it becomes normal. And we forget that what we're doing is highly abnormal. And it's worth taking another look to see how did we get to this very strange place where we are through a series of things that have now become normalized to us. Okay, so that's a theme also. All right, so I'm going to start with a very simple example with Google. Now, Google is fully compliant with a worldwide tax rate of about 2.4%. Fully compliant. And if any of you were paying attention to the PAC, the Public Accounts Commission in the UK, Google was on the hot seat along with Starbucks, Amazon, trying to explain away these odd structures. And so what I'm going to say right here is this. We're going to go through the Google structure. I'm going to eliminate a lot of nonsense, right? That I'm going to oversimplify the structure just to make a very basic point, okay? And to keep in mind, this is just one structure, and you name what you want to do, and there's another structure to get you there, okay? So this is just one example. And I'm a tax academic, so what I do is try to break something down to the most simple element to focus on the one thing that I want to focus on, which is to say that I'm going to eliminate necessary pieces of this structure. And I'm also going to make some assumptions that I can't prove because I'm not in-house at Google doing their tax planning, okay? So there can be mistakes. There can be assumptions that aren't correct. And what I will say is that it actually doesn't matter. right? That is, even if we get some of the details a little fuzzy, or we have to revisit some of the pieces of it, it still is going to show, I think, this very basic question about legal form and substance. All right, so we'll use Google. We'll start with Google. And the question is how to make income disappear without breaking any laws. Okay, so we start with Google. Google Inc. is a US company incorporated, of course, in Delaware. Although, as you may know, it's working in California. So there's already a little oddity going on there. But we'll leave that aside. US company, incorporated in the US. And we'll start from a presumption. If Google sold what it sells, which is 90% advertising, if it sold what it sold on a worldwide basis, all of its income would be taxed in the US currently at a top rate of 35%, right? Just make that assumption. But Google doesn't do that, right? It needs to make income disappear, so it goes, quote, offshore. All right, so step one, to make income disappear, you need to incorporate a subsidiary offshore. We'll call this GIH, Google Ireland Holdings. We'll call it GIH. We'll incorporate it in Ireland. Why are we going to Ireland? Because Ireland is friendly to IP. That's all. We could choose any number of jurisdictions. We'll choose Ireland. Ireland's friendly. What's the form here? Well, you set up a legal person. And both countries respect that. That's normal. It's normal to say that Google Ireland Holdings is a separate person from Google US. And that Google Ireland Holdings has a capacity to think and to negotiate and to act separate from Google US. It's normal to think this way because we believe that incorporation is substance. There is substance to it. Okay, so the form here is we file a paper in Ireland to make a company. You showed us how easy that is. And what we know is that Google Ireland Holdings will hire some people, and it's going to be the management of EMEA, right? Europe, Middle East, and Africa for Google. Okay. So the form is operating in Ireland. GIH is separate. GIH can negotiate. It has a mind of its own. It's independent. And in general, if we stopped right here, active income earned by Google Ireland Holdings is not normally taxed in the US. That is, if Google Ireland Holdings goes out and produces products or sells and has income from business, the US normally will not tax that right away. It won't tax it until GIH pays a dividend to Google US or Google US sells its shares, in which case we trigger some US tax, okay, normally. But if GIH has what we call passive income, royalties, rents, interest, that in some cases would be taxed by the US currently. Okay, just some complicated rules we don't need to go into. So what happens between these two companies? Well, we are going to transfer valuable intangibles to Google Ireland Holdings by means of something called a cost-sharing agreement. Now, you don't have to know everything about a cost-sharing agreement. All you have to believe here is that Google Ireland Holdings is a partner to develop an intangible that it's going to contribute. And together, Google Inc. US and Google Ireland Holdings, together, working together, will share the costs of producing whatever it is they produce. And that each is an independent actor in that contract, and that each has negotiated that contract. And the means of our checking on their negotiation, of course, you know, is arm's length transfer pricing, right? We'll take an arm's length transfer pricing, we'll say, did they act at arm's length? And if not, we may have to adjust it. But the form is a legal contract transferring rights from Google US to GIH, a legal contract, that's the form. And what's the substance? Well, it's hard to say, because Google Ireland Holdings is a holdings company. So it's not necessarily doing anything that you and I can watch. We don't, what do holding companies do? We don't really know. So it turns out that we're going to have most of our directors' meetings and management and so on in Bermuda. And now we come to a funny place. Once the mind and management is in Bermuda, it's no longer in Ireland. Now, it has been suggested by some looking at this structure that Ireland no longer sees this as an Irish company once the mine and management is offshore. I'm not an expert on Irish tax law, but I looked at the Irish Tax Authority's website, and they seem to suggest that they're an incorporation model, formalistic, like the US. You are where you are incorporated. You are where your piece of paper says you are. Unlike some other countries, which say you are where your mine and management are. Okay, so it's a little unclear to me whether it's really true that this disappears for Ireland's purposes. This is the position that some academics in looking at this structure have taken. And for our purposes, we'll take that position too. It sort of doesn't matter too much at the end of the day, as long as it's not US. But we'll just take this position that once we've moved this mine and management to Bermuda, it's now a Bermuda company from the US perspective. And from Ireland's perspective. Sorry, it's a Bermuda company from Ireland's perspective, but from the US perspective, it's still an Irish company because it's incorporated in Ireland. Okay, so far so good. So that's step 3. Step 4, let's incorporate another cell. Let's put this one in the Netherlands. Well, why are we putting it in Netherlands? Well, this is our finance tax haven, or tax jurisdiction. And lawyers and consultants and so on. And the Netherlands is going to like Google's presence and encourage Google's presence. And in fact, if you look at the PAC, the Public Accounts Commission inquiry, you'll find out that Google Netherlands, Google BV in the Netherlands, has a confidential agreement with the government, which the government of Netherlands has told Google not to divulge. The government of the Netherlands has told them. I don't know of any confidentiality law that protects an agreement between the government of the Netherlands and Google BV in the Netherlands. And the vice president of European operations wasn't sure either. He had to go back and check. He would let the PAC know whether that was really confidential, or what could he tell you. What we're going to do here in the Netherlands is we're going to license the IP that we got through our cost-sharing agreement. We're going to license that into the Netherlands, right? And that's going to create an obligation for royalties to be paid up, right? Once we license, we get royalties. Okay, so what's the form? Again, it's another contract that transfers rights and obligations among two parties who are respected because they are corporate entities, right? Okay. So form is incorporation, the form is a contract, and the substance is not sure we can necessarily say at this stage. Okay. Now, incorporate another sub, final, this is the last piece in our puzzle. I know it's getting complicated, but Google, we're back in Ireland again. Now we're back in Ireland again. Why? Well, this is where the jobs are going to be in Google Ireland Limited. This is the sales guys who are going to go all around Europe, Middle East, and Africa and sell Google advertising to customers. This is the actual active business going on. And why is it in Ireland? Well, it's a good place for this kind of thing. Again, we have it's an attractive, what we call non-harmful tax competition, right? A low tax rate. That it's on wages and on the corporate income, and I mean, there's no kind of evasion going on here. It's real. There's substance here. It's the people on the ground, on the phone, who are selling this product. All right. So, but for them to do that, we obviously have to sub-license again, and that creates again a royalty stream going up. Okay. And again, to give people the rights so that they can sell the thing that they're obligated to. So again, what's the form? We have contracts again, allocating rights and obligations. We have corporations treated as entities, treated as persons, and given rights. And the substance is that, in fact, now we have these people that are doing this job. But it's not to say there aren't people in the Netherlands or people in Bermuda or elsewhere. There are people at each of those levels. That's precisely why each of the governments wants to encourage the incorporation of each of these entities, because there are jobs being traded here around the globe. Okay, so the last piece of this structure that you need to understand is that these two at the bottom are not, it's a little unclear what should the form really be, And so in the US, you just can check the box to treat them as if they don't exist at all, right? Treat them as a disregarded entity. Now, let's just think about that, because this is a very interesting place where form and substance flip on their heads in an unexpected way. Because the form is two corporations completely owned above in the chain and contracts between them, and the substance is nothing. And so in this case, you would say the US rule, the US allows you to check the box, treat them as disregarded, is actually getting at the substance of the transaction here, is actually getting at the substance in that it's ignoring intercompany transfers that totally net each other out. So there's nothing wrong, really, on paper, with the check the box rules as applied here. It's doing the right thing. It's ignoring form to concentrate on the substance, which is that everything's controlled above in Google Ireland Holdings. Okay. So we have a number of form and substance elements here. And I would say each one of them is contestable. But let's just look at what we've accomplished before we start testing what in the world is going on here. What happens on paper? Well, what happens on paper in this structure is that Google Ireland Limited has that sales force. Now, 2,000 people working in Ireland who would not be there necessarily, right, if Google was selling directly from Silicon Valley. So 2,000 or so people selling products, services to customers. In Google's case, advertising. They pay the royalties up. The royalties comes in, the royalties go out. The royalties go in, the CSA fees, the cost sharing agreement fees go out. And the CSA fees show up here. Okay, that's what happens on paper. Now let's take this and disaggregate it a little bit. Okay, let's start with the US. Well, what does the US see as happening here? Well, the US doesn't see those two at all, right? That's the substance of it, that there's nothing going on. It's intercompany arrangements that should be disregarded. So the royalties and licenses are ignored. And what you have is a Bermuda branch of an Ireland company from the US perspective, in one view. The thing is, since everything is attributed to Google Ireland Holdings, all of that passive income underneath it disappears. And it's the active sales income that happened in Ireland that is attributed to Google Ireland Holdings by the US. Which means that that income, as I said before, won't be taxed in the US unless Google Ireland Holdings pays a dividend up to its shareholder, Google US, or Google US sells its shares in GIH. Okay. So the business income, now active business income, not passive income, it sits in Bermuda and it waits for a present from the US Congress. And the present is repatriation holiday. Okay? We'll come back to that in a minute. But in the meantime, if you need to pay dividends, you can pull a little bit of this income up and out of Ireland. It will have a foreign tax credit attached to it, and you can maybe mix it with some of your other income from other similar transactions across your multinational structure, and get a tax-efficient cash flow up through Google US and out to its shareholders who are demanding. Okay, and the final thing that the US sees is these CSA fees, which are subject to a transfer pricing, an advanced pricing agreement, which of course we don't have any access to. I don't know what the price is. I don't know what has been agreed to. Okay, so you might see the US as a bit of a shapeshifter here. Now you see it, now you don't kind of thing. Well, there were two companies here, but we don't see them anymore. But it's not a question of which one is right, form or substance. Right? We can't answer that question. But nevertheless, what we have is that the income has disappeared from the US. All right, well, what about Ireland? What does Ireland see? Well, Ireland doesn't really see anything above the Netherlands if we're right that the mine and management of Google Ireland's holding offshore makes it disappear from Ireland. So if that's true, and it's possible that it is true, then Ireland doesn't care about anything above the Netherlands. The only taxpayers that are relevant to Ireland are the one that's operating in Ireland and the one to whom withholdable royalty payments are going to be paid. And so what we have from Ireland's perspective is business income, but it's reduced possibly to zero, I doubt it's to zero, by royalties paid up. And so Ireland taxes the spread between the business income and the royalty payments. Again, simplifying it, just additional contracts and obligations. Okay. And there's no withholding tax, I believe, on the, it's been said, on the royalties to the Netherlands because EU, right? So a small spread to Ireland, that's what Ireland sees. Ireland is doing what I would call a classic jobs for taxes trade-off. Okay, we'll give you kind of your tax status, but you'll employ 2,000 people in Ireland that otherwise wouldn't be employed here. It's a good deal for taxpayers. It's a good deal for us as an investment in our job market. Okay, so what does the Netherlands see? Well, the Netherlands sees Bermuda again because now we have another person to whom payments will go. Netherlands sees royalty income coming from Ireland into the BV and royalty going up and out of this structure, and it can theoretically tax the spread. Now, this is where that agreement with the Dutch tax authority exists. It plays right here on that tax on the spread, and we don't know what that tax on the spread is. I don't know, right? They won't tell us. But that's the right we've held in the Netherlands, the tax on the spread. And the Netherlands does not tax royalty to Bermuda. I'm not sure why, but that's the choice of that jurisdiction to withhold tax or not as an income item leaves its shore. So we see here what the Netherlands sees is a trade-off. Jobs not for salesmen, not for 2,000 salesmen selling advertising, but for maybe 5 or 6 lawyers. Sorry, lawyers. But planners, consultants, accountants, right? Not sales guys. But it's, again, it's a trade-off. Jobs for those taxes that we're giving up to get Google here and to keep this sector alive in the Netherlands. All right, finally, our last player in the structure is Bermuda. What does Bermuda see? Well, Bermuda sees the US again, but Google Ireland is irrelevant to it because there's no connection there. Google US reappears in the structure in the sense that Bermuda could, ostensibly, impose source-based withholding on dividends, fees, royalties, etc., paid out from Google Ireland holdings to the US, but it's complicated by the fact that the US doesn't see Bermuda as a company, it sees it as a branch of an Irish company. So that's a little bit strange, to say the least, right? But normal. Don't think it's not normal. All right, so it's a bit of an oddity, but anyway, not likely to be any withholding tax even if we could figure out who the right country is for that corporation. So what Bermuda sees is royalty income received and CSA fees paid. And again, in the theory, there could be a tax on the spread. I suspect there's no tax on the spread. Otherwise, why would you be there? But that's the suspicion. The issue here is jurisdictionally, Bermuda has the right to tax that spread if they choose, just the way that Ireland did and Netherlands did below them. And Bermuda could tax payments to the US, but likely probably does not. And now the trade-off is not necessarily for jobs, although there are some jobs in the finance sector, but it's capital flowing through Bermuda, so it's the classic capital for taxes trade-off. Get that finance sector in charge. So what's the big picture? If you put all these things together, what do we see? Well, this is how the US sees this structure. This is how Ireland sees it. This is how the Netherlands sees it. And that is how Bermuda sees it. How is this possible? That these 4 countries see this structure in completely different ways and respond to it in completely different ways. There's a shapeshifter, jobs for taxes, jobs for finance for lawyers, and the jobs for capital, all working together through forms, legal forms, and substance that is malleable. And what we get is a fragmented world. But the worldwide result is a fully compliant taxpayer. I am not talking about tax evasion. I am saying in a fully compliant taxpayer scenario, not even with the CSA. I mean, that's a transfer pricing issue that's been worked out in advance through an advanced pricing agreement. So we don't even have any grounds to complain anywhere along the chain, really. Nominal tax to Ireland, nominal tax to the Netherlands, nominal tax to Bermuda, a growing pile of cash in Bermuda, and nominal tax to the US. Perfectly legal, fully compliant. That is how Google can say with a straight face to the Public Accounts Commission or to the press when they ask, yes, we pay a 2.4% tax rate on a global basis, and nobody's got that low of a rate. That's true, but we are fully compliant. And what's more, Google is a job creator. You will see those two put together all the time. It resonates, right? Don't crucify us. We are fully compliant with the laws. You want someone to be mad at? Maybe you should be looking at the lawmaker. It's not our fault. We're compliant. And if we paid more tax than we owed, our shareholders would have a lawsuit against us. So don't be mad at us. We are compliant with the laws and the regulations that have been handed to us. That have been handed to us with our own help in lobbying for them. But yes, okay, but nevertheless, law. It's law, rule of law. All right. Now, I'm going to come back to this form and substance, but I just want to get a sense of how big is this problem. Is this a small problem that I'm talking about? Is this, does this pale in comparison to tax evasion, for example? Illegal offshore tax crime. Well, in the U.S., from the U.S. perspective, we have an estimate of about $600 billion in offshore earnings, $97 billion on offshore taxes paid, which results in about a 16.4% average effective tax rate, with obviously some outliers, 2% for Google and so on. But the worldwide rates of US-based multinational companies seem just absurdly low. Something's not adding up. It doesn't add up. So Google, 2.4% worldwide tax rate, cash offshore currently 29 billion. Microsoft, 4.7 is estimated 4% worldwide tax rate, cash offshore 57 billion. Apple, less than 2%. Estimated, we don't know, right? These are all estimates. Worldwide tax rate. Cash offshore, that one is a little bit more known, 82 billion. GE tax rate, something like 7. Cash offshore, 102 billion. Pfizer, tax rate unknown, cash offshore, 63 billion. So you might say, okay, but you're talking about form and substance. Maybe it's not really money offshore. Maybe it's not real like that. Maybe it's just a paper trail and somehow. But I told you about a holiday before. Well, the last one the U.S. had, 2005, brought back 312 billion tax-free out of the structure that had been created and arranged. This is real money, in other words. It's real money. And it's real money that's escaping tax, not out of evasion, not by setting up secret bank accounts, not by colluding with local incorporation groups or law firms. It's a different kind of collusion. It's a rule of law collusion, isn't it, really? It's legal, dare I say it, legal evasion, which we are all contributing to. It's rule of law. Okay. Current estimate of U.S. cash reserves offshore, 1.4 trillion. 35% if you tax it right now would be 490 million, which I don't know. We're just writing numbers down that are meaningless at this point. But if you really could get that, you have a Tax Justice Network figures showing that aggregated globally money hidden in offshore accounts is currently 21 to 32 trillion. So this is the U.S. That's cash reserve, just cash reserves offshore, not tax evasion, not money laundering, not the TJN hidden figure. We're talking about just cash that just ended up trapped in Bermuda. Because if you bring it back, you'll have to pay taxes, waiting for a tax holiday to come back. Okay, so we're not hiding money, is what I'm saying. And the question is, how much is not hiding money? This is just the cash reserves for the U.S. How much is flowing through that structure? I don't know that anyone has done that analysis. I have not seen that analysis. Maybe someone's working it. I don't know. But what I do see is that we're looking at tax evasion a lot, rightfully. This is not to minimize tax evasion. We're rightfully looking to enforce the rule of law as written. But there is, in enforcing the rule of law is written, another pile missing, right? Another pile of cash missing. Maybe there's no way to measure it. Now I'm going to come back to this question about form over substance. Why does this happen? Why does it happen that 4 countries see the same structure 4 completely different ways to the final result of nominal tax being paid everywhere, money just disappearing in full compliance scenario? Well, I'll submit to you that that's because we do a bunch of things that seem normal because we've always done them. One is that we use documents to identify property ownership, you know, the contract. Just write down what you want to allocate risk, to allocate benefit, to allocate obligation, and most importantly, to allocate ownership. It's just a document, and we all respect it. Do we really want to say we're not going to do that anymore? How comfortable are we when we start thinking, okay, we're not going to respect the contract? It's not realistic. The second is that we accept the corporation as a separate taxpayer. We've always done that. The legal fiction. We call it a legal fiction. We know it's a fiction. It's normal. Are we really prepared to say we're no longer going to accept the corporation as a separate taxpayer? That, I think, is an easy place to be. We treat each corporation as if it had a mind of its own. Are we really prepared to change our assumptions on that front? We treat each corporation as if it can negotiate with other corporations that it controls or that control it. Now, interestingly enough, this is the place where we do see some movement. That's transfer pricing, right? That's where transfer pricing locates itself in terms of the legal regime. It's in here, in deciding how much we're going to treat corporations as if they could negotiate with others that control it or that it controls. That is the arm's length question, right? That is, in other words, that's the question, or that's the base assumption, the legal fiction that's being tested with arm's length transfer pricing or with any kind of transfer pricing regime, right? So we see something we've always done and always sort of implicitly believe being pressured, some stress from without, as things go horribly awry, right? We've lost control of arm's length. Nobody knows who's pricing what to anything. It's all just nonsense. It's all made up. But the alternative is, what I'm telling you is, the foundation upon which it rests is also fundamentally made up. And we're not prepared to disassemble that foundation. Right? But we are prepared to test it in some instances, and you see transfer pricing located here. We are prepared to, we're accustomed to treating each corporation as if it could bear risk independent of others that it controls or that control it. This is, you know, you'll see this play out a little bit in different rules for interest, capitalization, some other places in the tax code. Being pressured a little bit, but in general, we accept this. This is normal. It's always been this way. Are we really prepared to say that we're going to change the standard for risk bearing? Finally, we treat products and services as if they can be produced or provided in distinct and independent components along a vertical chain. This goes along with the negotiating, you know, with other corporations point. This is a transfer pricing point. But think about it. If this is, you can't come to the right answer here. Let's just think about this. Google is selling advertising for a website which is nowhere, right? And everywhere, all at the same time. And so what we're saying is that by setting up, I just gave you 4 pieces of the structure, 4 companies in 4 jurisdictions, we can actually disaggregate the product advertising space on Google web pages. We can disaggregate that product and assign a piece of it to each. That is actually possible and measurable and has any substance more than what we've already done. More or less than what we've already done. I'd say we're in uncharted water, really, to be there. But to move away from that is not any easier. How else should we see things? How else should we do this? Right? I think, Jason, you said, a shell company is just a legal person. Precisely. what other kind of person is there but a legal person outside of, you know, us, humans, right? That's what we do. The corporate veil, you talked about the corporate veil that screens the beneficial owner. The corporate veil screens a lot. Yes, the beneficial owner, but also a whole structure of how we view law and legal institutions and legal creations and legal fictions. And if you pull that veil across, you have to deal with all of those questions. You can't just choose the one, which is the bad actor, right? The one that's high. What was his name? Your guy? Yeah, the first one you started with, the guy you started with. Let's start with an L. The guy who's still, I can't. That's him. Him. That guy. You can't just talk to him. You have to deal with your own view of how you think the state ought to or can treat the corporate entity. Should we just abolish corporations? Because that'll solve a lot of our problems. Shall we go away from taxing corporations and just have them be flow-throughs like partnerships? Because that'll solve a lot of our problems. No, it won't. Huh? Lee thinks it will? Well, we'll get to you. You can rebut, I'll allow it. The question at the end of the day, though, is what is substance, what is form here? It's all form. It's all form in the sense that we can't do really anything without the legal structure that we create to do the things we want to do. Right? And so, given the norms that we accept as we go about living our daily lives, right? It should not be surprising, but it is in fact surprising that the legal rules and institutions we have developed reflect our underlying norms and assumptions and beliefs. And it's surprising because it took us somewhere we didn't expect it to go, right? We went somewhere we didn't expect to go with all of these norms. They were all perfectly reasonable and rational, and they are still, many of them, still reasonable and rational, but they take us to a place we didn't expect to go. So just to continue, why does this problem exist? Well, it's a function of legal constructs and legalized norms. Legal rules for corporate formation, almost wholly a fiction. The US check-the-box rules have been called a complete fiction. But I just showed you that actually, in some case, you might say they're more close to the substance than another. But, you know, if you have some countries that think that you incorporate where your piece of paper is, and some that say you incorporate where your mind and management or management control are, well, who is right about that? Legal rules for property ownership. Geographic source rules, completely fictional. I don't know anybody who thinks geographical source rules are grounded in anything but complete legal fictions. There's no substance there. It's just pragmatic decision-making, forged over many, many years. I'm seeing smiles, so I don't know if that's good, like this resonates, or what is she talking about? Fully prepared to back up each and every one of these statements with a well-articulated footnote, I promise. That's what I do. Legal rules, interest deductible by the legal borrower, no matter where the risk is, you know, all these conventions that we have. Legal contracts and legalized norms for intercompany arrangements. Arm's length pricing, wholly fictional, dare I say. The alternatives, wholly fictional. Combined reporting with formula apportionment, probably wholly fictional too, or to some degree. Where's the substance? I'm at a loss myself. We see a plethora also of advanced rulings here. Sorry, I got to point the finger at the Netherlands. They seem to be very, very accomplished at the advanced ruling game, where you have the rule of law on paper, but somehow everybody's doing something else. In fact, how does that happen? If you want to, you know, think about the rule of law, I don't know where that fits in. But anyway, all of that's undisclosed. So we, the observer, I think Mona talked about the outside person, the public has an interest in all these things. We can't observe 99% of all of these machinations, right? Because they're embedded in competent authority agreements, they're embedded in agreements with your tax authority, your home tax authority, on your transfer pricing strategy. There are agreements with other countries on various royalty arrangements, various income arrangements, various tax rate arrangements. So, yeah. But Why can't we just look through all of this and come, through the forest and start to see the trees? If we disagree, if we got to a place where all these legal constructs and legalized norms took us and we're not happy with where they took us, why can't we undo it? Well, because looking through or undoing it would violate some pretty, I think, serious and contentious norms. One is the corporate law norms. I mean, it's not tax. In some ways, the tax people say, well, look, we're working within a field which is not our construct. Corporate law statutes, right? The right to the person. That's not our fault. It's not tax's fault. It's not tax lawyers. You got a problem, talk to the people who write the business statutes. It's their fault. They let us have corporations, right? So we think that looking through violates this sort of essence, right, of the corporation as a legal person. The right of the person to confidentiality is another one. I mean, you talked a lot about confidentiality, and there's, I think, more coming. We'll see some this afternoon. It was talked about this morning on, the confidentiality. We have these sort of strong norms, and I think we would all agree that some of these we do want. We do not want the state, necessarily, to be able to pry unnecessarily into every facet of our lives. And I think that's a justifiable claim, that we humans don't want the state to have that unending and unchecked power. How are we going to regulate that power? And so we have these strong confidentiality norms, but they took us to a place we didn't expect. And now what do we do about that? You can't dial back to a little bit just to get that one guy whose name I can't ever remember. But you get all of us, right? Now we have closed circuit television on all of us, right? So there's confidentiality norms that I think people are rightly, uncomfortable about violating to get to a different tax result, right? The tax-driven anti-privacy state is a terrifying thing, and I think for good reason for many people. And then finally, sovereignty norms. And, truthfully, I've given many talks on sovereignty and really taken issue with the whole concept of sovereignty as it's practiced today, because I think we have put a lot into this concept, of sovereignty, that the state is the right place to put all these rights. And then we have to respect the state. Now that's another legal fiction that we respect. I mean, it's raw power, really. There's no sort of normative explanation for the dividing of the world among states. It's a convention in the history. It's power, right? So, and those norms are powerful. They are embedded. And will I say we don't violate these norms ever? Wrong. We violate them all the time. But when we set out on a campaign to violate them for tax reasons, people start to get nervous. Right? People start, this jurisdiction's being overreaching, and that one's being too helpful to this sort of taxpayer, and so on. We start, pointing fingers at each other. Who's the worst violator? Right? We're all terrible. We're all bad in that sense. Nobody's got clean hands. None of this, I would say, in the tax world, we can all say none of this is our fault, right? No, it's not our fault that there are sovereignty norms that have preserved relationships between states that take tax to a different place than we would have maybe wanted. It's not our fault that there are confidentiality norms that prevent our governments from doing things we want them to do in this place but not do them over there. Right? It's not our fault that there are corporate law norms that go way back and that we're comfortable with, and that if you disassembled, we'd feel very uneasy about. It's not our fault, we can say. It's just unexpected consequences. But you're not, in the tax world, going to change any of these things. These are basic norms. So then the question becomes, well, can these rules, standards, and norms be challenged? So if we say it's not our fault, do we say we can't fix it? And I will say you can look at the various substantive policy proposals from various venerable academics and tax mavens, and they'll tell you about formulary apportionment, and they'll suggest revising the source rules, or they'll give you technical ways out of the thicket, right? And I think we should listen to all that. I don't dismiss any of that. I propose some of my own in here and there. But I think what we really need to recognize is that the world we're seeing is fragmented, And we are not seeing a whole picture, kind of, ever. And even my own descriptions in the slides are missing big, important parts of the story that I've told, and the big, important parts of every story are missing because we just can't see. It's too fragmented. There are boxes, and then there are boxes. There are contracts, there are arrangements, there are agreements, there are guarantees. There are back-to-back loans, there are all kinds of structures, many of which I'm just not smart enough to understand. I just don't get them. I don't know what they're doing. And I know they have a play, but somebody else's expertise is at work. And I trust them, right? When I was a lawyer in a law firm, I would ask the counsel from another country to help me understand what we were doing. And they would say, don't worry about it, it's just this way, you put this here and that there, and it just works. Yeah, you know, you're right. And I'll tell you how to do it from the US perspective because that's what I know. Because that's what I've spent years thinking about. And I'm fully compliant, you know, fully compliant taxpayers. And we saw above that each government has reasons, and I think real reasons, substantive reasons, to see what it sees and not see what it doesn't see, right? And some of these reasons are self-serving. I mean, no, I'm not pretending this is, you know, some sort of principled. This is not principled. I'm not talking about principles. It is self-serving, but it's convenient, it's pragmatic, but it's also just history. Decisions made and stuck to. A path gone down one way. Very hard to diverge, right? Some theory that takes hold and seems right. But, you know, as we say about theory, every theory becomes a part of the thing it theorizes, right? And we're there. I mean, we're absolutely there trying to theorize something that sort of escapes, defies theorization. So we can see, I think, the project of transparency, it actually tries to re-aggregate, right? It's looking to the people that actually do have the information, notwithstanding the representative they sent to the Public Accounts Commission. There is somebody in the Google organization who understands the structure. Right? It's not the Vice President of European Relations, I can tell you that. But there is somebody in the structure who understands, and so the transparency, you know, the publish what you pay, this the country-by-country reporting, the idea there, I think the compelling idea there, and I'm not, and again, putting aside the tax evasion side of things, a compelling idea for country-by-country reporting is that the only people that have the information that explains the world, that draws a picture, are the companies themselves, right? They're the only ones that can draw the picture, pull all these boxes together. Such a project would pull a picture together for us and let us see what's going on. We sort of see it very fuzzy, and we might not be able to make things out. That is the problem with disclosure. We're still in an aggregated, disaggregated, fragmented world. We've just sort of put the boxes together in a way. We might not be able to make things out, but it's clear to me that governments are going to have to regulate, right? Because the advantages of opt-out for individuals and companies are high. Very, very high advantages for opt-out. Lots of arguments, therefore, against disclosure, right? You'll see the arguments against country-by-country reporting or against publish what you pay from the corporate world. They talk about the costs and the benefits of providing disclosure. It's going to cost a lot. It won't benefit very much. And we're compliant. We, as the CEO of GE, or the tax guy at GE, Will Morris, says, we are fully compliant. We pay, we take steps to ensure that we're compliant. So don't worry about us. We're not the bad guy. Go after the bad guy. He's somewhere else, behind a tree, right? Disclosure, though, isn't necessarily, it doesn't have to be about compliance, right? It doesn't have to be about keeping companies honest, only. Not to say that's not a big part of it. It doesn't only have to be about that, right? Companies might be honest, they might be fully compliant, but we still have a complex and multi-jurisdictional world of law and institutions. And we need to bring that into focus for everyone who's a stakeholder. That's the goal, I think, and that's, I think, the laudable goal of people who look for public disclosure. right? Bringing things into focus, well, it's a way to get everyone who has a stake in the outcome. That's all of society, not just governments, not just the companies themselves, and not just their shareholders, right? But the rest of us who have created a monster that we all would like to identify and figure out, why is it such a monster, right? So we need a way to re-aggregate. And we need to re-aggregate all the disaggregated parts, organize them, filter them, and make sense of all the info. What we need is some Google goggles. Right? That's, I think, the project of disclosure. That's giving us Google goggles to start thinking about how to solve the problems. But you can't start thinking about how to solve them until you can see them. Articulate them first. That's all I have for you. Thank you very much.
Our next speaker is Merete Smith. She is the chief executive of the Norwegian Bar Association, and she has been so for 9 years. She came to the Bar Association from a position as appeals court justice in Oslo. She's also worked for many years at the Ministry of Justice. She's been a deputy judge and also a judge at Kvitt eller Dobbelt, a very famous Norwegian question program. Her presentation is called Lawyers' Duty of Confidentiality and New Ethical Questions. And this is, as you know, a topic that has been touched upon several times today already. So it will be interesting to hear it from Ms. Smith's perspective. Ms. Smith, please.
Thank you very much for inviting me here. I had a difficult task of trying to explain to you why confidentiality in certain aspects is a good idea, even though the buzzword for this conference is transparency. But first, a few words about the Norwegian Bar Association, where I work in my ordinary life. It is the representative organization for lawyers in Norway, and different from most bar associations in the world, we do not have a mandatory membership, but we do have about 8,000 members, and more than 90% of the lawyers in Norway are members of my organization. And the Norwegian Bar Association has 4 main objectives, and they are to promote the rule of law and the principles of a state governed by law, to develop the code of conduct for lawyers, and I think I will talk a bit about this, quite a bit about this today, and to administrate the lawyers' disciplinary board, to ensure good framework conditions for lawyers, and to serve the members through counseling and membership benefits. In the following, I will give a presentation of what the duty of confidentiality for lawyers actually is, how it works, and share some ideas on how it should be dealt with when balancing the importance of confidentiality on the one hand and the need for transparency on the other. And let me start with the rationale or the reasons behind the principle of lawyers' confidentiality. First, it's very important, to realize that the confidentiality and the lawyer's confidentiality is one important interest of rule of law in a state. And of course, there are other conflicting interests, very important interests, as transparency is, and also the need to disclose information. And I think very much of what I will talk about today is to find a balance. How do we find a balance, and what is the right balance? And the rationale behind the lawyer's duty of confidence. But in order to have a meaningful discussion of the duty on confidentiality, we need to agree that lawyers are important. Probably I will lose some of you already here. But for the rest of you, to me it is essential that we appreciate that lawyers play an important role for all those persons and businesses that is in doubt of their legal rights and obligations, and who therefore need expert legal advice. This is important in very many different situations. A person and corporation regularly needs to make plans for his or her business to make it in compliance with the legal framework, a framework that continuously grows more and more complex. Or in other situations, the client is afraid that the law has been violated, either the client may be the victim of such a violation, or the client may be the alleged violator. In all these different situations, the profession that offers advice to persons and businesses about the legal situation and implications are first and foremost the legal profession. Lawyers are also the persons or businesses trusted advocate in disputes, which may often be in a conflict with the government or the prosecution authority. To be able to give the client the right legal advice, the lawyer must know all the facts of the case. The lawyer's advice may only be correct if he is able to see the whole picture, although we learned today that it's not possible to get the whole picture, including all the positive and the negative aspects of the client's situation. Only then may the lawyer fulfill his role as legal advisor to the client. The duty of confidentiality of lawyers, clergymen of the church, doctors and psychologists all share an important objective: that people may seek professional treatment, assistance or advice without fearing that the information they provide will be passed on to others. Only when the person seeking help may tell the truth free of risks, the priest, doctor or lawyer will get a sound foundation for his or her assessment. The doctor may only then diagnose correctly, and the lawyer may only then give the correct legal advice. The duty of confidentiality is a necessary tool for a lawyer to be able to get access to all the relevant facts of the case. And the client must be confident that the information he provides to the lawyer will remain with the lawyer and not brought to outsiders. The rules of confidentiality can be hard to understand. Why does the lawyer need to get information that cannot withstand the light of day to provide accurate and complete legal advice? The ideal client has in all matters acted rightly and morally impeccable. However, in a lawyer's everyday life, the case is often that the client himself has created a problem. The facts of the case are complex and hard to understand, and the facts in issue are more or less stressful for the client. And it is in these cases that the persons really need a lawyer. It is when the patient is really sick that he needs a doctor. In other words, it is especially in situations where the client has a potential problem with the law that the duty of confidentiality really assumes significance as a tool for the client to obtain correct and meaningful legal advice from the lawyer. Let me give you an example. A woman came to a lawyer and her father has just passed away. She inherited his company. And he had died unexpectedly at a young age, and she wanted to go on, take over the company, get started. She started to work with the company, and she suddenly realized there are troubles here. I think maybe my father did not pay all the taxes he should. And so she came to the lawyer. And of course, the first And that lawyer was me many years ago. And the first thing she said when she entered my office was, "Does anything I tell you, is that told to anyone else?" And I said, "No, it all remains with me unless you tell me otherwise." And we went through the books and we went through everything. And yes, it's true. There were some troubles. But I think if she had not, but we fixed most of the things, and she's, you know, she went on and she's still running the company actually. But I think if she had not come to me or to another lawyer, I think in the end she would have had paid less taxes. She, you know, she might have tried to fix things herself and gone on with the company, probably, you know, having troubles and doing things the illegal way for quite some time. It is, however, important to stress that the rules of confidentiality applies only as long as the lawyer is within the scope of ordinary lawyers' work. It is not enough to put a sign on the door that says attorney and then think the rules will apply no matter what you're doing. Confidentiality applies to activity based on legal assessment and leaves out, for example, pure money transfers, financial advice, and real estate brokerage. You have to do lawyer work to fall within the confidentiality rules. But on the other hand, all types of clients are protected by the rules of confidentiality. Private persons, government entities, and business corporations. There are, for example, many difficult legal issues when one company buys another. The employees must be taken well care of according to the law. There may be competition issues and applications to the competition authority. If the company is on the stock exchange, a whole set of strict rules apply to prevent insider trading. There are pricing issues, several contracts must be drafted, etc. In many countries, and among them Norway, the client may waive the right, may waive the lawyer's obligation of confidentiality. In other jurisdictions, they may not, for example, France and Netherlands. Those countries limiting the ability to waive argue that clients frequently cannot properly assess the consequences of a waiver. There are also other reasons for having confidentiality. The duty of confidentiality also protects the client's privacy rights. Personal and sensitive information is, as we are aware of, subject to safeguard in legislation. The lawyer's confidentiality is in harmony with those rules. When understanding the function of the lawyer's confidentiality, it is important to bear in mind that the confidentiality also have a broader impact in addition to protect client's interest. When the lawyer is able to give the client correct advice, the client will comply with the law. The rights and duties passed and sanctioned by legislators are, in other words, supported by the confidentiality. It must also be appreciated that lawyers have an ethical and legal duty to advise the client to comply with the laws of the country. If the client does not follow the advice, but chooses to act unlawfully, the lawyer must withdraw from the case or the assignment. And of course, under no circumstances should the lawyer provide the client any help in committing such actions. It has been argued that lawyers too often push the limits of the law on behalf of the client. Well, most of us do take the maximum number of wine bottles through the customs when we have been abroad. And often the difference of arranging the investments of the client's company so that the tax burden becomes as small as possible, but still within the boundaries of the law, makes a difference between a profit or a deficit. I think the problem is somewhat else. Some lawyers push the facts. By that I mean twist the facts. An officer at the tax authority told me that for some lawyers, they always have to ask them for documentation for the facts that they present to the tax authority on behalf of the client. While for other lawyers, they have learned that they can rely on the facts presented in the cases. I wish all my members were in the latter category. That, you know, you could always trust the facts that they are presenting of the case. Lastly, the confidentiality improves the opportunities to present all relevant aspects of a case before the court. When the lawyer knows all the facts of the case, he is enabled to fulfill the statutory duty of acting truthfully towards the court. Through these sets of rules combined with the adversarial principle, the principle of hearing both sides of the case, the judge can reach a decision being well informed of the case. This improves the possibility to reach a correct ruling. The duty of confidentiality is an important part of rule of law. And also, as the Secretary of State mentioned this morning, the European Human Rights Convention also has also safeguard the duty of confidentiality of lawyers. But how does the duty of confidentiality work? What kind of information is covered by the duty of confidentiality, and what issues does it bring along? The regulation of lawyers' confidentiality differs slightly from jurisdiction to jurisdiction. But at the bottom line, the rules are very much the same in most countries. This morning, the Secretary of State said that the Norwegian rules concerning some aspect of confidentiality was unacceptable to the Finance Ministry. And I think if that means that most countries have rules of confidentiality that is unacceptable to the Norwegian Ministry of Finance. So I'll be very interested to hear what the suggestions for new regulation that he talked about this morning actually will be. And also the Secretary of State this morning, he gave sort of a brief introduction to the Norwegian rules of confidentiality, and so I will not bore you with the details regarding the scope of lawyers' confidentiality. And I think as a general rule you can say that what it means is that lawyers must keep secret all the information that the lawyer has received in the course of duty on behalf of a client, as long as the information is not already generally known. So it must be a secret, and it must be entrusted to the lawyer, and it must be entrusted to the lawyer in the course of duty. That means it must be entrusted in the lawyer when he's doing his lawyer's work. And in reality, the duty of confidentiality covers a wide spectrum of information. Many occupations have a duty of confidentiality, but the scope differs. Real estate brokers, employees in insurance companies, auditors and civil servants are all examples of occupations that are subject to duty of confidentiality. However, these kind of duty of confidentiality are in Norwegian legislation given a more narrow scope than the rules for lawyers. The duty of confidentiality for lawyers is similar to the ones of doctors and priests, as I already mentioned. In fact, the duty of confidentiality of doctors and priests are regulated in the same provision in the penal code in Norway. I mean, all these three are in the same penal code provision. Breaches of confidentiality may be punished with up to 6 months imprisonment. For the purpose of effective administration of society, and particularly relevant to this seminar, the purpose of effective collection of taxes, there are several statutory provisions that give public authorities the right to demand access to information held by persons and companies, as the State Secretary talked about this morning. And for the tax authorities, it could also be an advantage to have the opportunity to compare their own information on a taxpayer with information that third party possesses. And then comes the question: to what extent can public authorities demand access to correspondence between attorney and the client? And here you have the collision between the right to confidentiality on the one hand and the duty to disclose information to public authorities on the other. Where do we hit the balance? The last years there have been several cases before the Norwegian Supreme Court regarding these issues. And the Supreme Court has ruled that the obligation of disclosure to public bodies must yield to the duty of the lawyer's confidentiality, and hence the issues that was brought up this morning, and the reason that the Ministry of Finance now want to have to narrow the scope of lawyers' confidentiality in Norway. And this takes me over to the ethical questions regarding the relationship between lawyers' duty of confidentiality on the one hand and the need for society to have efficient tools in fighting tax evasion, corruption and economic crime on the other hand. In Norway, public entities and especially tax authorities do actually have extensive powers to demand the disclosure of documentation and other evidence. Also, mostly from the taxpayer himself or herself, but also from third parties. The purpose of these rules is, of course, disclosure, not to undermine confidentiality, but to fight serious crime. Organized crimes in the form of terror, economic crime, and corruption is ultimately an attack on democracy and the welfare state. The fight against these threats is extremely important, and that's why we're all here. And I do not at all underestimate the seriousness of these kinds of crime. And I believe the reason why I'm asked to speak here today is that lawyers often play an important part in financial transactions. They possess the legal expertise necessary to make deals successful. They are aware of tax advantages and are often capable negotiators. And I am afraid that lawyers sometimes also may be involved in transactions involving proceeds of crime, money laundering, corruption, and tax evasion. And to make it clear, to the extent lawyers are aware of such circumstances, they are accomplices, and of course acting very far away from the role as a lawyer. This is criminal activity that I indeed hope is detected and prosecuted. And how can we supply the battle of economic crime with better tools? And I think the question is, how can we catch the bad lawyers without introducing rules that is a threat to all the members of the profession and does not treat all the members of the profession as criminals? And let me then first say something about the tools that already exist in the Norwegian legislation. A decade ago, anti-money laundering legislation that includes lawyers came into force. We already heard something about this. The purpose of the legislation is to both prevent and detect transactions associated with proceeds of crime or associated with acts of terrorism. This regulation has two main effects on the relationship between lawyers and economic crime. First and foremost, the anti-money laundering rules prevent lawyers from entering into relationship with clients with criminal intent. The regulation imposes lawyers to do a thorough client due diligence. Who is the client really? By detecting who the client is and who the beneficial owner of the client is, lawyers can more easily assess the risks of whether the potential client has to do with economic crime. If the client due diligence leads to information that links the potential client to criminal activity, or the due diligence cannot be carried out properly, serious lawyers will not take the case. Secondly, the anti-money laundering regulation instructs lawyers to file reports about suspicious transaction to the police. The introduction of this rule met resistance from the legal profession worldwide. The bar associations all over the world have argued that the duty to file reports on clients is incompatible with the ethic of lawyers. Many jurisdictions, including the United States, are still unwilling to, what they say, dilute the rules of confidentiality or the legal professional privilege, which is the common law term of confidentiality. In some countries, lawsuits have been filed contesting the anti-money laundering regulations application on lawyers. It is ruled that the reporting duty is unconstitutional in Canada, and constitutional courts in Belgium and France have set aside parts of the regulations application on lawyers. In Norway, similar lawsuits have, as far as I know, not been filed. And I think the Norwegian lawyers now have come to terms with the obligation under the anti-money laundering, it's a very difficult name, regulations. Especially do they realize that the legislation regarding identification of the client is a relevant tool in preventing getting clients they do not want to serve. Critics claim, however, that lawyers do not fulfill their obligation to report suspicious transactions, that lawyers are under-reporting. I do not think these assertions are based on facts. It is true that the number of reports is only a couple of handful a year in Norway, which corresponds with the number of many other countries. But it is important to understand that lawyers is the only profession comprised by the anti-money laundering regulation having exemption from the reporting duty for their core activities. The lawyer is namely exempted regarding information obtained in connection with work on ascertaining the legal status of a client and on information obtained before, during, or after judicial proceedings. So if you're giving legal advice, or if you are in a case before the court, if you get information in these two positions, the lawyer has no duty to report. And this is in compliance with the EU directive. I would also like to add that another reason for the number of reports is that lawyer avoids taking on assignment when they suspect that it has connection with criminal activity. And also, let me here give you an example from my practice. One of the first weeks I was a lawyer, and I had a businessman coming to me. And I didn't feel very comfortable with him, but I wasn't sure if it was okay just to say no. So I asked one of my colleagues, what do I do? And he said, well, you can try to ask him to pay a very large sum of money up front. That usually, makes them, find another lawyer. And I did. And then next day he showed up with all the money in his briefcase. And then, of course, I had to say, I'm sorry, you have to find another lawyer. This shows that, very often the lawyers, they never get as far as to take on a case. And I think maybe this is also a little bit what you mentioned, that many of the lawyers you wrote to, they never answered. And I think that's what they do. They don't They don't get in touch with you. They don't want to have you as a client. So I believe that the anti-money laundering regulation actually, to a large extent, has achieved its main goal regarding lawyers, making lawyers less attractive as a tools for conducting economic crimes. I know that the Secretary of State this morning said it is otherwise, but I really do think that anti-money laundering regulation, it has had an effect. And I think also, I really do think that the lawyers has come to terms with it, at least to a large extent. Another tool, to put it that way, that we already have in force in Norway is that under Norwegian law, lawyers that are suspected of being accomplices with the client can be subject to seizure of client-lawyer correspondence. Here the duty of confidentiality has been set aside to solve crimes where client and lawyer conspire in crime. I believe this is a sound arrangement. But while saying this, I must mention that it is not without problems. We see sometimes that the police charge lawyers of crime together with the client. Then they enter the lawyer's offices and seize documents. Soon afterwards, the charges are dropped. It leaves an impression that the police pushes the limits of the law or even cross the line in order to achieve seizure of a seizure order that in reality conflicts with the rules of confidentiality. In Sweden, not even these situations permit seizure. From a ruling of the Swedish Supreme Court 2 years ago, the Swedish judges based their decision on the fact that the prohibition against seizure exists in the interest of the client. And this particularly applies when the client is suspected for criminal activities. Due to this, the prohibition cannot be set aside when the lawyer himself is a suspect. In the ruling, one of the judges wrote that, unfortunately, a criminal lawyer may make use of the client's right of confidentiality, but this is the price one must pay to maintain the important principle of the rule of law. I have heard people claim that lawyers' ethics is deteriorating. I am not so sure. I think development has been the same as for the rest of us. But there are more lawyers now. The society has become more complex, the wealth of the population has increased, and marriages do not last a lifetime anymore. Maybe the temptations are also increasing. What can we do? In general terms, I think one possibility is to make it more difficult to become a lawyer and easier to lose your license as a lawyer. And of course, lawyers that are found guilty of crime must be disbarred. This maybe sounds a very too simple solution, but I actually do think that that is one tool, one thing we can do. Also, legal ethics should become a more important part of the legal education. My experience is that what you learn early on is formative. And I definitely see from the cases we have before the disciplinary board that young lawyers who has worked for a lawyer, for an older lawyer, with many convictions in our disciplinary board, also becomes a frequent visitor of our disciplinary board. And then coming on to the financial sector, it is a fact that lawyers facilitate international transactions and the formation of shell companies. This is in itself, of course, not illegal. Critics of lawyers' confidentiality claim that it is not only the lawyer's legal expertise that makes them an attractive advisor, but also the fact that they have a duty of confidentiality. It is said that the confidentiality adds an extra layer of security to the plot, in addition to secrecy characterizing the tax havens, making the plot even harder to unveil. One thing should be done to make the lawyer's client's account less tempting for those who want to launder money, and that is to introduce a duty to disclose the name of the client to the bank in connection with money transfers to and out, to outside of the country and back into Norway. And maybe we should also make the lawyers have a duty to put the name of the clients more often when they use the client account. And as I've said earlier, I am aware that it does happen that lawyers are involved in transactions involving proceeds of crime and money laundering. And in the debate, I think the argument for disclosure, transparency and control seem to very easily triumph over the duty of confidentiality without too many objections. And sometimes I feel that in conferences like this, people speak, they talk about why, many speakers about why confidentiality is a bad idea, and then I'm the only one who's talking about why it could be a good idea sometimes. I'm afraid that if we limit the lawyer's duty of confidentiality too much, clients will start holding back half the truth or quite simply desist from seeking legal advice. This is not the way we ensure more law-abiding behavior in our society. It would rather lead to the opposite, I think, less law-abiding behavior. Another oddity that would come out of this is that the information that lawyers may hold today, and that is interesting for the tax authority and the police, will no longer reach the lawyer, because the lawyer cannot be trusted anymore. Thus, I am afraid opening up the client files would be close to pointless and too dearly bought. I agree with those who argue that you will probably catch more criminals and perhaps also prevent some crimes if you allow the police to enter the files of an attorney office. But I think you overestimate how many you will catch. And I strongly believe that you underestimate the consequences of such legislation and the negative impact it will have on society. To strike the right balance between opposing principles, confidentiality and duty to disclose, both with good rationale behind it, that is exactly what makes a sound democratic society governed by the rule of law. The right balance is not always easy to find. But I am sure that society needs competent lawyers, and that the client need confidentiality in order to receive the good legal advice. But it is to find the right balance. And I think in the end, it is really a matter of choice. What kind of society do we want to live in? And I think I'll end here, but before I do that, I was coming over here. I came over the mountains, and 2 days ago, I was doing this. And so if you have some more time, for some of you, all of you who come from abroad, only 2 hours away from here, it's very nice skiing conditions. But anyway, thank you.
Our next speaker has been fighting the bad guys for a generation. Jack Bloom, you were involved in the Lockheed bribery scandal in the 70s, I believe. You've been at the Senate Antitrust Commission, Subcommittee, sorry, and the Senate Foreign Relations Committee. And you will be talking to us about legal privilege and international tax planning. You are now at the Tax Justice Network USA, and I'm sure you will provide us with yet another aspect of this fascinating topic.
I'll try to. Thank you. It's a pleasure to be here today. I've actually been in Bergen when there's been 5 days of sunshine. So I've had the miracle of Bergen, and I'm getting used to Bergen as it usually is. I'm going to begin this afternoon by talking about an incident in Cochabamba, Bolivia. I was invited to speak on legal ethics at a conference of the Inter-American Bar Association in Cochabamba. And this was at a time when Cochabamba was on the edge of rioting because the World Bank had told the Bolivians they had to sell their water system and privatize it. And the new company, an American company, Halliburton, no, actually an American engineering company, had taken over the system and imposed water rates, that is the cost of buying water, that was about half the annual income of the average citizen of Bolivia. And this, of course, was untenable. But meanwhile, here was a conference of lawyers in Cochabamba, and I was to talk on legal ethics. And I started out by saying that the obligation of a lawyer, I was taught in law school, is to assist a client in obeying the law of his society. That the first obligation is to teach your client what is your obligation under the law of your society. And you're not to take him into the gray area and say, look, this is how far you can go and push it. You're to keep him in a zone where he's clearly behaving legally. Secondly, you're not supposed to answer the question, what are my chances of getting caught? You're supposed to tell him, no, you can't do that. And if he wants to push into that zone of what are my chances of getting caught, you really should be finding a new client. The audience of lawyers in Cochabamba began to laugh at me. You know, what kind of idiot has come from America to tell us this? Because we all understand that our job is how to get around the law, not how to help people obey the law. Now, this is an extraordinarily important proposition because really adherence to the values of a society is what makes a society work. And if you don't have people who adhere to the values of the society, you have chaos, impossibility, and a place that no one really wants to live in. We actually have a system for trying to ensure that people obey the law, and it's a criminal justice system. We punish people. And societies for all time have been perfectly capable of saying, we'll take away your property, we'll take away your liberty, and in extreme cases, we'll take away your life if you don't adhere to the values of our society. Now, that is the way we bring about social control. If lawyers don't help make that system work, if what they do is try to find ways to take people out of an area where they have those responsibilities and are answerable legally, the society begins to break down. And what we've got now is a situation where the legal profession is adhering to the values of what yesterday Prime Minister Papandreou referred to as the Republic of Richistan, as opposed to the republic in which you live. The values that are being talked about are how do I get around laws by working the international system so that I find a way that either I have no personal responsibility in the jurisdiction that I'm operating in, or I pay no tax in the jurisdiction I'm operating in, or I have no responsibility to the society in the place that I'm operating. And if the lawyer takes on that role, I believe it's a fundamental ethical violation. I'm going to shift here to talk a little bit about how that proposition has been put into play by the legal profession. I'm old enough to remember the history and evolution of corporate law. For a long time, in British common law, in American law, the only way you could do business was as a partnership. Partnerships required unlimited liability, so that if you went into a business and you failed, you went into a contractual obligation, and you couldn't pay your bills, you were personally responsible. When the American Constitution was written, we wrote in ideas of bankruptcy, which is to say that you couldn't be put in debtor's prison for failure, let's say, in a business venture. And the idea here was to make it easier for people to take risks and develop new enterprise. A very noble idea, I think. And then we took it further and began to develop, and this happened in other parts of the common law world, the notion of a corporation, which could have two advantages. One, limited liability, that is, limited financial liability, and in addition to limited liability, perpetual life, so that you could keep this corporation in business. It didn't die with the death of a partner. It didn't die with the departure of a partner. Well, what's happened is that we have gradually taken the notion of corporation, which was very tightly controlled by the state when it originally came into being, and expanded it to the point where it's become the vehicle, along with other devices that have been invented, for separating individuals for responsibility for their actions. We've gone a long way in separating the act from real responsibility. And it's wrecking, I believe it's wrecking parts of our society. And it's not just in the area of taxation. If it were just taxation, it would be one matter, but it's in multiple areas. And let me give you a number of examples. In the recent financial crisis, you probably noticed that it was very difficult to pin down where the transactions occurred. Where were the shadow banks? Where were the contractual arrangements that were set up that were bankrupting the financial institutions? And suddenly you began to realize, if you dug into what was going on at a bank, that a bank wasn't a bank. It was 700, 800, 900 separate corporations sort of moving along in close formation. And these corporations were in multiple jurisdictions with very different kinds of rules, and in some cases included entities which had no owners, no one responsible for them. We discovered things like that in Enron. There were actually corporations that were set up, one particular in Jersey, I recall, in I think it was the Enron affair, which had no owners. And there were letters to that effect, that there were no owners. And all of this was to make liability disappear. Well, all of this didn't happen accidentally. Lawyers were here working for, as I called it earlier, the Republic of Richistan, putting distance between responsibility to the society and the state away from the individual and making it disappear in a welter of entities which no one could get their arms around and no one could do anything about. This is a shift which I think has really brought tremendous trouble to our societies. And there are some more things here to consider as we think about what it means. I'd like to talk just for a minute about the insurance business. In the United States, insurance is a matter of state law, And insurance companies are required to have certain fixed reserves to cover losses. So if I'm going to insure people's houses against damage from a hurricane, according to American law, by agreement, an insurance company has to have reserves that are sufficient to cover a once-in-100-year event. Well, the insurance companies don't like that much because we've had quite a number of once-in-a-100-year events. So now what they've come to be doing is writing reinsurance contracts. So wait a minute, what we're going to do is give up part of our premium income to insurance companies that are operating offshore. Bermuda's a favorite. And guess what? In Bermuda, an insurance company is only required to have reserves for an event that occurs once in 500 years. Okay? And now we've neatly sidestepped requirements that were designed to protect the society. Is it legal? Of course it's legal. Is it right? That's a question which most people won't even know to ask because these arrangements are not at all clear. They're very complicated arrangements. They're not very public. And no individual who's buying an insurance policy for a house has the time or the capacity or the capability of figuring it out. And so it goes with tax planning as well. It's financial regulation, it's tax planning, it's liability as well for incidents that cause tremendous damage to society. You may recall we recently had a blowout in the Gulf of Mexico. This was the oil rig that BP had. And the oil rig was owned by a drilling company called Transocean, a company fairly well known here in Norway, it being the target of a tax matter. But Transocean, shortly after the blowout, ran into a court in Houston, Texas, and asked for a declaratory judgment limiting its liability to about $175 million. And that was based on the fact that the rig, the drilling rig, was a ship. And as a ship under maritime law, the losses it's liable for are the value of the ship and no more. And not only was it a ship registered in the Marshall Islands. Wait a minute, how did that happen? Transocean's headquarters are in Houston. But no, if you look at its documentation, in the year 1999, it inverted and became a Cayman Islands corporation. And by doing the inversion, it managed to move all of its profitability and dividends to a place where there were no taxes. And now it could become one of those disappearing chimera arrangements where everybody could look at it through a different lens and see nothing. We had Google goggles, but without the goggles. We had multiple enterprises, but the business is still being run from the same place, by the same people in the same way. Only when it comes to liability, they're working from the Marshall Islands, and when it comes to taxation, they're working from the Cayman Islands. And when it comes to looking at the company, I feel like I'm a little bit drunk because I can't figure out what I'm looking at. This kind of corporate arrangement is now the commonplace for everything. If it were only Transocean, it's every large bank, it's every large insurance company, it's almost every large enterprise on the planet. And what's happened is they all have teams of lawyers whose objectives are minimizing tax, eliminating liability, and with it, eliminating responsibility. One of the most appalling and pressing questions of the financial crisis in the United States is, why hasn't anybody been prosecuted? Why haven't people gone to jail? There have been hundreds of situations where the securities that were sold and resold on various markets and sold over the counter from one firm to another were obviously fraudulently presented. You know, the fraud was absolutely classic. And you say, well, where were the prosecutors? Why didn't they do anything? And you'd go in and ask that and have that conversation with the prosecutors, and then you say, well, whose law governs? This instrument was an instrument that was done in the Isle of Man, and it was sold by a British subsidiary to a hedge fund that was operating out of Cayman. And, you know, who's responsible and whose job is it to prosecute and who has the resources? And if we really try to get to the bottom of it, where are the records? How will we get them? How much time and money will it take? And in the end, who is responsible? Who did it? Which individual in the company? Was it the guy who sold it on the phone? Was it the person who up top said, yeah, this is a good system, it's okay, go ahead, do it? And if so, how do we find that person? There's a notion that somehow these hundreds of entities that are floating around that comprise this large corporation each have a body of their own, a board of directors. Well, some of you here in this room were with me in Miami at a conference put on that's called Offshore Alert. And at this conference we had panels, discussion panels, that included lawyers and offshore service providers who were talking about the question of responsibility of one of these offshore shell corporations in the event of a bankruptcy or a fraud or a liquidation. And in the discussion it became clear that the first thing that any service provider requires of their client, that is to say, if I walk in and say, set up a shell company, the first thing they want me to sign or put in the contract is that they have no liability for anything the company does. They'll provide all the directors, they'll provide all the officers, they'll keep the books, but they say, sorry, we're not responsible for anything the corporation does. Well, who is responsible? They're the directors, they're the officers. And in the end, you can't find out who's responsible. And that was the complaint of some of the lawyers who were talking about it, who are liquidators, who are trying to go after people to find the disappeared money. So, you know, who are these lawyers who set up this complicated offshore structure? And what are their ethical obligations? I want to turn for a minute to a problem that I encountered when I worked with a whistleblower who was going to IRS with a lot of information. And what he had was an offshore planning document for how to structure a deal to make about $2 billion worth of income disappear. And this was income that was pretty obvious, and the transactions had already occurred. So this advice was after the fact. It was, hey, you better undo all of these things you did and let's redo them, and if we redo them this way, there won't be any liability for what there would have been if you keep them in the situation they had been before. Now, I thought to myself, here's a lawyer who clearly deserves to be disbarred because the transactions had occurred and they were actually organizing and perpetrating what I would say is a criminal tax fraud. But the problem was, whose bar had that responsibility? Because the target was the US, the law firm was British, and the reorganization and the crap that was in that letter that suggested how to do all of this was aimed at restructuring companies in the European Union. Who's responsible? Which lawyer? Which set of rules? And here we have the law firm working for Richistan, and no responsibility on the part of the individual lawyer to the society that he's part of. He's working to separate the people who are doing the deal from their responsibility to their society for tax, for any damage that might be caused, for any outcomes. And that, I submit to you, is absolutely unethical and antithetical to the role of the lawyer, and totally damaging to our individual societies. Now, I've given a lot of thought to the problem of why we accept this, and what the argument has been for accepting this sort of craziness. Well, part of it is that we've had a lot of trouble with the state. You know, if you go back through the history of the 20th century, we've had criminal states. World War II was fought over a criminal state. We had a state in the former Soviet Union that thought nothing of having, 10, 15 million of its own people starve to death because the dictator in charge of the state had the idea that that was the way to go. We've had a head of state in China that allowed 30 million people to die of starvation because he had a strange and warped idea of development. We've had states that have confiscated people's property with no explanation, no rights, no rule of law. And the idea that people should have a refuge for their persons and property from a criminal state have led us to accept, at some level, quite a bit of flexibility in moving money around and taking it away so that a state can't arbitrarily confiscate what belongs to the individual. That proposition is set on one side and used as the argument for rigid bank secrecy, for preventing any sort of look-through of the kind of thing I've been talking about. The preceding speaker talked about balance. Well, I think that there is balance. There is an opening for balance. But the balance has now swung so far in a direction of destruction, of undermining the possibility of the state to provide for its citizens, to protect its citizens through the use of criminal law, to make people adhere to the common values, that we have to find a way to bring the balance back. And this is personal and individual responsibility that I'm talking about. We can't anymore have businessmen whose home is a jet flying at 30,000 feet or a 200-foot yacht who have a squad of lawyers who explain to them how to do business anywhere and everywhere with no responsibility for any consequence. That isn't what you should do. Unfortunately, that kind of lawyering has become the best paid lawyering. That kind of lawyering has been where my colleagues make the most money. And it is a wonderful few of my colleagues who are able to walk through the labyrinth that's laid by these other fellows and recover money when it's stolen, find the proceeds of crime, find the stuff that's gone wrong, and get some manner of restitution. So when my friends here who've gone after Abacha money spend 5 years, 10 years of their lives chasing the money and trying to get it back, and they triumph, it's really quite remarkable. But we shouldn't have to do that. We shouldn't have to have a 10-year run. And some people in the discussion of that asset recovery yesterday were talking about the problems of getting back just a fraction of that money And what could you do to really make it impossible to get it? And I kept thinking, you know, what's wrong with our banking system? That the day after Ben Ali is out as head of the government in Tunisia, somebody says, oh my God, shock, we've just found $6 billion of his money in our bank. Wait a minute, why didn't you know about it the day before he went out of power? What did happen to all of the money that the Mubarak family got out there? And why are we worrying now about, well, how do we find that money? Surely the bank involved took it in, and they knew what to do with it, and they knew whose it was. Now, of course, again, those colleagues of mine at the bar who are divorcing responsibility from individuals, separating the individual from responsibility for their actions, have done both things. They've protected the Mubarak money from those who would recover it, and they've protected the bank. And they've given the bank the structure to help Mubarak hide the money. What will we do with those lawyers? So what I appeal to you today to do and to think about is how to get my profession to go back to what its job is, which is teaching people how to obey the law, how to find that place where we can tell people, if you behave this way, you'll be behaving honestly, and how we get to the position of not advising people, this is your likelihood of getting caught. And by the way, don't tell anybody I told you that. Right now, most of tax law depends on that idea of what are my chances of getting caught. And I will tell you, even after the UBS case and other cases, there are still clients coming into law offices asking, should they go honest? What are my chances of getting caught? And the truth is that no tax authority, no law enforcement authority can catch every criminal if every criminal has to be prosecuted. The system depends on the honesty of half the population and the fear of another 40% of the population that they'll get caught if they do wrong. And what we do is prosecute the dumbest and most egregious of the remaining 10% to put fear in the heart of the 40%. The way the system is working today, the fear is missing, the capacity to enforce is missing, the complexity of working through the international system is overwhelming, and as a result, we have real financial catastrophe. I think we're talking about time for change, and time for change now. Thank you.
Now, our next speaker is already present at my side, Lee Shepherd. Your lecture, which is entitled Corporate Tax Planning and Avoidance. Ms. Shepherd.
Okay, so we have the diagram here, and we're gonna stare at this until everyone understands it today. This is the value-free part of the program, because I am going to talk about what the existing international consensus is and how the countries that you people represent can defend yourselves against, you know, the structural problems. And I am going to speak as though you were advising your own governments what to do. Now, when we look at this, I'm going to go through my points here, and then I'm going to go back into detail. One big point is that, you know, as nice as it sounds to have country-by-country reporting and transparency, it's not going to get you where you need to be. I mean, we have in the U.S. system, in our transfer pricing enforcement, which has become kind of a charade, we have a lot of transparency. This is a simplified diagram done by our Joint Committee on Taxation of a real company. This is not all of the companies. This is just enough companies to show how market countries are deprived of tax revenue. Transparency is not going to get you there because these, as Jack was saying, and the speaker before, and as Professor Christian was saying, these companies, this is not the laser pointer. Okay, this is the laser pointer. All right. These companies are just artificial. Oh no, what did I just do? Okay, these things. This is all just one big happy family. There's the U.S. parent there, okay? Everything else, you know, except for the actual customers in the circles there, everything else is just a tax construct. It may or may not have employees. But, you know, if you say, oh, well, better transfer pricing and country-by-country reporting is going to get me where I need to be with this thing, then you're just buying into the idea that these legal entities mean something. These legal entities don't mean anything. Financial accounting, and I have actually nice things to say about financial accounting. It's some of the best information we've got. Financial accounting looks at this and says, look, that's all one big company. We want your, you know, whole numbers. Okay, next thing. Don't sign OECD model treaties. Don't sign UN model treaties. The OECD does not have the interests of small and medium-sized vulnerable countries. And notice that I am not talking about developing countries and developed countries. As far as these multinationals and their advisors are concerned, there is no differentiation. There are only countries from which there is extraction and countries where there are customers, and these are all countries from which income has got to be stripped. And the rubric that allows this is the international consensus. That's what it's called. It is the whole treaty network. The treaties protect multinationals primarily. That's all they were ever for, was to make life comfortable for multinationals. That's what tax treaties are for. Secondarily, the OECD protects the interests of the United States and the United Kingdom. Germany, okay? Germany is the biggest economy in Europe. It doesn't really even qualify to be listened to at the OECD. There's things that Germany wants to address this arrangement right here, this commission arrangement. They're not going to get them because they're not a constituent. Now, if they're not a constituent, is Norway a constituent? I'm gonna get back to the treaty part. You want to, and this is it's almost an advantage of being on the smaller side. You want to enact specific defensive laws to address the problems that you know you have. If you have problems with, you know, pricing of minerals going out of the country, or you have problems with ships being towed out into the ocean and sold, you know, I mean, I can write you a 2-sentence statute that says, if you have an oil rig that's licensed to operate in Norwegian waters and operating there continuously, and it is sold while it's under contract, the sale took place in Norway, no matter where the actual sale took place. That's not a hard statute to draft. You know, you can draft protective stuff and get it in your law, and they can't argue with it. Because right now, you know, in some of these situations, the treaties are protecting them, and the countries that are harmed are not protecting themselves in their own laws. And speaking of protecting yourselves, for those of you who are from mineral exporting countries, for heaven's sakes, the agreements that you sign, This is the point of maximum leverage over the multinational companies that are extracting the minerals. They want the minerals, you have them, you can put the conditions in the agreements, you can put tax conditions in the agreements. As I understand it, and somebody correct me if I'm wrong, I am told that both sides of the North Sea, both the United Kingdom and Norway, signed production sharing agreements. You haven't been able to get a production sharing agreement from Saudi Arabia for 50 years. You know, the country owns the minerals, the multinational gets paid to take them out, and then it buys them from the country at the world price, which is a very easy thing to find. And I think Brent is actually around here somewhere, right? You know, we can sort of see it. Okay, so let's go right back through, you know, why not to do these things? Why not to sign OECD treaties? I'm very grateful to Professor Christian, because she was talking about the norms. Well, where do we get the norms? The norms form what is called the international consensus. And the international consensus is basically a load of nonsense that protects multinationals. When you sign on to the international consensus, you sign on to a bunch of consequences that have very deleterious effects on what we call a source country. That's a market country. That's right around here. That's where this is Norway, and this is all of the countries that are represented in this room, right here where the limited risk distributor and the customer are, okay? When you sign an OECD model treaty, okay, you say there's no withholding or hardly any withholding on outflows of cash to multinationals. Now, why in hell do you want to sign that? India, South America, withhold. South America does not sign OECD model treaties because a treaty's a contract. They read the document. They don't like the terms. Okay, you sign on to respecting all these little boxes as real live corporations that decide their own actions and are separate economic actors, as Professor Christensen said, and as we know, these are not separate economic actors. On a balance sheet, these things don't exist, the transactions between them don't exist, but you sign on to not only recognizing the transactions between them, you sign on to recognizing and respecting the self-serving contracts that the multinationals' lawyers wrote to explain those little flows out of your country of cash on which there is no withholding. And you also sign on to a concept which we won't get into today unless somebody wants to ask about it later, called permanent establishment. And this is one the Indians are fighting to the wall. And you know, next time you have one of these conferences, invite people from the Indian and Chinese governments, because they have signed a bunch of these treaties and they are fighting this stuff. They are fighting for their own interpretations of this stuff, and they are fighting the permanent establishment concept, which is a rather nonsensical concept which says, well, if you multinational are operating in a country and are making money in a country, but you have any presence that is short of, a full-on automobile assembly plant, you are not taxable as in that country at the level of the owner of this plant. This thing has to be, you know, a little circle drawn around it, and it cannot be taxed in a normal way. That is a pillar of that treaty. And it allows companies to, and we don't see it on this graph here, allows companies to, you know, go in through the internet and sell services to everyone in the country and not pay tax. That's ridiculous. That's what permanent establishment has come to mean. You do not want to sign a document that's got that in it. Now, what do you do if you have these treaties? Norway has an awful lot of these treaties. Well, the European Commission, actually, the other day made some interesting suggestions because, you know, the multinationals not paying any tax anywhere, including in most of Europe, has gotten so bad that, you know, even the guys who are in charge of borderless Europe are starting to notice this. And they said, well, you shouldn't sign treaties with tax havens. And you shouldn't. The United States, by and large, does not sign treaties with tax havens. That's how the United States blacklists people. They, you know, if you're really a tax haven in the eyes of the United States, there's no treaty with you. But they have a kind of narrow definition of tax haven because, you know, one of the definitions, we heard this the other day, was, well, it's a small jurisdiction, and you have to be small to be a tax haven, because if you have real responsibilities to people and schools and roads and things like that, you kind of have to have taxes to finance all that. It's a jurisdiction that offers special deals to non-residents. Now that's kind of like Gibraltar. You know, that's a very narrow definition. But you also, so you don't want to sign treaties with that, okay? But the other people you don't want to sign treaties with are the international enablers. The Netherlands, Switzerland, Bermuda, it qualifies as a tax haven in most people's eyes. Ireland. These are members of European organizations in good standing. They are low-tax jurisdictions. They have real tax systems. They tax their own people. But they also basically do a full-on business as conduits of money out of, they are not in themselves big markets, full-on business as conduits of money out of the market countries. That is all of your countries. When your countries are in the posture of consuming goods and services from big multinationals, you know, all those American products and entertainment that you really want to keep your children away from, you know, that's, you're a market country for that stuff, okay? These are the conduits they use to get the income out of your country after your child has whined and pulled on your leg and you went and bought that product you didn't want to buy. You don't really want treaties with them, but these conduits have treaties with everybody, because you can't run yourself as a holding company jurisdiction without a treaty with everybody. You're beginning to see how treaties enable all this. But South America, you know, Brazil is a huge country. The United States does a lot of business with Brazil. The United States has no tax treaty with Brazil. A lot of the orange juice in the United States it goes right into a boat that looks like one of those oil tankers, and it goes right up to the port in New Jersey. You know, you can do business with a country without a tax treaty. As a country, you don't need one. You do need a bilateral investment treaty, which is a treaty that says that there has to be arbitration if there's an expropriation. You do need the rule of law. If you have enough oil, you don't really need either of those. But you don't need a tax treaty. Now, what do you do? What do you do if you've got treaties with the enablers? Okay? Well, you want switchover clauses. This country, Norway, signed a treaty with Ireland in the year 2000. It's clear what Ireland does. Ireland is one of the enablers. The enablers, and that's what these rulings that Professor Christian was talking about, they will defend the multinational's position in competent authority negotiations. That's a treaty negotiation between the two affected countries. They will defend it. That's part of the services they sell. There's nothing for them to defend if you have a switchover clause. The Norway-Ireland Treaty, somebody correct me if I'm wrong, but I looked at it, it does not have a switchover clause. Now, here's what that means. Norway is an exemption jurisdiction. That means foreign active income is exempt from taxation in Norway. Well, if the income has been shifted to Ireland and Ireland doesn't tax it, guess what? Ain't nobody taxes it. A switchover clause says that if the other party of the treaty doesn't tax the income, then the first party, that would be Norway in this case, gets to tax it. And the OECD model has in the draft a switchover clause that you can just pop into your document and say, guess what, we are not signing this treaty, or maybe, you know, we want to open up a negotiation for a protocol to get this. But yeah, if you've got treaties with these folks, because your businesses will whine and they'll say, you have to have a treaty with Switzerland. Why? Well, because we need it for business. What business? Well, tax evasion, you know, tax avoidance, not really evasion, avoidance, but, you know, we need it for tax planning. I mean, look, that argument carries in the United States. The United States has treaties with Switzerland, the Netherlands, Luxembourg, all these European enablers, because our businesses, and that is what this is a graph of, our businesses want to be able to strip income out of Europe. Now, I don't know why Europe doesn't get a little peeved at us for having this policy, but that is what it says. So yeah, you gotta have switchover clauses. Now, all right, what are we doing here? Let's talk a little bit about laws, and then let's talk about the chart here, since we're having so much fun with it, and then we'll talk a little about the laws that you can put in place to protect yourselves a little from this. Now, I am very grateful to Professor Christian for setting up what is sort of point zero in this chart, because this is the U.S. parent here, okay? In Switzerland here, we see an intellectual property holding company. And the phase that Professor Christian was talking about was how that U.S. parent, oh, I keep doing this, gets those intangibles into that Swiss intellectual property holding company. What the intangibles, the intellectual property, what that is, okay, that can be the patent on a valuable drug. That can be the trademark on that toy you bought your child. That can be a copyright on some movie you don't want your child to watch. That can be any kind of royalty-producing intangible asset. You know, this is where the economic rents go. That is, if we're not talking about oil extraction, and we're not talking about mineral extraction, that is the key to the success of multinationals and the reason they make what the economists call excess rents. Because if you look at multinationals, you know, there's not very many of them. And in some businesses, there's like one big company, or there's like 2 or 3 big companies. The reason they are successful, the reason they earn higher profits than a normal company is because they have these protected properties. Now, where the actual protection is going on in the United States, that's, you know, but what is happening is, you know, and this is what we saw in the Google case, and you know, the thing about the Google case, and the thing about this case we're discussing here, U.S. law and practice permit this stuff. I mean, that Google plan that was discussed, that's pretty clean. Employees in Ireland? Yeah, there's people who don't have employees in Ireland. They've got letterboxes in Ireland. You know, this U.S. law permits everything I'm talking about here, everything Professor Christian was talking about, which means that you cannot, at the moment, look to the United States to get you out of this mess. You can't say, oh, heavens to Betsy, United States, your companies aren't paying taxes anywhere in the world. And they'll say, yes, that makes us more competitive. That's what they say. That's the whole discussion in the United States. Okay, but the key to the thing's income is this intellectual property. When this intellectual property, the rights to foreign use of it, are outside the United States, okay, then the income can be kept outside the United States. And that was a lot of what Professor Christian was talking about. That's not what I'm going to talk about. What we're going to do here is we're going to focus, if I stop turning the slide off, we're going to focus on over here where your countries are as the customers, and we're going to see how the money how the profits stay out of your country if this company here, This company is, and this Bermuda thing, by the way, this could be a finance sub. And if it's a finance sub, that is completely a black hole of profits. We're assuming that this company uses this intellectual property in Switzerland to manufacture products here in China with the contract manufacturer, and then they get sold over here in Norway and the other countries represented in this room. Okay, now this plan up here, okay, this is, as our British friends would say, this is bog standard. This is every big American and British multinational has a setup like this for selling goods. Now, so what did we do here? Well, once we got the intellectual property in Switzerland, okay, then we made the product, right? That's our step one here. But notice that we didn't really, what's the sort of old-fashioned model? Well, manufacturer cranks out product. It costs $5 to make the thing, and then product gets sold to, a wholesaler for $50 and then gets sold to a retail customer for $100, right? This manufacturer, and this annoys the Chinese no end, this manufacturer doesn't make any profits. Why doesn't this manufacturer make any profits? Because this holding company in the Netherlands, and this is the holding company for all of Europe, because where there's this limited risk distributor here and this commission agent, there'll be one in each country in Europe where this thing is operating. This holding company in Europe owns, and this is going to sound perverse and legalistic, and it is, instead of the contract manufacturer owning the raw materials out of which the contract, of the stuff, whatever it is made, the principal company owns the raw materials. And the principal company sort of gives the raw materials to the contract manufacturer and pays it a little fee for manufacturing. This does not make the Chinese very happy. The Chinese will look at this and say, wait a minute, you sold that thing for $100 and our cost on that was $5, and you're telling us that this manufacturer makes $5 and on this graph $5.25. We don't think that's fair, and the Chinese will basically take the transfer pricing rules and argue with you about that. Now, the other thing that's happening is the Netherlands principal company, because now remember that it owns the product. It's paying royalties to the Swiss company for a license of that intellectual property, but it is not, and this is another little perverse part, it is not relicensing it to the contract manufacturer. Logically it should, but it doesn't, because it takes the position, well, since it owns the raw materials and the contract manufacturer is limited to a fee, it does not have to do a license there. So the income, really what we think of as the markup on a manufactured product, it is here in the Netherlands. But the Netherlands isn't seeing a lot of income either, and you probably have a ruling from them on this, because the principal company is paying a bunch of royalties to Switzerland, and you can shift a lot of income by paying royalties, and it's paying a lot of commissions to the commission agent. Now it's shipping product off to a limited risk distributor here, and why have I got my arrows wrong? It's shipping product off to a limited risk distributor. No, actually, what is the limited risk distributor doing here? The limited risk distributor is getting paid for product, and it's going through the Netherlands principal. And this is another thing about the limited risk distributor. In the old days, and this country has fought a case on this one, on the distributors. The limited risk distributor is a commissionaire. And that means that it gets a tiny little markup for just moving a product that it does not own. It is what in English law would be called an undisclosed agent. Now, before it got reorganized or restructured, as the OECD says, because the OECD blesses this whole mess. This is called a supply chain restructuring, and the OECD wrote a big, long paper saying, oh, heavens to Betsy, there's real business reasons for doing this. There are no business reasons for doing this. This is a tax setup. But before it got restructured. This little thing right here was a full-on distributor. It bought product from the manufacturer, and it resold product at a markup. And the markup, well, you know, the markup got taxed here in Norway or in Germany or in some real country with a real market and a real tax system where it would have to pay real tax on that markup. So what the restructuring does is it limits the profits that are in this thing. And that means that all the markup on the manufacturing, remember our cost was tiny, it was $5 on $100. All the markup somehow winds up in the Netherlands, where it doesn't really get taxed, and then it will eventually, you know, probably be lent to the Bermuda finance subsidiary to get it out of the country. But this thing is a little circle has been drawn around this to say that, oh no, it's not a distributor. It's not a real distributor, it's a commissionaire, and it's an undisclosed agent, and it only gets this little tiny fee. Now, Norway has gone into court on this one, and Norway lost, because on the same ground that France lost, that was under the commissionaire law. They said, well, it's described as a commissionaire, and heavens to Betsy, a commissionaire is limited to this little tiny profit, so therefore all it has is this little tiny profit, and there's no permanent establishment there. Well, Spain went into court with the same one, pretty much the same case as Norway, and they said, you know what? We understand that buying into the OECD model means that we have to respect those little self-serving contracts that were written between the principal company and the limited risk distributor, but we think that the limited risk distributor here, or the commissionaire here, is not behaving according to the terms of the contract. And because it isn't, there should be a permanent establishment there of the parent, and more profit it should be attributed to Spain. Now, what is that? That's a fight in court. And that's a difficult fight to have, because you have to march into court, and you have to prove that this thing was not behaving according to the terms of its contract. And the Spanish have been doing that, and the Indians have been doing that. And we are going to see in the long run the breakdown of the permanent establishment limitation, and that is a good thing. But when you're talking about smaller countries that are less prepared to fight big taxpayers in court, and are not just making a full-time business of fighting in court, then you really want to think about having other avenues of argument. You may want to think about taking commissionaire out of your law. The basis on which Norway lost the case was the commissionaire rules. What do you need those for? If you had English rules of agency, and you said, this thing is acting on behalf of its principal company, and it's basically earning all the income right here in Norway that its principal company would have earned, you'd be in better shape in court. And that's the kind of thing, and this is my second point about enacting defensive laws. One of the things that the European Commission suggested, they said, well, you know, you should have a general anti-abuse rule. Now, China has a general anti-abuse rule. The United States has one, but our IRS has said that they don't want to enforce it. India is going to put a general anti-abuse rule in its law. But those are very big countries with a lot of resources to expend on tax administration and fighting in court, because a general anti-abuse rule, and there's nothing wrong with them, but they are a ticket to a fight in court. And the reason for that is that they're flexible. They're supposed to cover everything. They say things like, well, if you did this purely for tax avoidance and it has no business purpose, we can unwind the transaction and we can tax you, okay? Now, I've just said three things there that have to be proven in court, all right? You have to prove tax avoidance purpose. You have to prove that you had no business purpose. And, you know, this is not the burden on the tax administrator, but this is a pain in the ass in court. And you have to figure out what the unwind is. This is all very difficult in court. So if you're a smaller country with less resources to spend on tax administration, and you don't have a big, complex economy where there are going to be surprises And what I'm saying here is, you know, if you can sort of look at, you know, what multinationals are doing in your country and say, you know, I have a set of known problems here. I have the oil extraction. I have, you know, this transfer pricing issue here that comes up over and over again. I have, you know, this commissionaire issue. You might want to go for more targeted laws that solve your immediate problems. I mean, usually with a big country, we advise against that. We say, well, if you make a specific law, then they'll just run off and they'll get around that specific law. But in the case of a smaller jurisdiction, a specific law, when the same stuff is happening over and over again, is no bad thing. Because, you know, you go at these guys with a general anti-abuse rule, and they will basically say, oh, heavens to Betsy, that law is vague. They'll say this to the judge. Judges are lawyers. Judges don't like vagueness. We can't know what the law really is because it's so vague. Oh, heavens to Betsy. Okay, how are we doing here? And then that also brings us to production contracts just for a second here. And that is, you know, not production contracts. Don't sign production contracts, for God's sake. Because that's the point of maximum leverage over the multinational that was going to extract the minerals. There is a new line of thinking, and actually the IMF is working on this, that says put stuff in those deals. Put the tax stuff in those deals, sort of get the equivalent of an advanced pricing agreement in those deals. Get conditions that the mineral doesn't move out of the country unless taxes are paid in those deals. Do not sign deals that give the company ownership of the minerals as part of the deal. You want the country to own it and the company to just pay for it. If you're in a situation where, okay, you've got the production contract and the company already owns the minerals, then you want to have in your transfer pricing law a thing that says, look, when the first sale of this stuff is at the world price, which is a very easy thing to find, and it's actually consistent with the arm's length pricing nonsense. I mean, nobody can argue that's not an arm's length price, it's the world price. You also don't have to give them a gazillion deductions from that. And this is the hard part for smaller countries, and that is, do you really want to do things? You know, if I'm dealing with the company and they've got the mineral and they're sending it out of the country, and you're saying, okay, world price for that, and they're saying, oh no, we have transportation costs and we have this cost and that cost, and you know, first of all, you can challenge those costs. Second of all, you can write rules in your income tax law that say you don't have to have deductions for all those costs. I mean, an income tax does not mean unlimited expense deductions for every expense that a multinational can dream up. Like, there's loads of South American countries where management fees are just flat out non-deductible because every affiliate in their countries will pay management fees to the very distant parent who doesn't appear to be doing a whole lot of managing down there in Patagonia. You know, it's just an excuse to move money out of the country, so you don't have to give them every cost. But what that points up is the fallacy of, and I actually am winding up here, so give me some props. The fallacy of going at these guys through a corporate income tax. And that is, you know, yes, they're selling in your country. You want them to pay some taxes for the legal protections and the market they get in your country. Why does it have to be a corporate income tax? I mean, I worked with the corporate income tax forever, okay? I'm really a 600-year-old vampire. That's why I'm dressed like this. and it's a lot of fun, but it is not the easiest tax for a smaller country to administer. The reason market countries have them, and big American companies have gone into countries and asked for them. They said to China, you have to have a corporate income tax, and the Chinese just looked at them and said, because we want the foreign tax credit for that. Oh, well, whatever, you know. But it's a license to a big, long bunch of arguments with the companies. And it's expensive to administer. And there are other taxes that can be collected more easily, that you're not arguing with the OECD about jurisdiction with, like value-added taxes, and that, you don't get a foreign tax credit for it back in America, but there are other taxes that are easier to administer. So if you're in a situation where, it's like you've got a tax administration that's kind of not as much as you'd like, and you've got multinationals on the other side, and they're not paying, you might want to have a rethink and say, well, is there a tax that I can put in that I can collect with the resources that I have? And the answer to that is not usually going to be a corporate income tax, because it's a complicated and messy tax to collect. There's kind of a headline problem there. Multinationals pay no corporate tax, but they pay no corporate tax anyway, so you almost have nothing to lose sometimes. Okay, do I have anything? I think I am okay with this. All right, thank you.
Our next speaker is Daniel Reeves. He worked for 35 years at the IRS. He guided the development of the Offshore Compliances Initiative program and led high-profile tax investigations into the cross-border banking practices of UBS, HSBC, and Stanford Financial Group, among others. He will present to us today a presentation called Offshore Tax Havens and the Financial Community that Promotes, Facilitates, and Enables Them. So, Mr. Reeves, the floor is yours.
Okay, well, thank you very much. This is going to be something slightly different from what you've been hearing. Because, first of all, what I'm going to be talking about is not multinational corporations and how they avoid paying taxes in their home jurisdiction. I'm going to be talking about very high wealth individuals, the uber wealthy, the people who enjoy the best that this world has to provide, who live in multiple homes, and they have servants, and they have yachts, and they have planes, which can come in very handy if you're booked in an economy fare. And yet, despite all of these great luxuries that they have, and despite enjoying the best that life has to offer, they don't think they should have to pay tax. They think all of you should pay tax. In fact, there was a very famous woman in New York City. Well, she used to be in New York City. I believe she's passed. By the name of Leona Helmsley, who ran a chain of very high wealth luxury hotels, and she was very famous for having once said, "Only the little people pay tax." There was also a great singer-songwriter of the 60s and 70s by the name of Bob Dylan, who once said that the times they are a-changin', and Bob Dylan was right. By way of a little personal introduction, my name is Daniel Reeves. As was said, I spent 35 years working for the United States Internal Revenue Service as an IRS agent, and at the time of my retirement, which was only in June of this year, I was IRS's senior advisor on offshore matters. That means that I bring a different perspective to this group. Previous speakers have been academics, lawyers, policymakers. I'm a law enforcement officer. I'm a regulatory compliance officer. My job was to go out and conduct investigations and to develop ways to find people who were using offshore structures, offshore arrangements to hide their money and not pay their taxes. And what I'm going to do in my presentation is to tell you a little bit about what we learned, how we learned it, what we did with that knowledge, and as has been said, and I say this only because it's part of the presentation, I was the individual who led the UBS investigation and the HSBC investigations and the Stanford Financial Group, that's the Allen Stanford Ponzi scheme. And when I say I led those investigations, I want to be clear, I led the civil investigations that resulted in the issuance of John Doe summonses, that resulted in the piercing of the veil of secrecy surrounding Swiss banking and some other things. The criminal matters were a separate investigation. They were parallel investigations that were conducted by the United States Department of Justice. And when I say parallel, that means that we followed separate tracks. It's very important under U.S. law that that the criminal people and the civil people do not cooperate on investigations because it can jeopardize the criminal case. So, let me begin by saying that I first began investigating offshore tax matters in 1999. Prior to that, I had spent about 15 years investigating anti-money laundering programs at gambling casinos around the United States. Through that, I also worked very closely with our FIU called the FinCEN, Financial Crimes Enforcement Network, on developing meaningful regulations for the casino industry in terms of currency transaction reporting and also suspicious activity reporting. And we had considerable successes with those efforts. Because of that, in 1999, the IRS decided that it wanted to create a new strategic initiative, a new project that would look for offshore tax evaders. And the reason for that was because at the time, when it came to offshore, IRS was an agency that reacted, as I think many agencies, many tax agencies throughout the world today still react. What I mean by that is that some piece of information would come across someone's desk and it would indicate that someone might have an offshore bank account. For example, you might be doing an audit of a business, a small business, or a law firm, or whatever, and you would come upon a check, and when you turned the check over, you noticed it was deposited into a bank in Antigua. And you would say, well, wait a minute, what is this all about? So we were an agency that reacted to information, and very often, when we found someone offshore, it was serendipitous. It was by accident. It was by luck. It was just the way things fell out. But in 1999, IRS, I think very wisely, said, you know, we need to look for ways to proactively identify these people. Let's not wait for something to happen. Let's make it happen ourselves. Let's develop some programs that can be replicated time and time again to go out and identify people who are involved in this activity. And because of my experience in the casino industry, where you are dealing with millions and millions and millions of transactions. I don't know if any of you have ever been into a U.S. casino, a Las Vegas style casino or an Atlantic City style casino. There are literally just millions and millions and millions of transactions occurring every single day. And under the law, how do you identify which of those are suspicious? How do you aggregate those for purposes of cash transaction reporting? And what we did, me and my team, was we went into casinos and we studied the problem and came up with solutions. So they came to me and they said, we would like you to become part of a small group that is going to look at offshore tax evasion. And I became part of a three-man task force, three-person task force, which was made up of myself, a brilliant international agent from New Jersey. I'm not going to give you his name only because I don't know if he wants his name out there. And then an attorney by the name of John McDougall, who became my partner as we moved on with this process. We started by studying the offshore industry because for you to be able to go in and audit a company or to be able to investigate a company, you have to understand its business. You know, if someone is running a pharmaceutical business, you can't go in there without knowing anything about the pharmaceutical industry and do an effective examination. So we decided we needed to learn a lot about offshore tax evasion. We studied the industry extensively. We interviewed many people who were involved in the industry, including a couple who were in prison. We attended offshore conferences where the use of offshore for tax evasion was openly discussed and even encouraged. We met with certain subject matter experts who provided us with the benefit of their extensive knowledge. I'll leave it up to them if they want to say who they are. Jack. And we learned a lot and we gained a considerable amount of knowledge about the industry. The project we came up with ultimately came to be known as the Offshore Credit Card Project. Now, the Offshore Credit Card Project was one that we felt would be easy enough to start in the beginning. It came out of our understanding that there were basically 4 components to every offshore transaction. There are 4 standards. And what we did was frame them as questions. And we said, first of all, how did the person come to be offshore? That's question number 1. Is this something that just they happened to be on a plane and they picked a magazine out of the pocket and there was someone in there talking about offshore. Were they in the Cayman Islands on a vacation and there were signs all over the airport about opening up offshore bank accounts? How did they come to be offshore? And then secondly, once they got offshore, how did they get their money offshore? How did they expatriate it? Third, once the money's offshore, how do you control it? I mean, if your money is sitting in a foreign country, you know, how do you make sure that you control that money? And then finally, how do you get access when you want it? How do you repatriate the money? Those are the 4 essential questions involving offshore. And what we did was to look at them as choke points. These were places where information and opportunity came together. And the reason for the offshore credit card project was because credit cards became a very easy and convenient way to repatriate the money, to get the money when you needed it. All of the schemes that we saw being promoted, all of the conferences would talk about, you set up a bank account, we issue you a credit card, and then anytime you want money, you just go to an ATM and take out the money, or you go to use the credit card to pay for your expenses. But the key is none of these were actually credit cards. They were secured credit cards, which meant that behind every single credit card, there was a bank account. And that bank account had to have enough money in it to cover the credit line plus more. And the reason for that was very simply that if a individual defaulted and didn't pay their credit, how was the bank going to get its money? Well, it's very simple. Just take it out of the account. All right. So for us, it became a way of identifying people. So if someone had an offshore credit card issued by a bank in a tax haven, and we could find the use of this card, we could identify where these people lived and who they were, we knew instantly, not only did they have an offshore credit card, they had an offshore bank account. And at that point, it's just a matter of detective work. It's the same kind of work that we do on any other audit. It doesn't matter that the money's offshore. There are some challenges brought by it being offshore, but it's the same process. Go get the records, go analyze them, and if you see a credit card and the credit card had, you know, the person only spent $1,000 on the credit card, that doesn't mean there's not $10 million sitting in the bank account behind it. So that became our first project. And it was very successful. It received a great deal of media coverage. In the 1990s, we were on the cover of the New York Times and the Wall Street Journal above the fold, which is important, especially for a tax case. Well, based on that success, IRS, again, I think wisely, and I give them all credit for this as an organization, decided to establish a new national program. And that program was going to be called the Offshore Compliance Initiative. The initiative would be a strategic initiative that would develop other projects and other methods for identifying U.S. persons with offshore tax arrangements, as well as identifying the banks and the attorneys and the accountants and the promoters and all the others who promote, enable, and facilitate this activity. I was put in charge of the design phase of that, if you will. I was not the manager who ran the operation, the day-to-day operation, but I was the one who guided its development and developed many of the strategies and methods that we came up with. What I'm going to tell you is what we learned through all of that research and about some of the successes that we've had because of it. So first, let me tell you something about the business of offshore tax evasion. And make no mistake about it, it is just that. It is a business. It is a huge business. Various estimates have put the loss to the U.S. government alone at between $40 billion and $100 billion a year. Now, in reality, it's very difficult to measure something when related to offshore banking because there are no records to look at. You have no empirical data that can be analyzed. Because after all, what's offshore is about what's off the tax return, not what's on the tax return. And all of these banks are operating in secrecy jurisdictions, so they're not about to tell us how many people are offshore. So it really became a very difficult process to think of other ways that we could look at this. But the recent high-profile investigations of UBS AG of Switzerland, HSBC in India, and the Stanford Financial Group of Antigua have clarified the fact that whatever the amount is, it is huge. They've also shown that there is a considerable offshore financial industry made up of lawyers, accountants, financial advisors, private bankers, and others who knowingly promote, facilitate, enable, and even encourage citizens of other nations to violate the tax laws of their home country. A senior executive at the IRS once said to me after the UBS case, or not after, but in the midst of it, one of the documents we uncovered was a PowerPoint presentation that had been prepared by an employee, which listed out where all of the accounts were located around the world. And this document is included in the declaration that I filed with the court in Miami. That declaration said that, that PowerPoint presentation said that there were 52,000 accounts, undeclared accounts, held at UBS by U.S. persons. Now, previous to that, the number that had floated around was 20,000. And when that PowerPoint came out showing 52,000, that went viral. This individual came to me and said, you know, up until that I saw that PowerPoint, I thought all these estimates about offshore were probably grossly exaggerated. But he said, when I saw 52,000 at UBS, I started wondering, well, if we add in Credit Suisse and Bank Julius Baer and Wegland and all the other banks in Switzerland, and then we add the ones in the Caymans, and we add the ones in the Bahamas, and Panama, and Hong Kong, and Singapore, you know, those numbers might be pretty accurate or even low. What it did was it quantified we had a serious problem, and that was an epiphany for many people, and for us, what it did is it gave us all of the support we needed to move forward with our programs. And to this day, continues. I mean, my leaving didn't stop anything. Others have just stepped in to fill the void. So what are the tax issues that are involved in offshore tax cases? Well, first of all, offshore tax evasion is all about creating the appearance of international legitimacy while disguising actual beneficial ownership and still retaining personal control, use, and enjoyment of the income or assets. That's what it's all about. And as I said before, this is often aided by a cadre of professionals. Taxpayers will devise schemes that create the appearance of legitimacy, but in substance are really nothing more than shams. You know, yesterday I was intrigued by I'm going to butcher his name, I know, and I apologize in advance, Mr. Arshnez, who talked about the duck standard. You know, if it looks like a duck, and if it walks like a duck, and if it quacks like a duck, it's probably a duck. What the offshore industry does is they like to take that duck and paint it green. And then they want to add some long feathers at the end of it, put some feathers on its head, and say it's a peacock. Now, it may look like a peacock, but I'm here to tell you that, by God, it's still a duck. At the end of the day, under U.S. standards, if we can show that the taxpayer has control of the funds and enjoys personal use of those funds, then that equals ownership of the funds. We take what's called a bottom-up approach. We don't look at everything that's on top and try to drill our way down to find out who owns the money. That's too complicated and it takes too long. What we do is we start at the bottom and see who owns the money, who controls the money, who enjoys the money. And when you see an offshore bank account that's allegedly owned by a corporation, but the monies are all being used to pay for children's education and veterinary bills for the family pet and things like that, you can pretty much say, hey, this is your money. Professor Christian, is that right? Made a statement in her presentation earlier about the recognition of the corporate structure and how it has to be done. And we fought a long battle with our own internal people because many of these involve corporate structures, but they're shams. And we were told from time to time, you must recognize the corporation. It is a formal recognition. And we would say, no, it is part of a criminal fraud. And therefore, we think we should disregard it for tax purposes. Not under the disregarded corporation rules related to CFCs and all that stuff. But I mean, we think we should disregard it. And our counsel, to their great credit, took a couple of cases to court on that issue, and we won every one. Since then, we have continued to win every case. We have never lost a court case related to offshore, period. So let me tell you a few things about offshore, and some of this may be repetitive, and if it is, I apologize. I didn't get to see everybody else's PowerPoint before I did this. But hopefully it'll be explanatory and we'll build upon this. But you know, there are three elements to offshore. There are offshore jurisdictions. They are the ones who offer certain advantages to non-citizens. You heard about this earlier. There are offshore banks who offer services to clients domiciled outside the jurisdiction. And then there are offshore transactions that occur outside the country of residence. But it's really the financial secrecy laws that are at the heart of everything. Financial secrecy affords confidentiality to financial transactions, and this can be either by enactment of law or simply by other means. For example, there are civil laws in some countries that establish banking secrecy. In some places, there are criminal laws, such as Switzerland. In Switzerland, it is a criminal violation to release information about clients. Jack Blum had a very famous client named Rudy Elmer, and it's all public, so I can say it, named Rudy Elmer, who presented some CDs to Julian Assange of WikiLeaks, and was promptly arrested by the Swiss government and spent how much time in jail? 6 months in prison. Okay? Criminal violations, and they take it very, very seriously. Other places, it's simply a matter of bank policy or industry practices. Either way, if it's offshore, there are going to be problems in getting it. Now, I want to emphasize here that we're not talking about financial privacy. I'm a big believer in financial privacy. I want my financial matters kept private. I don't want any of you in this room to know anything about how much money I have or how much of it is offshore. I don't have anything offshore. But if I do, you'll never find it. We're not talking about financial privacy. Financial privacy is the right to keep your financial affairs to yourself, to your bankers, to your attorneys. But there is an openness in the event of certain events that allow, through due process of law, certain people to get access to that information. Certainly, if you're in a partnership with someone running a business, and it looks like the partnership may be dissolving, you don't want your partner running off with all the money and hiding it in a bank account where you can never find out. Even with a court order, you can never find out how much money is in that account. That's secrecy. Secrecy is no one will ever know what you have except you and your private banker. And while my business was tax evasion, secrecy allows for all kinds of criminal activity beyond just tax evasion. Some of it the most heinous, human trafficking and all the other stuff that has been referenced by some of the people here in the room. So we're not talking, when we talk about this kind of secrecy, we're not talking about financial privacy. We are talking about absolute financial secrecy. So who are the offshore players? Who are the people involved in this? Well, first it is the offshore jurisdictions. Then it is the financial institutions, and finally the offshore professionals. Who are they? Well, the offshore jurisdictions provide the financial secrecy laws. They provide for a low or no tax on the conduct of business that takes place outside their borders. They provide favorable laws for corporations, trusts, foundations, and other legal entities or arrangements. And they work closely with the offshore financial and professional sector. Financial institutions, these are banks, private investment firms, private banks, brokerage firms, insurance companies. They actively promote offshore investment. They assist in the creation and execution of offshore schemes and offshore entities. And when I say schemes, I want to be clear. I'm talking about something that is I won't say fraud, but it's a sham. It's a, I know the term scheme. I was in Great Britain one time and I made a presentation talking about schemes, and apparently scheme is over there used in tax not as being anything nefarious. It's the scheme is the setup that you have. But to us, it means something that is nefarious. They facilitate covert control of the offshore assets and income, and they even provide false documents and false statements. So that if you, you know, that very often what we found was that in some of the Caribbean countries, there were passwords involved. Each account was issued a password. And if anyone wrote correspondence to the bank that did not include the password, then the bank did not reply because they knew that it was probably being written because the IRS or some other agency had asked for the information. So they facilitated that kind of control and secrecy. Offshore professionals include attorneys, accountants, promoters, trust companies and trustees, private bankers, brokers, financial advisors, and company service providers. And it's important to note here that not all of these people have to necessarily be in the tax haven. These people can be anywhere. Many of them are in New York and Chicago and Los Angeles and San Francisco and London and elsewhere. And they are setting up the very structures using offshore entities that I'm talking about. I'm going to show you a couple in a minute. So working with one another, these offshore players create an environment of anonymous ownership of assets and discrete control that allows beneficial ownership of entities to remain hidden. These two concepts are the cornerstone of offshore. So what kinds of entities do get used? Well, the most common forms are the International Business Company, or IBC. An IBC is a personal corporation. It's your corporation. It can be structured in a variety of ways. We've heard talk of nominee directors and such, and it varies according to jurisdiction in some cases. But essentially, an IBC is your personal corporation. It is there not to conduct business. It is there to do one thing, and that is not have you identified as the owner of the assets of the funds. I'm going to show you how an IBC gets used in a minute. Also, foreign trusts, foreign partnerships, foundations. Foundations are big in Liechtenstein. Personal investment companies. Protected cell companies. This is a fairly new concept. Lee and I and Jack attended this conference in Miami that he referenced a minute ago. And there was a presentation made at the conference about a new concept called a protected cell company. And it was promoted as a way that you can limit your liabilities but create the appearance that you're actually something much bigger. Think of it as a honeycomb, a bee's honeycomb. You own one little cell. Other people own the other cells. Your liability is limited to the one cell, but the appearance is that you're something much bigger. In insurance, that could be huge. But you can do other things with protected cells. You can buy 2 or 3 protected cells, and you can name one as a consulting business, name another as a legal practice, name another as whatever, and now you can start writing checks out of your business to pay all these business expenses and deduct them on your tax return, lowering your income. And if the IRS ever questions you, I hope I'm not giving people ideas here. If the IRS ever questions you, you're going to have all the documentation you need to support your claim. Why? Because you're going to create it. It's your company. They're all your cells. I can't say the last one. I can't pronounce it, but it's okay. These are used in Mexico to own property, I believe. Correct, Jack? So let's go over the basic structure of how this all works. And I'm talking about for tax purposes now. That's my area. I leave the others to the others. But basically what happens is a foreign taxpayer will go into a foreign jurisdiction and form an offshore entity, usually an IBC. They're cheap to form. They're easy to acquire. They've gotten easier over time. Someone mentioned earlier, I forget who, and I apologize, but the British Virgin Islands, this is like their primary business. The British Virgin Islands is a small island in the Caribbean. I forget how many square miles or kilometers they are, but it's about the size of Washington, D.C. They have a population, I believe, of around 19,000 people, most of whom are involved in the tourism industry. And as of the end of 2007, there were over 900,000 corporations, IBCs, registered there. You could register one tonight from your laptop. They have a portal that you can go in, and it's just like buying something from Amazon.com. You go in and you put in your name and what corporation you want to be known as. You give them your credit card number. They'll charge your credit card number, and very shortly thereafter you'll have incorporation papers. Now you can go out and open yourself an offshore bank account. And normally what's going to happen is you're going to open up an account. You're going to have one account. This is not required, but it's what we see more often than not. You're going to have one account which is going to be the account that you use for repatriation when you need it. And then all of the other ones are going to go into various investments. Because at the end of the day, you know, you're not going offshore for the interest income, unless you're putting millions and millions offshore. You're going offshore to invest, usually into U.S. securities, because U.S. securities, people who invest in U.S. securities from foreign countries are exempt from tax in the United States. That's like our little tax haven, our contribution to the tax haven world. If you're a foreign national and you invest in U.S. securities, you're exempt from taxation on gains and losses. So guess what? You form an IBC in the British Virgin Islands, and what are you now trading as? A foreign entity. So what happens is you form the corporation opens the bank account, and you're now in business. Now it's just a matter of getting money into the account and getting it out. Very often, a foreign trust will be put over this entire arrangement to further obscure it. You're creating multiple layers of secrecy here. And remember what I said about the top-down approach. If we start at the top and start drilling our way down, what you have to do is you have to look at that trust and find some way to vacate it and say it's not real. Once you get through it, now you've got an IBC. Now you've got to do the same thing with the IBC before you can get to the bank account. And what if the trust was in St. Kitts and the IBC was in BVI and the bank account was in the Bahamas? Now on top of everything else, you've got 3 different legal jurisdictions to fight that battle. It becomes very difficult and very complicated. Ultimately, however, that foreign taxpayer is going to continue to own, control, and personally enjoy all of the funds that are in those accounts. Now, these schemes, this is a simple one. These can get very complicated. This is an actual exhibit from a slide that was submitted to Senator Carl Levin's Senate Permanent Subcommittee on Investigations related to his a report by his subcommittee called Tax Havens, the Enablers. I forget the name of it now, but it's, you know. And basically what they held hearings, and this particular scheme related to a strategy called the point strategy. Basically a U.S. tax shelter promoter, remember I said they don't have to be in the country, a U.S. tax shelter promoter concocted a scheme that was based on fabrication of billions of dollars of fake securities transactions that were used to generate billions of dollars in fake capital losses that were then used to offset real taxable capital gains of U.S. taxpayers so they could avoid paying taxes in the United States. The point strategy or the point transaction was carried out under secrecy laws with the knowing assistance of trust companies and corporate management companies in the Isle of Man and the Cayman Islands that allowed the true nature of the security transactions and entities to be hidden. Prominent law firms in the United States collaborated with the promoter in the development of the legal basis for this strategy. Prominent U.S. and foreign financial institutions provided the financing, planning, technical assistance for the execution of the transactions, knowing full well that they were designed to avoid paying taxes in the United States. At the end of the day, however, all of the transactions were phony and no real losses were generated. Basically what happened is they set up all of these schemes, and what you see here is all of these are all entities and trusts and things that all of this stuff they were selling to one another, but the only things that really mattered were the Barnville and Jackstone trusts. They were the only 2 real things that existed, and basically what they were doing was trading back and forth. So what would happen would be Barnville wanted to buy stock from Jackstone, didn't have the money, so it would borrow the money from Jackstone to buy the securities, and vice versa. And all it did was create phony losses to offset real capital gains and avoid paying tax. In another example of the same hearing, the committee documented how two brothers from a very wealthy family in Texas controlled, personally enjoyed, and beneficially owned millions of dollars in securities, real estate, business ventures, art, and jewelry through a single offshore structure, one offshore structure that involved the use of 19 offshore trusts, 39 offshore corporations, and multiple offshore jurisdictions. So when Jack talked earlier about how these white shoe law firms will sit in New York or wherever and come up with all of these strategies, he's exactly right. If the amount of, I've often wondered if the amount that these people pay to their attorneys is more than the amount they save in taxes. I've often wondered that. So what are some common offshore tax schemes? Once you've got this structure in place, the simple structure, I'm going to keep it simple. What are some of the common strategies that people use to move the money offshore? Because that's one of those 4 questions we talked about. Well, first is the use of sham entities to hide ownership of assets. Sham entities are things like these IBCs and these trusts that are not real. They're only set up for purposes of disguising true beneficial ownership. Diversion of income, mirror corporations. Mirror corporations are where you have a corporation, and I'm going to talk U.S. here because I don't know your individual jurisdictional laws, okay? But in the U.S., you could have a medical practice could have an account. They could be incorporated, could be known as Reeves Medical Incorporated. Well, you go to the Bahamas, or you go to the BVI, you form an IBC, and you call it Reeves Medical Inc. Not Inc. Ltd. Limited. So now you've got Reeves Medical Inc., Reeves Medical Ltd. They are mirror corporations. Now when your clients come in and write checks to you, assuming that they write checks, I know checks are going by the way, but assuming that they write checks to you, they just write them out to Reeves Medical. I can deposit some in my U.S. account. I can put the others, bundle them up, stick them in a FedEx, and ship them off to the Bahamas. When the IRS comes in and audits me, I pull out all my bank statements from the U.S. bank account, and guess what? Everything ties perfectly to my tax returns because nobody knows that there's this other account sitting in the Bahamas. Another is offshore merchant accounts. This is one of my personal favorites. There was a mild reference to it earlier, although it wasn't called this. But offshore merchant accounts are where you, if you're engaged in business and you want to accept credit cards and debit cards in your business as payment, and if you're in an online business, you have to. That's the only way you can get paid. What you need is you need a bank account somewhere that the proceeds of all those, your sales, can be deposited at the end of each day by whoever's doing the processing for your accounts. It may be a big processor like First Data Corporation or one of these, or it could be a smaller company. It could be a bank. It could be anyone. But you need somewhere for it to go. Well, guess what? You form one of these IBCs in BVI, and you're now a British Virgin Islands corporation. And you can open up a bank account and have all of your proceeds deposited into an account there. For purposes of who owns the money, both Visa and MasterCard have regulations that say that the business has to have a merchant account wherever the business is physically located, and in cases of businesses that have no physical location, it is where they are incorporated. Well, where are they incorporated? And you know what's really interesting about that particular dichotomy? An IBC is not allowed to conduct business in the tax haven in which it's incorporated. That's part of the concept of an IBC. It's got to be outside the area. So what you've got is an entity being recognized as being a BVI corporation that's not allowed to conduct business in BVI. So how can it be in the BVI? I mean, it's very confusing. It gets very confusing. There are also various false deduction schemes. There's false invoicing. As I said, you set up one of these protected cells. You call yourself a consulting business. You send yourself a invoice once a month for $10,000 consulting fees. You write a check, pay it, and you deduct on your tax return. Guess what? You're moving $120,000 a year to your offshore bank account and getting tax deductions for it. All right? Re-invoicing is basically a small-scale transfer pricing arrangement. You know, a optometrist who sells glasses buys all of his supplies through an offshore company. He pays $5 for each pair of glasses he buys. Each frame costs $5. Then his offshore company turns around and sells it to his U.S. business, charging $10 a pair. He's moving $5 offshore for each pair of glasses. All right. False loans. You know, people who just have moved the money offshore and then they lend themselves the money, and then when they repay it, they pay interest to themselves, and then they get tax deductions for the interest that they paid. It's not on the screen, but one of my favorites that I ever saw was someone who set up a charitable scholarship kind of program for people who wanted to go to college, where they could apply to this organization and they could get full 4-year rides to college. And the process was you had to apply, you had to write an essay, you had to do certain things, and then the committee would decide who got paid. The only people who ever actually got a scholarship were the 2 daughters of the people that owned all the money. So basically they got to pay for their Harvard education and have all of us law-abiding citizens in the United States pay for it. So what can governments do? When am I supposed to get off? I'm like Lee, I don't know. 2 minutes? Okay, let me wrap it up. What can governments do? Well, first of all, some are obvious. Enhance international cooperation. This was talked about. TIAs, you know, tax information exchange agreements, treaties, mutual legal assistance treaties. All these things are useful. The problem is they all have limitations. Many of the TIAs actually only allow for them to confirm information that we already have in our possession. So if we go to some of these jurisdictions with a TIA request and say we know that this individual has a bank account, here's the account number. They may give us the information on that account, but they won't tell us that there are 3 other accounts owned by the same person at the same bank, and that's where the money really is. Okay? There needs to be better information sharing between agencies, between taxing jurisdictions. There even needs to be some joint ventures. There are certain opportunities where the promoter is located possibly in Norway, and the processor is in the United States, and the bank is located in Germany. Why can't we all work together to stop this, as opposed to fighting territorial battles? You know. Very quickly, since I'm running out of time, I know there's interest in the UBS case. I'll just tell you a little bit about the UBS case. You know, on October 12th, 2007, I first met with a gentleman by the name of Bradley Birkenfeld, who was a U.S. citizen working at UBS in Switzerland. He was in a unique position because he was a U.S. citizen subject to U.S. laws, working at a bank in Switzerland. I interviewed him, and based on his information and other information that we came into possession of, we filed a petition with a court in Miami asking for permission to issue a John Doe summons. John Doe summons is a very unique kind of a tool that we have available to us that allows us to gather information on people when we don't really know what their identities are. The islands like to refer to these as fishing expeditions. That's because they want to try and denigrate it, but the fact is we are fishing in waters where we know there are big fish. And we are presenting that to the court and saying, here's where the big fish are. Can we get a fishing license to go in there and drop our nets in and bring some of these back home? So if it's a fishing expedition, and I am a fisherman, I like to go fishing, it's a pretty good one. But there are standards that have to be obeyed. So it was approved by the court. Then in February of 2009, UBS entered into a deferred prosecution agreement with the Department of Justice in which it acknowledged participating in a conspiracy to defraud the United States and IRS of lawful tax revenues. As part of the settlement, they agreed to pay $780 million in settlement charges. They agreed to exit the U.S. cross-border business and provide the U.S. government with the names and account information on certain U.S. clients. 6 months later, well, actually, the very next day, we went to court and filed another petition seeking enforcement of the John Doe summons. That went gangbusters. And 6 months later, in August, literally, I was in court in Miami. The courtroom had as many people as are here, and everyone was a journalist except me and my lawyer. And literally 5 minutes before we were scheduled to take the stand, they announced that a potential settlement had been reached. The nature of that settlement was that UBS and the Swiss government agreed to turn over to us the names and account information of approximately 4,450 high-wealth U.S. clients who, according to the bank's records, had accounts valued at more than $18 billion. The standard was the account had to be owned by a U.S. person, and it had to have more than 1 million Swiss francs in it. The investigation showed clear evidence that UBS was involved in very unusual activity. I mean, it was very much like out of a James Bond novel. They were training their employees to avoid detection, to cross the border, fill out those forms you fill out when you enter a country, fill them out falsely. They carried encrypted laptops. They had secret codes that they used for communications. It was quite interesting. Since that time, IRS and DOJ have continued investigations. In February of this year, the U.S. announced a criminal indictment against Wegland Private Bank, the oldest private bank in Switzerland, that it had helped wealthy Americans hide more than $1.2 billion from the IRS in secret accounts. We've also filed indictments and criminal charges against 19 employees and former employees of various Swiss banks, 5 independent financial advisors and attorneys who assisted them, and 41 U.S. taxpayers who used undisclosed accounts at various foreign banks to commit tax evasion. Interestingly, the criminal charges against Wegland and its financial advisors are against people who actually live and work in Switzerland. They're not U.S. citizens living and working in the United States. And what this has shown is the change in attitudes towards global competition and global law enforcement, in the sense that we have been able to successfully obtain criminal charges against them. Now, granted, we can't go out and arrest them because they're on foreign soil, but if they ever enter the United States, or if they ever enter a country in which we have extradition treaties, they could be facing some serious jeopardy. More important than that, their reputations have been ruined. Anybody who stays with them and lets them continue to control their money is only asking for trouble. Finally, I will just tell you that that we also, in order to deal with the extensive number of cases we expected, we announced a voluntary disclosure program where people could come forward voluntarily and self-disclose the assets. It was not an amnesty program. It's been referred to as an amnesty program. It was not. You did not get amnesty. What you did is you avoided criminal prosecution, and in return you had to pay your tax and your interest for 6 years. There were certain penalties that had to be paid, and you had to pay a one-time penalty equal to, it grew from 20 to 25 and then 27.5% of the highest value in the account at any time during that 6-year period. So it was a very no one got amnesty. It was very substantial. I will tell you that as of today, well, not as of today, as of about 2 weeks ago, the Commissioner of IRS, in his departure statement, he has moved on, announced that we are now at 38,000 of those have come in, and we have collected more than $5.5 billion in tax that previously was not collected. More importantly, all of these people are now back in the tax system, and they will be paying their taxes for years and years to come. And more importantly than that, one of the conditions of coming in is that they must agree to, or they must consent to meet with someone who used to be on my staff, no longer, and tell all about who put them there, who helped them, who set them up, how was the whole thing done, and that will just lead to more and more cases. So as I said, Bob Dylan once said, the times they are a-changing, and they are. We're not there yet, but we're getting there. So with that, I apologize. I know I probably ran over, but let me just say that I hope that you've enjoyed it. I hope you learned from it. But what's really important is I hope it helps you as you move forward with doing the very important work that all of you are doing. So thank you very much.
We've come to the 8th and final presentation of the day. Yesterday you heard about the Abacha case and how that money was retrieved. We have a similar story here in Norway, the Yara case, where the large fortune of a Norwegian businessman was left offshore, and it took almost 30 years to retrieve that money. The sum that was eventually returned to Norway was about 1 billion Norwegian kroners. And we will hear more about this story from one of the lawyers who was central in retrieving the money. Mr. Karsten Espelid is a partner at the Norwegian law firm BAR. He is originally from Bergen, but now lives in Oslo and works at the headquarters of BAR in Oslo. He is a former prosecutor and deputy judge, and together with his colleague Even Var Hansen, Espelid was appointed to manage the Anders Yara estate, and just recently finished that very, very long process of retrieving a very large amount of money. And we'll hear more about the story from Mr. Espelid now.
Thank you very much. Thank you for being invited here. My talk is about the Yara case. And the Yara case, what is it all about? 3 main issues: hidden assets, locate the assets, repatriate them. Very clear and easy goals, but very, very difficult to achieve, and not to forget, involving enormous costs. As Mr. Rønneberg already told you, my name is Karsten Espelid. I'm born and raised in Bergen, but I do live in Oslo. And as we all have experienced the Bergen weather over the last days, you do understand why. And I am, as also told you by Mr. Rønneberg, a partner of the law firm BAR in Oslo. And this is our new building. The architect is Mr. Piano, worldwide known. But this has nothing to do with the Yara case, except for some money I placed there through our bonuses. This is the content. And I start now at the beginning of my speech, the introduction. BAR, the law firm I'm a partner of, is perhaps best known as a commercial law firm, but has considerable experience in dealing with litigation, restructuring, and insolvency matters. Before the Yara estate, we were, for instance, involved in the estate of another famous Norwegian ship owner, Hilmar Reksten, who operated out of Bergen. And a short story from the Reksten case, which I also litigated, is that that took place in Bergen, partly, and I had to go to a shoe repair with my shoes. And when he saw me, he said, "No, Mr. Espelid, you can't call for any services by me." So that is a sign of the local patriotism in Bergen. While the estate of Anders Yara has been under public administration since shortly after his death in 1982, we, BAR, have only acted as administrators since 1991. That is to say, for more than 20 years. In connection with the recent winding up of the estate, a comprehensive report from the administrators have been made publicly available in Norwegian only, and you will find it on BAR's homepage. The purpose of my speech today is to address some of the challenges we were faced with on behalf of the estate in our quest to bring Anders Yara's foreign fortune back to Norway. As a background, I will first say a few words about Anders Yara and how his foreign fortune was built up and concealed. This is a picture of Mr. Yara, highly decorated, as you can see. Anders Yara was born in 1891 in Sandefjord, Norway, where he lived and worked until his death in 1982. Anders Yara, mind you, practiced as a lawyer in his hometown until 1928. But already in the early 1920s, he began to engage himself in the whaling and shipping industries. He invested in many whaling and shipping companies and personally formed several companies to conduct various administrative and operating functions. The most important company associated with Yare was Cosmos. That's a clean entity. An entity operating out of Sandefjord and managed by the firm of Anders Yare. In addition to being a successful businessman, Anders Yare made contributions to society, inter alia by forming several foundations for the promotion of scientific and humanitarian objectives. He was regarded a major philanthropist and was honored with the Royal Norwegian Order of St. Olav in 1950 and 1962, as well as an honorary professorship at the University of Oslo in 1961. So, as you can imagine, Anders Yare was a highly respected shipping and industry magnate, both in his hometown of Sandefjord and within the Norwegian society at large. There is, however, another side to the picture, namely Anders Yare's hidden funds overseas, his foreign fortune. And that leads me to my position here. The solvent estate of Anders Yare deceased, the estate. Investigations by the tax authorities that had been initiated before Anders Yare's death in 1982 resulted in a tax claim being levied against his estate in 1983 in an amount of in excess of 335 million Norwegian kroner, the largest tax claim that had ever been assessed in Norway for tax avoidance. The estate was thereafter treated as an insolvent estate, its liabilities exceeding its assets. The main creditors of the estate are the municipality of Sandefjord and the Norwegian government, represented by the tax collector in Sandefjord. After Anders Yare's death, the administrator of Yare's estate came into possession of documents that confirmed Yare's unlimited control over a period of more than 40 years to conceal that control from the authorities. And the unlimited control was over foreign assets. Such control has subsequently been confirmed by two Norwegian judgments in 2002 and 2003. Thus, he was regarded as the true beneficial owner of the assets in question. At the time of Yare's death in 1982, the value of the assets remaining in his foreign fortune totaled some $80 million. There is no other known instance in Norway of tax avoidance on such a large scale over such an extended period. A few words about the background to the Yare case, and then I'm going into the foreign fortune as such. In his lifetime, Anders Yare built up and managed a considerable fortune outside Norway via companies registered in Panama and elsewhere. In 1939, Panko's operating company SA was incorporated as a Panamanian corporation. Throughout his lifetime, Anders Yare consistently maintained that he had no ownership interest in Pankos. Only after his death was it established that Yare had controlled this company from the day it was incorporated, and that from the 1950s onward he had been its sole owner. During the 1950s, the Norwegian authorities commenced an investigation of Yare's connections to Pankos and other foreign companies. In response, and in order to conceal his ownership interest, Yare claimed that these companies were owned by Aristotle Onassis. The investigation was put on hold when Yare suggested that it might be possible for Norwegian companies controlled by Yare to purchase Pankos et al.'s floating assets from Onassis at market price. Such ships would in that manner become Norwegian flagged vessels, which at the time was considered an important objective by Norwegian authorities. This had to do with currency situation in Norway. This solution was accepted, and as a result, large sums were transferred abroad to companies ostensibly owned by Onassis. The net result of the transaction, however, was that the cash generated by the sale of ships was consolidated with Pankos' other assets and became a major part of Yare's hidden fortune, foreign fortune, a fortune that grew substantially in the years thereafter. To conceal his connection with Pankos, Yare secretly changed the name of the company in 1958 to Continental Trust Company CTC. Pankos' minutes, as you can see here, of the extraordinary general meeting in 1958, at which the renaming of the company was resolved, demonstrate Anders Yare's full control over Pankos CTC. And you can read it by yourself. Mind you, that it states that all shares were represented. Well, I can tell you there were hardly any shares issued. So this is the way they fabricated the renaming and set it in for registration. Pankos was known to the authorities, the name. CTC was unknown. But CTC continued business was conducted quietly, however. And it was only after Anders Yare in 1972, on behalf of CTC, promised the Sandefjord municipality a 40 million Norwegian krona donation for the building of a new town hall that Anders Yare's foreign interest again attracted the attention of the authorities. The town hall donation to the Sandefjord municipality generated lengthy correspondence between Norges Bank. Norges Bank is the equivalent of the Norwegian Central Bank, and Anders Yare. Starting with the question whether Norges Bank would issue a foreign exchange license for transfers to the Sandefjord municipality from CTC's account in Sweden. Anders Yare categorically denied having any ownership interest in CTC. After 1972, the Norwegian authorities' interest in Anders Yare's relations with CTC showed no signs of abatement. It gradually became clear to Anders Yare and his helpers that the focus on his foreign fortune would make it difficult for him to repatriate it to Norway in the short term. Efforts were therefore commenced to reorganize the ownership of CTC in order to create a formal structure whereby Anders Yare could retain control of the funds abroad without appearing to have any involvement in the company. With help of Bjørn Bettum, who by then played a leading role of Cosmos and the firm of Anders Yare, and Lazard Bank London, an ostensibly charitable trust was formed in 1976 under Bahamian law, later Cayman Island law, under the name of Continental Foundation to act as the formal owner of the shares of CTC. Since Anders Jahre could not appear as the settlor of the trust, as this would reveal his ownership interest in CTC, the Norwegian in exile, Torleif Monsen, was appointed as the nominal settlor. Continental Foundation was organized so that no single person could acquire control over it or its funds. Formal control being exercised jointly by the appointed advisors. This is in accordance with the structure of trusts in Cayman and Bahamas. And the appointed advisors were Torleif Monsen, the in exile Norwegian, Hugo Kindersee from Lassad Bank, and a third person connected to Lassad Bank. In addition, Lassad Bank had a central supervising and controlling function for the purpose of safeguarding compliance with Anders Jahre's intentions and interests. Bjørn Beckton, Mr. Jahre's right-hand man, was instrumental in the establishment of the trust, but did not personally have any formal position in it. Sorry, I moved too fast there. Some words about the state's legal actions, jurisdictional obstacles. The whole estate has been full of litigation. I don't know how many court instances I've been through, but it's a number of them. Many, too many. And this is a result of the fact that the estate has brought a number of legal proceedings in order to recover assets. The cases have involved the following jurisdictions, mainly Norway, UK, the Cayman Islands, and the US. Matters involving parties from around the world are almost bound to cause jurisdictional complications. The Jahre case is no exception. In 1994, that is to say 3 years after we were appointed, the estate brought a claim against 82 persons and companies before the Chancery Division of High Court in London, UK. Several of the defendants did not have legal venue in London, but were included due to their connections with the events and certain central London-based defendants. The choice of London as venue was also desirable from the estate's perspective due to the renowned competence of British courts and their highly skilled and respected judges. Objections to the court's jurisdiction were raised, and a preliminary hearing in London for the purpose of determining jurisdictions was scheduled to take place in 1995. In the meantime, the estate was sued in the Cayman Islands by certain parties related to some of the defendants in the UK proceedings. The estate saw this as a counter-move to the proceedings in UK, and therefore moved for a stay in the Cayman Islands proceedings, pending the outcome of the UK proceedings. The estate was unsuccessful, and as the Cayman court began to deal with the merits of the case, while the estate's appeal with regard to jurisdiction was still pending, well, the estate was left with no choice to renounce its objections. Subsequently, the estate even withdrew its action from the UK court in order to fully focus on the Cayman Islands proceedings. It is fair to assume that the Cayman Islands proceedings were initiated by the estate's opponents largely on the assumption that the Cayman Island court would look more favourably at the arrangements the estate was challenging than the UK court. If so, the plaintiffs were not disappointed by the court of first instance, the Grand Court of Cayman Islands, situated in Georgetown. In the estate's experience, the court was dragging its feet. Furthermore, and mind you, the court approved the use of trust funds to finance the defense against the estate. Conversely, the estate was obliged to finance the costly litigation from the estate's own funds. However, subsequent judgments by the Court of Appeal and the Privy Council — the Privy Council is the answer to House of Lords within the Commonwealth, constituted by 5 judges, 3 of them recruited from House of Lords and 2 from the various islands in the Caribbean. It was judgments subsequently from the Court of Appeal and the Privy Council. They were both in favor of the estate. Those 2 judgments confirmed the estate's view that Continental Foundation was not a validly established trust. These judgments altered the entire attitude of the Grand Cayman Court towards the estate. So although the Cayman Islands judicial system eventually stood the test, one can easily imagine that jurisdictional matters may have great impact on the possibility of fighting economic crime. Some words about the results and the recoveries and the funding. Through settlement agreements and judgments, the estate has recovered in total, including interest, 1,060 million Norwegian kroner. The net assets for distribution to the estate's creditors are some 420 million Norwegian kroner. This shows that the costs have been formidable, amounting in total to 600 million Norwegian kroner, plus a 40 million Norwegian kroner profit sharing with a third party. So, what does this tell us? Asset tracing through cross-border litigation is extremely expensive. In practice, only states or solid group of companies will be able to raise and risk the funds required. The portion of the Yara estate, the assets that was easily available to the estate, was relatively limited in size. When the estate brought legal proceedings in the UK in 1994, much such assets, around 40 million Norwegian kroner, had been spent, and the estate was dependent on third-party financing to pursue its interests in the courts. Attempts were made to obtain private financing, but no responsible institution was willing to take the risk involved in such a project where the outcome could easily be zero. In light of the fact that the main creditor was the tax creditor, the Norwegian government proposed provision of a guarantee of up to 100 million Norwegian kroner in order to cover expenses and any liability in connection with the administration of the estate. This proposal was opposed by the right-wing Norwegian Progress Party, Fremskrittspartiet, but was ultimately approved by the Norwegian Parliament, Stortinget. The initial guarantee was increased in 1998 over the opposition of both the Norwegian Conservative parties, Fremskrittspartiet and Høyre, by an additional contribution of 50 million Norwegian kroner, that is to say, in total 150 million Norwegian kroner plus interest. Throughout the period when the original guarantee and later its increase was under Parliament's consideration, both Bjørn Bettum and Anders Jares Humanitarian Fund had actively opposed state financing of the estate activities, often in coordination with conservative elements in Parliament. The guarantee financing was nonetheless approved, the majority in Parliament being motivated, in part, by a desire, a clear message, to send a clear message that those involved in tax avoidance would be pursued no matter the cost. From 1994 and up to January 2002, the estate's accumulated expenses, including interest, under the guarantee amounted to 176 million Norwegian kroner. That amount was repaid to the state in January 2002. Excuse me. In summary, without state financing, it can safely be stated that the estate would not have been in a financial position to trace assets and bring lawsuits in various jurisdictions to recover and repatriate the foreign fortune. We were absolutely dependent on the guarantee from the government and supported by the majority of the Parliament. I will now deal with some secrecy aspects, since that is the heart of today's issue. We haven't been touching upon the banker confidentiality, but that's one important one. And I'll start out with that, because that was a major hurdle which we had to pass. And which we passed, but not without complications, and not without involving the courts. I start out with the case against Lassad et al., banker confidentiality. When Anders Jahre died, the foreign fortune was not made available to the estate. Shortly after his death, the acting administrator of the estate contacted Lassad Bank, among others, seeking information regarding CTC's assets and Jahre's other holdings. In response to specific inquiries, however, Lassad withheld essential information and failed to provide the information necessary to repatriate the foreign fortune. In doing so, Lassad misled the estate and gave the impression that Jahre did not own CTC. A key issue at the time of Jahre's death, and in the years immediately thereafter, was whether Lassad was prohibited by a contractual duty of confidentiality from providing the requested information to the estate, where such information had been obtained by Lassad in the course of providing banking and related services to Jahre and or CTC. In England and most countries, there is a general principle that bank owns a duty of confidentiality to keep its customers' affairs secret. Not surprisingly, that's common. It may not divulge such confidential information to any person other than the customer. And Lassad relied upon this privilege. During the legal proceedings in Norway, the estate alleged that under Norwegian law, the administrator, we, were walking in the legal shoes of Mr. Jahre, and that Lassad was therefore under an obligation to make disclosure of what it knew concerning Jahre's hidden foreign assets. Lassad disagreed and maintained its position for many years after Jahre's death that it was unable to provide the requested information. During the legal proceedings in Norway between the estate and Lassad et al. In the late 1990s, the bank was to a large extent compelled by the court to produce the documents and information as requested by the estate. It had taken some 15 to 20 years after Jahre's death, however, before the estate, through court compulsion, finally obtained the documents and information it had been seeking all along, and which pointed to the assets' locations. We have heard several of the speakers talking about trusts. Trust is a very complicated concept, in particular seen with Norwegian glasses. It has nothing to do with the Norwegian Stiftelse, which is a separate entity regulated under Norwegian law. But trusts are very common in England, in Commonwealth, and in all of the jurisdictions down in Caribbean, and not to forget in Liechtenstein, where they also have anstalts and fondation, and in Switzerland too. But now I'm talking about trust, insight into trust domiciled mainly in Cayman Islands and many of the tax havens in the Caribbean. For those seeking to place assets beyond the reach of creditors, offshore asset protection trusts offer secrecy and freedom from taxation, while preserving the trust set laws absolute control over trust assets. Yare's Continental Foundation was an example of this type of trust. By way of example, the formalities for creating a trust in Cayman Islands could hardly be easier. There are 3 essentials: find a trustee, agree the terms of the trust, and transfer the property to the trustee. In the usual case, the terms of the trust will be set out in a document signed by the set law and the trustee, called the trust deed or the memorandum of agreement. The creation of a Cayman trust is ordinarily a private transaction involving no filing of documents or information with any government authority. So you need the document at hand to see that there is a trust, who contributed to the trust, the name of the set law, and so on. There's no registry. Furthermore, in general, there are no taxes or government charges on the creation or funding of a trust or on its operations and distribution. But there is a stamp duty of USD 50 to be paid on every trust instrument. That has to do with the validity side of the document. But indirectly, this is another way of securing income for the financial department in each island down there. It is often decided that this trust structure should include one or more holding or investment companies. In other words, the assets of the trust may often comprise shares in a holding company, with the actual assets, the cash, the real estate or other investments, being held directly or indirectly by the holding company rather than the trust itself. Thus, upon establishment of Continental Foundation in 1976, it was bearer shares, you know that, I hendeavaksjer in Norwegian, bearer shares in CTC rather than assets of CTC, which were settled upon the trust. So CTC continued its corporate activities as before, but with the trust rather than Yare appearing as owner of CTC bearer shares. To be more precise, this structure was intended to eliminate speculation that Yare was the owner of those bearer shares, and was one of the devices used by Yare and his associates to place the CTC assets beyond the reach of Norwegian tax authorities. Mr. Reeves talked a lot about various legal entities in the tax havens around the world, and I can point to one just to illustrate. Sorry? 2 minutes left. 2 minutes left. Give me 5. or 7. He took 5 from me and you had 5, that gives me 10. Use of exempted company in Cayman Islands. The Cayman Islands and many other tax havens authorize the creation of various forms of corporate entity. One such form is the exempted company, which is very often used by those seeking to maintain secrecy with respect to the entity's true principles and purposes. Notable features of a Cayman exempted company include, and you can read it by yourself, a tax-free status for 20 years, good to have in your pocket, issuing shares in bearer form, securing absolutely anonymity. And mind you, keeping its registered members anywhere in the world, with the register not available to public inspection. No requirement to hold an annual general meeting of shareholders, nor to file shareholders' information, and so on. It may not engage in business in the Cayman Islands, but it may conduct operations from the Cayman Islands. And what does this result in? If you do search for this company, you do have the name by hand. The search of the company registry will only reveal the date of incorporation, the type of company, namely exempt, and where the registered office is situated. That's it. Finally, no information treatment can repair that lack of information. You have to change the internal rules. In summary, those forming an exempted company can keep secret both the entities of the corporate owners and its financial activities. Moreover, the company can be operated tax-free so long as a nominal annual fee is paid to the local government. Perhaps not surprisingly, when the estate inquiries with regard to the foreign fortune began to focus on the Cayman Islands and the activities of the Norwegian expatriate Torleif Monsen in connection with the CTC assets, the estates found that various entities involved in the holding of administration of assets derived from CTC were Cayman exempt companies. Not only were efforts to investigate the actual ownership and purpose of these companies time-consuming and expensive for the estate, but Cayman law actually made it a criminal offence for any person to divulge the kind of evidence the estate was seeking. And I'm moving on to this because this is very interesting, and it follows up what Mr. Reed talked about, namely it's a criminal offence to give information. And that has to do with the Confidential Relationship Preservation Law in Cayman Islands, also called CRIPPLE. The disclosure of confidential information in the Cayman Islands arising in a professional relationship is governed by Cayman Islands CRIPPLE. CRIPPLE was introduced only to maintain the secrecy of business activities and is, mind you, of extraterritorial effect. Its provisions defined confidential information to include a broad range of commercial information and set forth the circumstances in which such information may or may not be disclosed. CRIPPLE makes it a criminal offence to disclose such confidential information or deliberately to obtain it or attempt to do so except in certain specified circumstances. The law applies not only to bankers but also to all professional persons. I forgot this. Confidential information includes information concerning any property which the recipient is not authorized by the principal, i.e. the client or customer, to divulge. A professional person is widely defined and includes banks, trust companies, attorneys at law, accountants and insurers, among others. Subject to some exceptions, CRIPPLE has application to all information with respect to business or of a professional nature, which arises in or is brought into the Cayman Islands, and to all persons coming into possession of such information, whether they be within or even without the jurisdiction. And that they tried to give this application to us, and I come to that. I think this is interesting. The estate was approached by a third party who handed over information to assist the pursuit of the foreign fortune. There were potential difficulties with this. For example, trust law. Are the relationship between trustee, settlor, and beneficiary professional relationships? The relationships between a company, its shareholders, and its directors, are those professional relationships? Information which has been imparted to a professional, which may not itself be considered confidential, since it is readily known by another non-professional. Does the existence of the professional relationship mean that cripple is nevertheless engaged? Those in control of what remained the foreign fortune knew that the estate had acquired information from the third party I just mentioned. Predictably, they contended through the litigation that the estate had acted in breach of cripple. It could not rely on any of the information. Worse, it could not bring any action at all because it was irredeemably tainted by breaches of cripple. And yet worse, its representatives, me, were under threat of criminal prosecution and imprisonment. In the case, the estate was ready to argue that there had been no breach of cripple at all. Even if there had been, the estate did not rely on any information which had been provided in breach of cripple. It could mount its case without it and without any abuse of the Cayman courts. The estate remained free to rely on such information in any event, since there was no confidence in iniquity. The arguments as to the breach of cripple were never tested in court. The experience still demonstrates that cripple is a powerful tool that one can expect will be used for all its worth as a defense against those tracing assets. And some closing remarks, very few. What is this? This is the Yara case in a nutshell regarding secrecy issues. However, I've only been able to touch the top of the iceberg. Still, I hope the case serves to illustrate some of the practical difficulties one may be faced with when tracing assets across jurisdictions. Thank you for your attention.
I'll start with one question, and it's for Mr. Reeves. I liked your analogy about fishing. You're in an area with lots of big fish, and you managed to catch a few of them. It must get frustrating to know that all the other big fish are still out there. How does that feel? Is it enough to get those few that you actually catch, or is the frustration still massive when you think about all the maybe even bigger fish that are out there? And secondly, one point that I saw on the screen, but since we're running out of time, I don't think you had the chance to elaborate. What laws need to be changed in order for the IRS and other parts of government in many countries to do that job better? What reforms are needed to change the system?
Should I answer this now, or?
Yes, please.
Okay. First of all, is there frustration? No, there's not frustration. One can only do what one can do. And very often I've said that when it comes to any activity, any enforcement activity that the IRS or any tax administration office is involved in, it's about closing doors. And when you close a door, someone opens up a window. And then you have to try and close that window, and then they open up another door. There's always going to be this movement. But the key is that as people involved in enforcement and administration of the tax laws, our choices are to do something or to do nothing. We chose to do something. We think that we've made, we meaning not me, meaning the collectively, all of the team. I mean, I get a lot of the attention because my name was the one that was on the marquee, but the fact is there were a lot of people involved in this, a lot of people who deserve a lot of credit for the UBS and all the other stuff, not just at the IRS, but at the Department of Justice and elsewhere. You know, we have accomplished something as a group that had never been done before. We penetrated Swiss bank secrecy. I don't know that that has ever been done. I can tell you that there was great sense of accomplishment about having done that, but we recognize that we've only touched the very tip of the iceberg. Okay.
I'd like to add something about that.
Sure.
The main point of this is deterrence. You catch a few big fish and scare the hell out of the remaining fish. And what you've seen is a real loss of customers at the Swiss banks. You can buy a private Swiss bank very inexpensively because the customers are really afraid of getting caught. Now, that was what I was talking about before in the way of deterrence. You prosecute people, usually the dumbest and biggest and most available, to scare the hell out of the 40% who would be crooks if there wasn't a threat of prosecution.
And evidence of that is the fact, and this has been publicly disclosed by the Commissioner of the IRS, you know, the voluntary disclosures. We normally receive as an agency about 100 a year. We've received 38,000 since UBS. And they are from all over the world, every continent of the world, except what's the frozen one, Antarctica. We didn't get any from there, but we, you know, every other continent in the world, we've received voluntary disclosures. We've received them from I can't tell you how many banks, not just banks in Switzerland, banks all around the world. So I think to Jack's point, there was a time when everyone thought that offshore was this impenetrable wall of secrecy, and there was no way that it was ever going to get penetrated. And that issue is now by the boards. Now the question is, how far in can we go? And if you're on the other side of that wall, do you really want to stay there and wait for us to come get you? Because once we knock on your door, it's a basic premise. Once we knock on your door, it's too late to follow voluntary disclosure. You're done. You're now in the system. Okay? To your other question about things that can be done, what I was going to talk about there was the single most effective tool we've had, in my opinion, is the John Doe summons. I only know of 2 other jurisdictions, 2 other countries that have similar laws. Jack may know others, I don't know. But Canada has a law called the no-name request, I believe, where they can go in and do something similar. And then Great Britain has one, and I forget what theirs is law. It's different procedures. We have to go to a federal court. I believe in Britain they have to go to a particular commissioner for approval to issue this kind of thing. And when I have spoken to representatives of other countries, they often say to me, boy, I wish we had that authority. We could accomplish so much if we had that authority. I don't know why any country would want to not create a law that would help it catch the worst of the worst. One of the biggest businesses in Washington, D.C. is lobbying. There is no lobbying organization for offshore tax evaders. So no one's going to come forward and complain about that.
Thank you. I do have another question. Lee Shepherd, we saw this fascinating diagram of how money is moved back and forth, but you never mentioned a single, you never mentioned one specific company. And I'm imagining...
What do you mean? This is everyone.
This
is every big
yeah, but I'm
US
getting to my point.
British company.
In your work, you must come across some fantastic stories of how companies, of innovative ways where companies have avoided tax that are particularly innovative, or where they've come up with some really fantastic ideas of how to do it. Is there anything that comes to mind of specific anecdotes?
Here is the problem with, because I don't write articles like the Google article, okay? And newspapers like to write those, because if you're a newspaper, you want names and faces. And as I was saying, in our law, if you showed that Google stuff to a room full of U.S. lawyers, that's a pretty clean case. I would not want to be in court against that one in the U.S. It is clean. What happens is these big companies get their advice from a lot of the same people. There's a set of law firms and a set of accounting firms that they get their advice from, and we could sort of count them on two hands. And they do a lot of the same setups. I mean, the setup I showed you, that's a very common setup. And, you know, it's been done, it's been being set up by companies for about 20 years. And you know, some of their European counterparts have done it too. It is now reaching the courts in Europe, in India, in, you know, in countries that are fighting this stuff, and it is not getting the results. I mean, it did, the commissioner thing did survive in this country, but, you know, you're not guaranteed the sort of promised results that, you know, were anticipated back when this started being sold. But, you know, when you're saying, oh, is there anything unique or novel? Actually, no. What there are patterns.
Right.
You know, there are, you know, okay, this is your intangibles holding company setup. This is your Dutch European holding company setup. This is your, you know, this is how you do your foreign tax credits. There's a whole bunch of transactions and patterns that we know about because, you know, one of the things, and this goes back to the point about transparency isn't going to get you everywhere. We have a lot of transparency in our law. I mean, these companies have to tell, and in your law in Norway, you have transfer pricing documentation too. That means you have to tell the tax administrator what transactions you did with your affiliates, and that the tax administrator knows quite a bit, but they still can't win a case because of the structure of the law, because of silly customs like recognizing the little contracts even when the taxpayer isn't behaving according to them. You know, even if they have a problem with it, then it's, do I want to fight the taxpayer in court about this when the taxpayer's got control of the facts? That's a tough fight to have.
Are you as optimistic as Mr. Reeves that the times they are indeed changing?
Well, here's what's changing the times. What's changing the times is India and China, because India and China are big enough to fight these cases. They are big economies where the multinationals have to be, because when it's a little country, the if you try to tax us, we'll pull out of your country, and, you know, your people will be unemployed, and you won't be able to buy our precious product anymore. You know, they can say all kinds of things and stomp up and down when you know, you've got a situation where the company is bigger than the country. But India and China will fight. You know, I mean, it's kind of an interesting, you know, colonial point, is that the British left India with a legal system and, you know, common law training and a common law system where they can just look at things and say, you know, our interpretation of the meaning of that word is different than your interpretation, and we'll see you in court. But they're also changing they are undermining the international consensus, too, by fighting it from within. And a lot of people, including the Americans, don't understand that. They just think, oh, well, India's just being a pain. It's like, no, you don't get it. This is a long game. This is not over.
Let me just follow up with one thing. We heard this morning from the State Secretary at the Ministry of Finance that he wants to change the law. He wants to take away some of your privileges when it comes to confidentiality. And you're obviously against this. What do you think are the concrete negative implications of changing the law in that way?
Well, first of all, I'd say if it's only in terms of the client accounts he wants to make changes, I'm not sure if we are that much against it. But if it's in terms of restricting the general confidentiality, I really think in society you do need to be able to come to some advisors and tell them everything and say, please, can you help me? And then I think if you lift the sort of the rules of confidentiality, or you take away the confidentiality, I think you treat a whole profession as criminals. I mean, the whole legal professions, and if you did the same with the priests or without, you treat the whole profession as criminals. And I think, I don't think that's going to help that much, and I think there must be other ways to deal with these problems.
The issue, I would argue, is not the confidentiality of the advice or what the client says to the lawyer. The issue is, what is the lawyer doing? If the lawyer is advising the client on how not to break the law, that's fine. If the client comes in and says, give me a tax plan so I won't pay tax anywhere, and that pushes the boundaries of the law everywhere, there's a problem. And that's the stuff that you have to address in a different way. It's not a confidentiality issue, it's a role of the lawyer issue. And the lawyers have to begin to think in terms of the consequences of what they're about. Now, how bad did this get? I was involved in the case of Ernst & Young, which was criminally prosecuted, this is the major accounting firm, for offering tax shelters to very wealthy Americans, which involved bogus transactions that created fake tax losses. 6 partners were convicted. There were fines in the many millions of dollars for the activity. They didn't even carry out the transactions. And Ernst & Young made $70 million from selling these shelters to wealthy individuals. Now, I maintain a firm that does that should lose its license. That was never considered.
Sorry, Mr. Espelid first.
You could keep in mind then that the Chief Justice in America of the Supreme Court in the 70s, he stated as follows: no American has a duty to pay more tax than the rules tell him. And if you put that to a lawyer, try to minimize my tax, wouldn't that be prudent?
In our law, we have the privilege. We have an attorney-client privilege. Actually, it was before the 70s that was Hand, right? You know, that was in the 20s. Anyway, we have the attorney-client privilege. It does not apply to tax return information. That means it does not apply to the memo that the lawyer wrote advising the tax plan. That is disclosable to the IRS. And also, if the client follows through on this advice and puts it on a return, which is a disclosure document in and of itself, then the lawyer is also a return preparer under our law and subject to return preparer penalties. So that goes back to Jack's point. Really, when you're giving tax advice, you're not really practicing law as the attorney-client privilege contemplates.
I have another question for Mr. Sharma. With all the information you gathered on companies that were willing to provide illegal services, did you give that information to the authorities? Did you expose those companies in public, or what did you do with it?
Yeah, you wrote a book.
Yeah, but all the companies, were they exposed?
No, we didn't give that information to the authorities, and indeed we're prohibited from doing so on ethical grounds. In order to get university permission to engage in deception and to lie to people, we had to agree that that information would be destroyed. So I'm happy to make all of the information that we have available to anyone who wants it, but all of the names of people and companies have been destroyed.
If you send it offshore, maybe someone can publish it there. Okay.
Could I say one thing real quick, just very quick? But it's interesting that Judge Learned Hand, who issued this statement about citizens don't have to pay more tax than they really. The issue in that case, believe it or not, was actually about a corporate reorganization where a company had engaged in a sale and they tried to reorganize the company and create a new corporation in order to avoid paying the tax on the gains. And in his decision, in the very next sentence after the one you refer to, he goes on to say, creation of a corporation for tax avoidance purposes is not a legitimate use of a corporation. I may be paraphrasing that, but the point is that takes you right back to the tax havens, because that's what they're doing. They're creating all these corporations and then saying this is a separate entity and you have to treat it as a reality. So in the very same paragraph where he says you can reduce your taxes, he also says, but you can't do it by creating sham corporations.
Yeah, but that's because substance above form.
So exactly. Yeah.
Okay.
Exactly
Next question. Second row.
My name is Alex Prats from Christian Aid. It's a question for Lee. I think it was very clear from your presentation and also actually from Professor Christian's that legal tax avoidance by multinationals is a huge problem today, even as big, if not more, than tax evasion. So probably there has been a mismatch between the globalization trend in the last 30 years and the capacity of governments to react from a policy point of view to that situation that's been created. Now, assuming that governments have good intentions, because you talk about UK and US obviously offering resistance, what, in your views, would be the solutions to that problem from a policy perspective? So now, for instance, the OECD is now working on this BEPS initiative, which is base erosion and profit shifting, and probably because the UK and Spain and other countries are also suffering out of this, they are thinking, I don't know if with good intentions or not, how to tackle that. Now, let's assume that's good intentions, really. So what would you recommend in terms of policy changes to tackle the problem of legal tax avoidance?
What I was trying to say in the speech, without repeating everything, is that it is the structure of the international consensus, which the OECD is the guardian of, okay? That is the problem. It is recognizing those little boxes as corporations. It is recognizing those little contracts between the boxes. It is trying to apply transfer pricing where if we took everything that I had up there, every entity that I had up there, and we totted up its income, we still don't get to 100% of the group's income. And transfer pricing, all the best transfer pricing in the world is not gonna get you there. And it's not gonna, even if you got a satisfactory amount of the thing's income, transfer pricing is not gonna allocate it fairly among the market countries. That's what we're talking about. We are talking about, in the long run, the breakdown of this system. There is reason to have hope, and the reason, but the real fight is not, it's whatever the OECD's good intentions are. They're not gonna go after their own structure. They're not gonna say, well, that Bermuda finance entity up on that chart there, that's ridiculous and you shouldn't recognize it, tax administrators of the member countries. They are not going to say something like that. And if if you're not willing to attack the structure, then you're really not moving the ball. You're not being constructive. So, the OECD can make little nibbling around the edges recommendations, but they can't recommend anything serious. It's not even in their role to recommend anything serious. Where the serious challenges are coming from, and the non-governmental organizations that are in this room are part of the serious challenges. There are a lot of challenges coming from a lot of avenues. One is the NGOs, but the more powerful one is India and China, because they're doing it from within. And a third very powerful one that we didn't talk about today is the European Commission and the Common Consolidated Corporate Base, because that will eliminate transfer pricing in Europe. And you can say, well, so what about that? Well, most of the OECD treaties, there's only 2,000 of them, okay? Most of them are between European countries, okay, or European countries and outside countries. Europe has been the biggest adherent to this system. When the biggest adherent to the system gives up on it, and that's what CCTB is. When the biggest adherent to the system gives up on it, then the only defender left is the United States. I mean, you basically have Brazil, India, China, and Europe now saying, we don't want any more of this.
There's one more thing to say.
We have only time for one more question.
Okay, but let me just say that at bottom, your issue is an issue of democracy. And I would argue that every public company's tax returns everywhere should be public. It's a public company, make the returns public. And I also want to see a real marriage of the numbers on those returns to the numbers they report to the SEC, the shareholders, and the public at large.
Moving towards that in our law, we have a stronger reconciliation of your book numbers with your tax numbers for big public companies now.
Okay, we have a question from the back here.
Thank you very much. I'm from Nigeria. Just 3 quick questions to. The first has to do with the experiment on willingness to register anonymous companies. From the presentation you made, it did appear that it is in tax haven countries that you are least likely to find corporate service providers willing. And you did also say that seemed to have been ironic. I don't know whether in the course of your work you try to find an explanation to why that is. Perhaps that could shed some light. And then this has to do with the role of lawyers again. We're beginning to see, as we fight corruption in my country, that there may be a need to begin to differentiate between where individual rights end and where group rights begin. Where does my right as a governor or public office holder who had access to public resources to manage on their behalf end in the midst of trying to pursue judicial review and legal technicalities where I can hide behind my individual right and the right of all the people who had rights to development and healthcare ends, so that we begin to see if we can begin to redefine the role of a lawyer in society as an agent of social change and not just someone who teaches the people to obey the law, such that when that kind of thing comes up, you can begin to say, yes, we have a law, but we also have people who have been put in positions of responsibility. And if we have to waive this individual right in the interest of the common good, then let the law go and let us get justice and punish the crooks. Because it's beginning to become like, behind every successful crook, there is some lawyer hanging around. Thank you.
Anyone care to comment?
I think it was for you.
Why are tax havens more compliant than developing countries, but particularly developed countries? Because you have the OECD and FATF stick up for the interests of their members and then beat up on small and vulnerable countries. No one beats up on Britain or the United States, and that's why you see that difference.
And on the question of Nigerian lawyers, a month ago I spoke at the International Bar Association, where there was a group of African lawyers talking about what to do about these problems in Africa. And we talked about social responsibility of lawyers. And among the best people in that room were Nigerian lawyers seriously asking, what do we do when clients come to us and tell us we want to do bad things in Nigeria? How do we handle it? The consensus answer was get rid of the client. I was overjoyed to hear that, because it means there is the beginning of understanding among educated Nigerians that the status quo won't stand.
I'd like to say thank you again to all 8 panelists. You've been wonderful, and we've all, at least I can speak for myself and say I've learned a whole lot. So thank you very much.